it's going to be not 72 nanograms of DNA consistent with Mr. Goldman, but a much smaller portion.
That's correct.
And it's for that reason that you conceded yesterday that you would expect that once the process began of putting the probes, developing the probes, that it would take a considerable period of time to develop them because you knew that the amount of DNA that could arguably be consistent with Mr. Goldman would be a small contribution.
Yes, in other words, that these autorad development times would be prolonged because there was an overall total low amount of DNA, and since it was a mixture, then that would, any of those particular components would be even less, obviously, than the total.
Now, between the period of March 22nd and when you began the 3 to 4 day process of putting the probes onto the gels to develop them, okay, you went through some considerable discussion with Mr. Harmon here yesterday as to what your activities were, correct?
Yes.
Now, much of that time in April was taken up in discussions with Mr. Harmon in preparation for your testimony in this case.
There were a few meetings with Mr. Harmon on the, I believe it was on the Fridays of April, yes.
Well, it took you one day, April 5th, to prepare your report.
Yes, I logged 14 and a half hours on that day of report preparation. That was, in addition, there was some other work. There was the Sunday, April 2nd. Before that, there was also some time spent on the report.
Okay, so those 2 days, April 2nd and April 5th, that's what you took to prepare your report, which was a summary of your results.
Yes, and I believe there was some other time in there also where I was doing some word processing, putting things together. That's all part of that mix.
All right. And your notes, you've told us before, you kept contemporaneously as you performed your work in this case.
Yes.
So in order to turn over to the defense discovery of the notes, all you had to do was take your contemporaneous notes and Xerox them and turn over a copy, as far as the notes are concerned.
Well, as far as the notes, we make copies. We have a special numbering system we follow. There's preparation of correspondence. There's sometimes taking it to the Federal Express office is something that I would do. There's a lot as far as making sure the autorads get copied and numbered, and the discovery process is not just a matter of sticking some pages in a Xerox machine and walking away and coming back and having them ready to go.
You turned over to us your notes, which you kept contemporaneously, and the autorads, which were being produced on all the other material that you testified about in this case, as you went along.
Yes.
In other words, before you're reporting the results, you have to look at the autorads.
That's correct.
So in terms of the discovery, all you ever turned over to us were the autorads and your notes, right?
Well, there are my notes, there are other analyst notes, and there are also review notes and that sort of thing. There's a whole package, and you receive several of those, so you know what's in them.
Right. But you've indicated here that you spent all of April 10th and all of April 11th engaged just in discovery preparation.
No, what this indicates is that as far as those 2 days are concerned, I did spend almost all of April 11th. I have 8 hours I logged on discovery prep. On April 10th, it was only 3 hours, so I was apparently doing something else on April 10th.
Mm-hmm. Now, then you have on Wednesday and Thursday preparation for testimony, correct?
Yes, I believe that's the 13th and the 14th.
All right. And so those are at least 2 days that you spent with Mr. Harmon preparing testimony.
No, a lot of those times are just my own time spent. That's not with Mr. Harmon at that point.
Okay. And what about, incidentally, after you prepared the report on April 5th, on April 6th, you and Renee Montgomery actually flew to Los Angeles to give the report to Mr. Harmon?
Yes, and to consult, yes.
So on April 6th, you consulted with him in preparation for your testimony in this case
Yes,
in Los Angeles.
yes.
On April 7th, I take it you did the same thing, even though it's not listed here?
I believe that was a Friday.
A Friday.
I think that's incorrect. I think I came back sometime in the evening on April 6th, and I'm not sure what I did on April 7th. Apparently, it didn't relate to anything on this case.
All right, so you didn't do anything on the case on April 7th, but you did other work?
Yes, I put in, I believe, a full day at work that day.
All right. So on what about Wednesday, April 12th? Was that another day that you were preparing for your testimony?
No, I didn't log any hours on this case for April 12th.
So April 12th, you didn't do anything on this case?
Well, I won't say I didn't do anything. I may have been developing an autorad, for example, but I have no mention of it in any of my time sheets that I could find.
All right, so April 13th and 14th are other days that you're preparing testimony? April,
Yes, you mentioned those earlier. Yes,
then you put down here April 17th and 18th, you're preparing for testimony?
yes,
Is that, are you spending time with Mr. Harmon?
no.
That's all day you're just sitting around preparing for testimony?
Well, on the 17th, I believe there were 2.5 hours, and then the next day was a full 8-hour day on preparation.
And incidentally, getting back to this before, the 3 or 4 day process that you describe as being necessary to get those probes going, that is not 3 or 4 days of hands-on work by you.
Well, all the hands-on work is by me, but it's not full 8-hour days.
Right. Not full 8-hour days by any means.
Well, one of those days is virtually a full 8-hour day.
But as you described before, the restriction takes an hour, and then you just let it go overnight.
The hands-on time that I would mention would be the actual adding of samples and
Yeah.
tubes, but there's also the planning stage in that, and that takes a considerable amount of time.
Well, you could put, I think you testified yesterday, it would take you, what, an hour and a half to do the restriction and put it overnight, right?
In this particular case, I believe there was some additional time in terms of the planning, but as far as the hands-on,
Give me the
that's correct.
total hours it would take you to plan and do the restriction.
In this case, I would say it was about a half a day, something like that, maybe
What's a
4
half
hours.
a day?
4
4 hours? You're going to get this 4 hours?
Something
Okay,
like that.
so you
That's an
could-
approximate.
Excuse me. If you guys want to talk at the same time, we're going to stop the hearing right now.
So, if that takes you 4 hours, my apologies, Your Honor, if that takes you 4 hours, you could do that and then spend the remainder of the day preparing your testimony, right? Looking over the materials.
Well, as I think I mentioned yesterday, the restriction is something that is typically done at the end of the day. So that's something I would save that latter part of the day.
Okay, so you could prepare your testimony in the early part of the day by reviewing things and then start the restriction at the end of the day.
That's possible, yes.
And then, to get back to this, on April 19th, you talk about analysis of test results. Is that still more preparation for your testimony?
I think there may be some of that in there. There may also be some autorad development. Another thing that was going on at this time was there was some monitoring of some of the testimony of the other witnesses. So I'm not sure exactly what all was going on that
Well,
day.
let's get to that. In other words, part of what you were doing here is you were listening to the testimony of other witnesses before you testified.
Portions of those testimonies, yes.
And were you listening on a radio in your lab?
At times I was, yes.
And sometimes you'd watch on television.
At times, yes.
All right. And then on April 20th, there was a whole day preparing testimony.
Preparation for testimony. I logged, I think, a half day on that particular day.
A half day, and was that alone or with Mr. Harmon?
That would be alone.
All right. And April 21st, you took off.
Yes, I took that Friday off.
And what about that Monday, April 24th? No work on this case?
I didn't log any time, no.
All right. And then on April 25th, you were reviewing other materials and preparing for testimony.
Yes, and at that point, I went back to the plans for doing the RFLP, and I made some notes that are reflected in my laboratory notes for that date.
Now, on April 26th, you talk about what Renee Montgomery was doing, correct?
Yes, and also that's the day that I actually laid out and I'd hoped to do the restriction, and I think we alluded to this yesterday, that was the point at the end of April when I got very close to doing this, but I was not able to complete the restriction that night.
How long did you spend doing the restriction?
I logged a total of about 4 hours on the case that day, April 26th, which
Not my
was a
question.
Wednesday.
How long did you spend doing the restriction?
Well,
Planning the restriction.
the plan, I don't know the exact amount of time that was spent that particular day. It was probably on the order of a few hours, something like that.
A few? Can you, planning the restriction? I'm asking you how long you spent planning the restriction.
I don't know exactly. I mean, I'm looking at my notes for that day. This is my notes on page 242.
Well, Mr. Sims, you mentioned that in terms of preparing the reference samples, you wanted to make sure that the reference samples would be in similar quantities to the amount that you had from the combined samples, correct?
That's correct.
So the autorads would look balanced in the lanes, right?
That's correct.
Well, and so basically, that doesn't take very long to do, does it?
Well, no, the difficulty here, and I think we got into this a little bit yesterday, but the difficulty was that I was running out of some of these reference sample extracts. And in particular, I had a note that I was trying to get more of the defendant's extract, and I had a note that I would check with Renee Montgomery to see if she had any sample available left over from some of her extraction. And this was one of these nights where it got to be, I think I logged out at 11:30 that night.
Are you talking now about, what date are you talking about?
April 26th.
All right, so April 26th is the time that you're first looking to see if you have sufficient amount of reference sample from the defendant to proceed with the RFLP. Is that what you're telling us?
That's correct. That's when I actually start handling the tubes again.
All right, so that's already April 26th.
That's April 26th.
So that's over a month after you have realized that you have 72 nanograms to do this RFLP, right?
That's correct.
And incidentally, so the judge understands exactly what we're talking about here. Basically, what you're trying to do is, you know, if you have something like 72 nanograms of DNA for one sample, instead of using 5 microliters of the reference sample, you'll knock that down to something like 1 microliter.
Yes.
That's a simple calculation you make on your handheld calculator, right?
Well, given the number of calculations I make in any case, I don't consider any of them simple, and I spend a lot of time with my calculations to try to make sure I get it right.
I understand, but it's just a simple question of reducing the amount of DNA from the reference sample so it roughly corresponds to what you think you have in the combined sample.
Well, I mean, you make it sound so simple, and when you look at it from your perspective, perhaps it is simple, but to me, it's a matter of making sure that I have how good are my quantitations, how good did they look on the previous set of autorads that I ran, that sort of thing, and making the proper estimates. And I take a lot of care in trying to come up with the best amount of DNA to use, for example. So it's not just a simple punch it into a calculator and get the result.
I understand, but you had 72 nanograms on March 22nd. Tell this judge, in all candor, how many hours it took you to figure out how much reference sample you would need to run, given the fact that you had 72 nanograms. The total number of hours it took you to make this calculation.
Now, this would be for April 26th.
No, I'm asking, how long would that operation take? Once you knew on March 22nd you had 72 nanograms, how long does it take if you decided to do it soon after March 22nd? How long would it take you to figure out how much DNA you needed from the reference samples to run on the RFLP?
Well, again, I can only speak in the context of the samples in this particular case, and it's not just a matter of saying, I have this sample. I mean, I have this sample. How much of this sample do I have left? How did this sample look when I put it on the previous autorad?
Mr. Sims, taking everything into consideration, all the complexities and unusual circumstances of this particular case, how long did it take you to make the calculation regarding what size of a sample from the reference sample was necessary to do your testing in this case?
I think in this particular date, I spent a few hours doing that, maybe 2 hours, something like that, maybe 3, I don't know.
So in other words, if you sit down to do it, it's going to take you 2 or 3 hours, max.
Something along that line, yes.
And so the record is clear, you didn't really sit down to even do the planning until April 26th.
No, that's not clear at all, because I think if you look at my notes, the planning against, I have on April 25th, this is at page 242, plan for additional RFLP on April 25th.
Okay, so you started on April 25th, this 2 or 3 hour process, and it ended sometime on April 26th in terms of planning the restriction.
Well, I think you're simplifying the situation, and I can't give the precise number of hours that all these processes would take. Okay. But there is time on April 25th, and there's time on April 26th.
Right. Now, you then indicated that on April 27th, you're doing more preparation for your testimony and attending a CAC study group meeting?
Yes, that was on April 27th.
All right. April 28th, you're reviewing other data, but you're meeting with Mr. Harmon in preparation for your testimony?
Yes, and I also met with Dr. Blake that day, too.
Mm-hmm. On May 1st, you talk about in your notation, what Renee Montgomery did, right?
Yes, and I was working a little bit with her on that particular day.
How many hours you spent working on this case on May 1st?
I logged about 4 hours.
And what were you doing? Watching Renee Montgomery?
No, I think I was consulting with her on some stuff, and there's a lot going on at this point. Now, this is shortly before I come down to Los Angeles, so there's a lot of last-minute sort of things that are happening on that particular date.
All right.
I can only say that I logged 4 hours on that day.
Mm-hmm. And May 2nd, these are 4 hours on a photo log?
Yes, I put together, because there was a request for some of the photographs, I spent some time numbering and organizing the photographs that we took into some kind of numerical system.
These are the photographs that you took after Dr. Blake took photos?
Yes, most of them are after that, or made about the same time as Dr. Blake's photos. I also spent some time preparing to testify on that day.
Okay, so that's another one of those preparation for testimony days.
That's part of it, yes.
And these are the photos that
Counsel,
we've never seen.
Isn't the issue how long the testing takes?
Yeah. Well, I'm just trying to...
Is there any dispute as to Mr. Sims' calendar here?
Oh, I just want to point out a few more things, Your Honor, in this regard. Now, you indicate here on May 3rd, May 4th, you're preparing for testimony, right?
Yes.
Saturday, May 6th, you're preparing for your testimony.
Yes, I also may have come in and developed an autorad that day. I'm not sure.
Now, you flew down on May 7th to watch Dr. Cotton testify, correct?
Well, I flew down on May 7th, which was Sunday, yes, I was standing and also standing by because I didn't know how long her testimony would take, and I was requested by the prosecution to be here for May 8th, Monday.
Well, wait a second. You didn't think that Dr. Cotton's testimony would take a few days, at the very least?
Counsel, his presence here for the purposes of being with prosecution counsel for the testimony of other expert witnesses, this doesn't tell me anything about the issue that I need to resolve
Well,
here.
just want to make one point, Your Honor, in this regard. You sat in this courthouse watching Dr. Cotton's testimony on television, correct? Monitoring it.
I think I was at the hotel at that time.
Okay. Now, you had monitored other witnesses' testimony in your lab. At the same time, you're doing some work.
Yes, for example, there would be days when I would be preparing to testify and then I'd have my radio on, for example, something like that.
So,
May I finish?
yes, I'm sorry.
I don't listen to the radio while I'm doing any laboratory analysis.
All right. But it is certainly possible for you at, let's say, the end of the day, for example, to have done the restriction and have monitored testimony during the day and been in telephonic contact with the prosecutors.
Is that possible? Yes.
Yeah. Okay. Now, there are other people. There's an individual in your laboratory named Steve Myers.
Yes.
Did he participate in creating some RFLPs in this case?
He was involved in some of the batch probing, but he didn't do anything as far as preparing the samples for RFLP analysis.
Is he qualified to do the restriction and prepare the southern blot and get those probes moving?
Yes.
And he was available to do some work on this case?
Well, he was available to do some work on this case, but he also has a number of other cases that he's working on. This was not the only case in our laboratory for this period of time, I can assure you.
But he's somebody that's qualified to do that?
Yes.
And did on occasion pitch in and assist you in RFLP work in this case?
Well, his main assistance was in some of the PCR testing, and I think we mentioned that earlier. He also extracted the hair sample, you'll recall.
But he participated in the RFLP. He does most of the RFLP work in your lab.
No, that's not at all
He
correct.
does a lot of RFLP work at DOJ.
He does a lot more PCR work than he does RFLP work. He did some of the batch probing because he's a very good prober.
Okay. All right, Your Honor, I think on this issue, I'm completed with my cross-examination, Mr. Simpson.
All right, Mr. Harmon?
Couple of questions, Your Honor. When Dennis Fung began his testimony on April 3rd, did you know how long his testimony would take?
No.
Was that one of the considerations in not knowing exactly when you'd be able to do the RFLP process?
Yes, because there were certain things that I needed to accomplish, I felt, before I would come down and testify.
Okay, did you expect the kind of long-winded cross-examination that occurred of Dennis Fung?
Well,
No.
that's not really necessary.
Did you expect the kind of cross-examination that occurred with Andrea Mazzola?
Well, I think after I saw Mr. Fung's cross-examination, I expected some long cross-examination after that, yes.
Okay. Did anyone discourage you from doing the RFLP results so Mr. Scheck could see them presented in the case in chief?
No.
Thanks.
Any recross as to that? All right, Mr. Sims, thank you very much, sir.
Thank you.
Mr. Harmon, anything else?
Not on that point, Ron.
All right. Mr. Scheck, do you have anything you wish to offer?
Yes, Your Honor. There's a few issues on the table. I have to respond. I take it, or I really think it's our motion. Initially, I want to
That's
make...
why I'm asking, do you have any evidence you wish to offer, any witnesses you wish to call?
No.
All right, I'll hear argument.
Your Honor, well, first, the first issue that I would like to address, Your Honor, are the points that were raised by Mr. Kelberg. I'll take them in order. And before even reaching, it's my understanding that the law with respect to rebuttal involves three factors, as we outlined them in our brief. Was it available? Could it have been available in the people's case in chief? Is the evidence important or crucial evidence that it's unfair to sandbag with the defendant with at the end of the case, and would bringing this evidence forward at the last minute unduly highlight the evidence. Those are all the issues that are involved in the court's exercise discretion as to whether or not it's proper rebuttal testimony. But Mr. Kellberg tries to make a point which plays fast and loose to the facts as to whether or not these RFLP results are direct rebuttal to Dr. Gerdes, and it is not, for a number of reasons. Number one, Dr. Gerdes testified about item 31, and the board involved in item 31 is a PCR result of a sample collected on June 14th. That's item 31, where he disputes what we call the failure of controls on that particular set of results, and it has to do with the sample collected on June 14th. I would note for the court's edification that item number 30, which was also collected on June 14th, had DQ alpha types that only were consistent with Mr. Simpson and no evidence of any other contributor. So that was not a mixture. There's 30 and 31. Those are June 14th. Also presented on the prosecution's case were PCR results as to 303, 304, and 305, the samples that were collected on August 26th. Dr. Gerdes did not comment on the PCR results on 303, 304, and 305, taking the position that as a scientist, he would not even consider those samples because the Bronco, after June 14th, was outside of the chain of custody that he, as a scientist, normally requires for examining the integrity of evidence. So he did not comment on 304, 303, 304, and 305, those PCR results. These RFLP results are on 303, 304, and 305. They are not on 30 and 31. So it doesn't directly rebut that. Nor can they come in and say, well, those are really the same samples, because they were at great pains to have Matheson testify that even though 30 and 31 were supposed to be in the general area of, even though 303 and 304 were supposed to be in the general areas of 30 and 31, they were separate and distinct swatches of separate and distinct bloodstains. And they have to take that position collected on completely different days under completely different circumstances, that those are separate and distinct pieces of evidence. So the fact of the matter is that these RFLP results are not being offered to rebut Dr. Gerdes' questioning of the scientific controls on item 31, because that is a separate and distinct sample. What they're being offered here is to add additional evidence to the PCR results from the 303, 304, and 305, which were samples that were collected on August 26th. So those are the facts. Secondly, I would point out, in terms of the rebuttal argument, that when this issue was first raised about their failure to pursue these tests in a timely fashion, and in fact, in the whole issue of the Bronco samples, I pointed out to the court exactly what was going on. I stated to the court at the whole discussion, starting, for example, at 27331 of the record, in the argument on, I think it's May 12th, and I had previously indicated to the court on March 29th at page 20966 in the record, and that's where we were having the general discussion of when we re-raised our challenge to DNA evidence under prong 3. I was discussing then under prong 3 that there was a failure of controls on some of the evidence samples collected from the Bronco, and that this was a problem in the people's case. and that what I was fearing here is that they were not going to proceed expeditiously with the RFLP results from the combination because they were going to sandbag us with this. And they could have it done on their direct case, but they were choosing not to because they wanted the best of both worlds. If they got ambiguous results, they wouldn't offer it. And if they got results that they thought supported their claims about 303, 304, and 305, they would suddenly bring this in at the end of the case in a fashion that unduly highlighted it. And I called it sandbagging, and I described exactly the problem from the very beginning. I reiterated that again on May 12th. It was absolutely clear what they were doing. Now, I think on this record, as far as the issue of timeliness is concerned, there can be very little debate on when this court permitted them to combine the samples. It was the understanding of this court, and you said it yourself, when we had our discussion on May 12th about this, that it was our understanding, your understanding at page 27331 of the record, that when they got permission to combine these samples, they were going to proceed expeditiously with the testing, and it was going to begin immediately, if not sooner. Now, during those colloquies, Mr. Harmon took the position, and it's been the people's position all along, that there are no legal restrictions. Even the restriction that they should put on their case, the evidence they have available to them in their case in chief, and they can't just suddenly save testing for their rebuttal case. They take the position that they are completely unfettered, that we cannot in any way, the court cannot direct them. There are no rules restricting them on when they do the testing, that they are completely free to do it whenever they want. That was their position. That's the position they've taken from the beginning. Now, the fact of the matter is that this court told them and made it clear that once they got permission to combine these samples, and in light of the arguments we were making about fears of sandbagging and everything else, that this testing should begin immediately, if not sooner. When the issue was then raised again, this court indicated to the prosecution on May 12th at page 27340 of the record that we may have here a preclusion by the passage of time. Now, I don't know how much clearer the court could have been that they had to make a real effort to get this process started. And Mr. Sims's testimony is absolutely clear, and these prosecutors knew. Everybody knew that they were dealing with a very small amount of DNA that was determined as early as March 22nd, that the big period of time that it would take for these RFLP tests to get completed, because it was a small amount of DNA, were the times that it takes once those probes are beginning to, the autoreads are developing when the probes start. That's going to take like maybe 2 weeks per probe. That's where the time is going to take in completing the tests. So the issue is, could Mr. Harmon have said to Mr. Sims, look, the judge has made it crystal clear to us, immediately, if not sooner, this RFLP testing ought to be done. We could get precluded by time. This is something that should be done. Get Steve Myers to do it. Get Renee Montgomery to do it. The process of beginning that probing is one that he concedes takes 3 or 4 days overall, and in terms of actual hands-on time is much less. He could have been doing other things while the restriction was done, while the Southern blot was prepared, and these things were going overnight. While the analytical gel was prepared, that is a 3 or 4 day process. He'd prefer that it be done on consecutive days, but he didn't even do it on consecutive days, as the record is clear. They waited from March 22nd, by his own admission now, to April 25th. That's what he said this morning, even to plan the restriction, which is a process that he just conceded takes 2 or 3 hours. Now, the point here, Judge, is that these prosecutors, even being confronted with the fact that they were obviously trying to flout the rules and sandbag us with these results, and even in the face of the fact that the court told them immediately, if not sooner, you could be precluded by time, did not say to Gary Sims, look, they spent, and this record is clear, he spends close to 25 days and 100 hours between March 22nd and coming into court to testify in preparation for testimony, reviewing his notes. He spends a week sitting in his hotel room watching Robin Cotton testify, when on other occasions he had been listening to the witnesses, or he could have been done on videotape. It doesn't take that long to get these probes started, where the major bulk of the time is going to take. And as Mr. Sims conceded, once those probes are, beginning to cook for those 2-week periods, he doesn't even deal with it, technicians deal with it. And there's another person in the lab who pitched in on the RFLP and other work, in this case, Steve Myers, who could have taken out some short period of time to get this done if they wanted to get this done. But they didn't want to get this done. In spite of the court's clear admonition to them that they could get precluded, they were flouting the clear direction of the court and trying to gain a tactical advantage. The record is crystal clear on this, crystal clear that this would have been available to them if they proceeded in anything close to an expeditious manner. There is a huge gap here between March 22nd and when these probes went on June 15th. It is inexcusable. It is purposeful. There can be no question about it. It is in bad faith. And we don't even need bad faith. It's just a question of whether or not it was available to them. And it is arrogant. It is arrogant. How clear could you have been to them when you said immediately, if not sooner? It was all our clear understanding they were going to proceed with this important evidence expeditiously. They were trying to gain a tactical advantage. That's all there is to it. And Mr. Sims, I concede, is a fine man. He has a lot of work to do. Demands are made for him in preparation of his testimony, but it's on them. They could have said, the court's been clear as to what the timing is, get this done, get somebody else to do it, because it was a very simple process to get those RFLPs going, the 3 or 4 day period that it takes to do the restriction, the analytical gel, and get the probes going. They knew precisely what was going on. Mr. Harmon is experienced in how DNA testing works. Mr. Sims made that data available to him. They'd rather sit around and talk about how the testimony should go or watch television with other witnesses when they could have done it. The record is crystal clear on this, and they basically were figuring, well, Judge Ito didn't rule against us in terms of when we should start the tests at the beginning of the trial. It was a close call we had on that ruling, but he didn't rule against us. And we take the legal position that there are no obligations on us to begin testing at any particular time or to make anything available in our case in chief. And even after Judge Ito told us immediately, if not sooner, it was clear to us that there was a time problem here, we can ignore it because he's not going to do anything about it, despite the clear rules and the clear admonitions and the clear point that they were taking an unfair tactical advantage. That's what they think they can get away with. And that's exactly what the record shows, and it's exactly the game that they're playing. And it is unlawful. It is not directly rebutting testimony. As I've indicated, Mr. Kellberg's arguments are playing fast and loose with the facts. This is not rebutting 31. A sample collected on June 14th and a particular PCR result. This is supplementing the previous PCR results from 303, 304, 305, samples that were taken on a different date, samples that the prosecution witnesses were at pains to say were taken from a different blood stain on that console.
We're repeating ourselves at this point.
Okay. With respect to the law of rebuttal, the prejudice here is clear. This is important evidence in the case, and by proceeding in this fashion, they are trying to unduly highlight this evidence, and it makes it extremely difficult for our witnesses who would have been on direct examination to confront this evidence when they first testified. That's the advantage that they're seeking, and that's the advantage which the law says is improper in terms of proper rebuttal, and this is not even rebuttal. This is really reopening their case, It is absolutely and utterly unjustified. Now, with respect to what this is going to entail, Mr. Kellberg made another argument that is fast and loose with the scientific facts with respect to the numbers and the testimony that would be required from Dr. Ware on mixtures and the peculiar problems presented by mixtures here. And on this point, if with the court's permission, I would like to defer to Mr. Neufeld, since this is his area, to address Mr. Kellberg's point with respect to the statistics. Well, they got two people to
A
do it.
very discrete issue. You've chosen to argue both issues, counsel. Conclude.
But he made both issues. No, I didn't choose to argue it. I'm saying I don't want to argue both issues.
Let's finish this. We've spent almost 2 hours now on this.
The arguments with respect, Mr. Kellberg argued that the RFLP results on 303, 304, and 305 merely serve to corroborate the PCR results on 31, which is a completely different sample at a different time. And it can't be corroborative for a number of reasons. Number one, what we're talking about here is a mixture. And this court has already ruled that you have to have a number for the mixture. And that obviously, creating a number for a mixture is a complicated process, as we've seen. The problem, and the key problem here, is that the jury has numbers about a single source RFLP pattern for Mr. Goldman and Mr. Simpson, which are very, very small numbers, very low frequencies. And they may assume, they would be entitled to assume, that if they just heard, well, there's an RFLP that shows a mixture of a pattern consistent with Mr. Simpson and Mr. Goldman on the 303, 304, 305 combined stain, the argument is the jury would naturally think that those very, very low numbers in the millions or billions, whatever the patterns are the numbers that they should apply to the mixture on 31, which is an entirely different stain anyhow. And we know, even from the calculations of Dr. Weir, which we contest are unduly making that probability a low one, that a mixture is different, and it is far less of a persuasive number. And you have already ruled that it's the law of the case that they have to present those numbers. And that's what Barney rules. They have to present those numbers separately, and it would be plainly prejudicial here on an entirely different sample to let them not present a number on a mixture. Not only that, Dr. Weir's report that we have gotten here, because of some peculiarities in these RFLP results, engages in a completely different method for calculating the mixture, different than even the one that he presented here the last time. And so it seems that it would be contrary to what this court has already ruled with respect to the need to present numbers for mixtures, to let them put on an RFLP result for a mixture and let the jury speculate about what that could possibly mean. It just violates all the court's previous orders in this case. Finally, I think it's clear from the testimony of Mr. Sims, he's not qualified to present these numbers with respect to mixtures anyhow. He doesn't have sufficient expertise in statistics, particularly on a method for calculating a mixture which has never been published, which Dr. Weir was essentially presenting for the first time in this court. himself. When Mr. Sims' only background in this essentially is taking a few day courses a while ago from Dr. Weir, which couldn't have even addressed the method that Dr. Weir testified to and presented in this case. So for all these reasons, what we're facing here is that if you permit this, what we think is not rebuttal testimony, reopening the case, despite all the warnings this court gave them that they were at peril if they didn't get this done, to be precluded. If you permit it, Gary Sims would have to testify about the RFLP, Dr. Weir would have to testify about the mixture numbers, and we're going to have to call Dr. Shields as a rebuttal witness on all of this. So that's what we're facing. It's unduly extending this case, and it wasn't necessary in the first place, and it was only done to gain an unfair tactical advantage.
May I respond briefly, Your Honor?
I'm interested in just two things.
All right.
I'm interested in the physical proximity of 31 and 303, 304, 305, and I'm interested in an explanation for the delay between March 22nd and April 25th. I'm only interested in those two things.
All right. Mr. Clark has been kind enough to do Mr. Goldberg has been kind enough to do a drawing. Unfortunately, I also used it to write a note or two to myself, but let me hold up for the court's observation. The note is Matheson took swatches from the area immediately contiguous to the 30 and 31 stains, and it looks like the concentric circles one might see on the stump of a tree after it's been cut. And the court can see the proximity. I think the court can see from the distance. If you'd like, I can bring it up for you to...
No, I can see. Thank you.
The proximity, and obviously that goes to the relevancy of using 303, 304, and 305 to corroborate the accuracy of the 31. It's not an issue of when the stains are taken. Obviously, the people's position is those stains were deposited at the same time, June 12, 1994, in the late evening hours. And so the real question, and by the way, Mr. Goldberg hands me from a property report that bears the contiguous numbering scheme with 000685 DR94-08-17431. Under the last item listed, 6 cloth swatches, 5 used to collect additional stain from the same location of item 30, right side of, looks to me to be center console, 1 swatch used to collect a control area adjacent to the stain. I think is what Mr. Goldberg would like me to apprise the court of if the court was not aware of that. The point is that the contiguous contiguous relationship between the stains 30 and 31 and 303, 304, 305 is really the issue, on the theory that they were deposited clearly at the same time. I don't think anybody can really argue with good faith that an RFLP result cannot corroborate a PCR result. And so if the court finds that, in fact, the area is the same general area for these stains, and Mr. Goldberg then points to the next item from the same report, next page, saying, looks to be 6 cloth swatches, 5 used to collect additional stain from the same location as item 31, right rear top of the center console, and 1 swatch used to collect control area adjacent to the stain. So that should take care of identifying where 303, 304, 305 come in relationship to 30 and 31. So that makes it clearly relevant. And I hope that answers the court's question, because clearly circumstantial evidence which corroborates the evidence received in the people's case in chief from the PCR results on 31 is rebuttal evidence. And I must point out to the court, Dr. Gerdes took the stand in August. According to the notes from Mr. Sims, Dr. Blake saw the last, the D4 autorad on July 20th. That's before, I believe, that's the 3rd probe? 2nd probe. So he at least knows we've got a 2-probe result at that point. And certainly his interest must be piqued. I'm assuming Dr. Blake is in contact with Dr. Gerdes in preparation for the defense case, so Dr. Gerdes has to at least be aware of this. Dr. Gerdes attacks all PCR. Unlike what Mr. Scheck says, in fact, Dr. Gerdes does inferentially attack the results on 303, 304, and 305 because he says PCR forensic out for inclusion, exclusion. And that's going to take care of all of our PCR results, if you believe Dr. Gerdy's opinion. So with respect to the first question the court has, that is the direct response. With respect to the delay, Your Honor, I know the world thinks this is the only case in California, the only murder case, the only rape case, the only case where DNA evidence is involved. I think the world has seen one thing. Gary Sims is a meticulous craftsman of his trade. And I must say it's a bit disingenuous to have the defense attack Dennis Fung as a bumbling fool and then criticize Gary Sims for being a craftsman in his trade. And I must say, Your Honor, if every judge said to the prosecution, I want this case put to the priority number one and everything done ASAP on this case, how can any laboratory figure out which priority really comes first? The law requires we use judgment and reason and common sense. And I think from the record that's been laid out here today and yesterday evening, and an interesting record it is to learn how Mr. Sims spent his spring and early summer, it is clear that the prosecution had a scientist of the first order who wanted to be certain that he was doing things carefully so that the same kinds of attacks made on others would not be an attack made on him. And I must say, Mr. Schecht's suggestion that other people could come in and do this, I doubt there are too many folks in the scientific community or in our office who would want to rush in and volunteer to get involved in this case. And as one who was asked to come in kind of at the last moment, hindsight being 20/20, when the call came, I maybe should have reconsidered. I have a feeling that that gentleman up at the DOJ lab that's been mentioned as the possible person to have taken over for Mr. Sims, probably saying, man, thank God I wasn't the one asked to do this. Scientifically, it makes sense, of course, to have one person try and control the sequence of tests so that you can have the chain of custody and you can have the continuity of presentation. And that's what Mr. Sims provides. I must speak in response to Mr. Schecht's comment about the prosecution. We wanted the best of both worlds. Boy, if we got an ambiguous RFLP result, hey, we bury it. We don't bury it. We Brady it. We bring it to the court's attention. We bring it to the defense's attention. And they're going to say that that result corroborates Dr. Gerdy's opinion that the 1.3 allele on 31 is an artifact. We want scientifically reliable, valid results to offer. Mr. Sims is that kind of scientist. He took his time. He had other responsibilities. I don't believe this court, in hindsight, can say that he was negligent in how he went about his business. He was examined at length as a witness here. For the court to say he should not have properly prepared or should not have listened to other witnesses who testify, all the experts in this case are listening to the experts on the other side or on their own side who testify in related areas, because it could be a matter for which they will have to give testimony or be subject to cross-examination. Is that unreasonable?
Go back to my original question then.
Okay.
Your explanation for the delay between March 22nd and April 25th.
I'm sorry, March 22nd and April
25th.
I think Mr. Sims has laid it out. He wanted to make sure in the way he does business that, number one, he had the human DNA, and he did some additional work to make sure he had that, and to be sure that he could conduct the tests in the manner that he feels is scientifically necessary, and without knowing for certain when he's going to have that continuous period of time necessary to do these tests in sequence. If he gets tied in to begin with and something comes up to take him away, he's not going to be able to do one thing or the other. He exercised his judgment, Your Honor. If the court feels he made a mistake in exercising his judgment, do we keep this jury from learning the truth? Do we keep this jury from learning something that corroborates Mr. Sims' original testimony and shows that Dr. Gerdes is simply wrong? This is not bad faith. This is just going through the process of doing his work in a careful, meticulous manner and having time go by. You know, maybe what we should have done when the court said, is it time for you to rest? We should have said, no, we can't rest. We got to wait for these probes to be done. You know, the defense says they can't rest. This is unusual circumstances, at least in my experience, Your Honor, when one side doesn't rest waiting for something to come in. I mean, maybe that's what we should have done. Hindsight being 20/20. That's not what we did. The point, though, is there's no reason for us not to want to put on this evidence if it is available. But we want to put it on when we are certain that it is reliable and valid. And I ask this court to recognize that in this case, time estimates by all sides have proved to be very, very short-sighted estimates. And to hold Mr. Sims and the prosecution at this time because of what the court may perceive as an unnecessary 1-month delay between the period in March and the period in April, I think is to penalize us at a time when we cannot penalize really anyone else for estimates that have proved to be less than accurate. I don't think the court can see Mr. Sims as someone who intentionally avoided doing what should be done to get results. And that is, I believe, what the court would have to find. Bad faith by the prosecution, trying to gain an advantage. And I think this court understands from Mr. Sims that he's not the kind of man who's going to let any prosecutor tell him how he should do his business in order to gain a tactical advantage. He is the scientist. He is the one who believes this is the mechanism he must follow to get a reliable and valid result. This is true rebuttal evidence, Your Honor. If the court has any other questions, I'll be glad to answer them. Otherwise, I'll submit the matter.
Thank you.
Do you have a brief response?
5 minutes.
Mr. Kelberg's argument is completely circular. He says since it's obvious that 30 and 31 were deposited on the same day, June 12th, as 303, 304, and 305, then if we put on evidence about 303, 304, and 305, it rebuts Dr. Gerdes' criticism of 31. Well, that's not the record in this case. And it's plain from the testimony of other witnesses that we're contending, or the jury is free to believe, that all those bloodstains were not necessarily there on June 12th. That's the point. Secondly, they can read from police reports all they want, but I commend the court's attention to 25187 of the record, where Greg Matheson's begins to discuss his collection of 303, 304, and 305. And as I indicated, he is at great pains to point out that he was swatching in the vicinity of 30 and 31, but he was distinctly taking a different blood stain that he had actually seen, he claims, a lighter area which might have represented previous swatchings, and he was taking a new sample. So again, it is a circular argument, and it is not directly rebutting. This is evidence about 303, 304, and 305, which Dr. Gerdes did not address. He was addressing 31. And as I point out again, on 30, there's no evidence of even a mixture. His argument about no one else should be asked to do anything in this case, the record is clear. Steve Myers assisted in other RFLPs in this case, and this was really nothing more than a ministerial matter to begin the restrictions and the analytical gel, and it could have been done. I would point out to the court that the record is that on March 22nd, they knew how much DNA and they knew how long it would take. He only began planning on April 25th. The restriction, which is a process he would take 2 or 3 hours, and he didn't actually begin it until June 7th. So I would submit that the real delay here is between March 22nd and June 7th. Finally, the prosecution is very conveniently putting it on Gary Sims. I think the record's clear. It's not Gary Sims. The activities of Mr. Sims between March 22nd and the time April 25th or June 7th were primarily taken up with preparation sessions for testimony in this case. When Mr. Kelberg says, who sets priorities with reason and judgment and common sense? It's them. They could have said to Gary Sims, Mr. Sims, it only takes a few hours and a 3-day or at most a 4-day process to begin getting those probes cooking, which is going to take the longest period of time developing them. The judge said immediately, if not sooner. The judge said we could get precluded because of time. The record is clear. During this period between March 22nd and April 25th or June 7th, as we would contend, they could have told him to do that. They could have suggested he gave no scientific reasons why that couldn't be done. It's not a question of Gary Sims' scientific judgment and trying to be careful. That's all a lot of nonsense. Steve Myers could have done it, but that's not even the point. They had the obligation. They had the obligation to say, the judge has made us clear that we are in danger if we don't make a good faith effort to get this evidence there, or an effort. The standard is not even good faith as far as the rebuttal issue is concerned. We have a problem. The defense has made it clear what the problem is. The judge has told us in no uncertain terms immediately, if not sooner, we could get precluded because of time. Just start that 3 or 4 day process to get the RFOP results going. That's what the prosecution could have requested of the scientist, and he didn't get up on the witness stand and say there was a scientific reason he couldn't have done it. It's on them, not Gary Sims.
All right, thank you, counsel. All right, I want to review 2 items from Dr. Grudy's testimony, and I want to review, before I rule, the exhibits that discussed items 31 and 303, 304, and 305. So I'll have to have Mrs. Robertson pull those out. Mr. Kelberg, would you give Ms. Robertson a list of the exhibits?
I would be glad to.
The photo exhibits. All right. As to the 1054.7 hearing that the court conducted with regard, and Brady hearing, that the court conducted with regard to Dr. DeForest. Where's Mr. Neufeld? Chosen to absent himself. Well, Mr. Scheck, would you tell him that the result of the hearing this morning was that the pages that the court had concerns that were potentially Brady material were in fact turned over in a previous discovery matter, so the issue was moot?
Mr. Hodgman spoke to me before he left and said that the issue had to do with the wet transfer stain of Nicole Brown Simpson's blood on the other sock that went through to the other side. And I want to point out that that's a finding not just of Peter DeForest, but Mr. Sims. So I understand, if I take it, this is the July 17th materials. Are there pictures associated with that?
No. But there were notations. That's what caused me concern about whether or not it was Brady materials, but it turns out that had been, unbeknownst to me, had been previously turned over to you.
Okay.
All right. So I wasted all of my time reading those materials.
Well, if it had been put together in a fashion and a form, it would have been easier.
So there was another 2 hours of my time.
I'm pretty sure that you're talking about.
Your Honor, may I be excused so we can go upstairs, get the exhibit numbers, and
Yes.
give them to your clerk?
All right. Thank you. All right. On, let me see. All right, Ms. Clark, do you have your next witness available?
Yes.
All right, where do you intend on going after Mr. Rubin?
After Mr. Rubin, then Gary Sims.
How long do you anticipate will be with Mr. Rubin?
5 minutes. 25.5 minutes.
All right. Mr. Blazer, any guess?
No, but I do have a limited motion to make with respect to Mr. Rubin, briefly.
All right, we'll hear it.
I would ask that he be limited, in terms of looking at pictures or testifying about pictures, that he be limited to what
has been presented and identified in court and not testify about pictures that aren't in court.
Ms. Clark? I'm sorry, Mr. Darden, any comment on that?
No, we intend to show him anything we can lay the appropriate foundation for, Judge.
Are there any other materials that have not been presented in court or that defense counsel has not had access to that you intend on using?
I don't believe so.
All right, I see we have counsel from NBC with regards to the SDTs present in court.
I would ask if Mr. Rubin be instructed to not testify about things that he's not shown.
What's the, it would be an incompetent opinion if he were to testify and give an opinion on items he has not seen or examined, wouldn't you say?
No, about items that the jury has been presented with. He's seen other items. I don't want him blurbing out things about things that haven't been introduced. That's my only concern. Well, I'm
All right,
sure
what's the
Mr. Rubin
status,
has.
what's the status of our, Mr. Yokelson, what's the status of your conversations with NBC?
Your Honor, Ms. Edgerton is here from NBC. I'd ask her to step forward. She could step forward to represent NBC's position. However, with respect to the declarations that we referred to yesterday, apparently Ms. Edgerton has been unable to secure any modification. However,
I'm sorry. All right,
she's of the opinion and I
hold on.
join.
All right, the record should reflect now the presence of the defendant, Mr. Simpson. We also have present counsel Ann Edgerton representing NBC. Good morning, counsel.
Good morning, Your Honor. I wanted to summarize very briefly for the court the history of these 10 subpoenas, now 11. We received another one late yesterday, which I'll come to in a minute.
All right, it's noted in your letter to the court.
Yes, I know, Your Honor, but what we have on the record as of late yesterday afternoon is a statement by Ms. Clark that NBC has been, I think her phrase was, totally uncooperative in responding to these subpoenas. And therefore, I would like an opportunity very briefly to summarize for the court what the history of this has been. We have received 10 separate subpoenas over 14 months. In response, we have responded to each and every one of those subpoenas. We have produced 19 separate videotapes, which constitutes about 3 Beacons boxes full of material. In addition to the videotapes, we have produced at least eight custodian of records declarations. In order to produce those videotapes, which were first requested on VHS and then later on 3/4-inch tape, we were asked by the district attorney's office to produce them on a very expedited basis. As a consequence, we had videotape engineers working nights, and we had videotape engineers working weekends. I personally have spent more than 50 hours responding to these subpoenas. There are countless others at NBC, videotape engineers, clerical staff, other lawyers, many in the sports division who have spent tens and tens, if not hundreds of hours complying with the many, many requests for footage that we have received from the prosecution in this case. So when Ms. Clark represents to this court and to the public that we have not been cooperative, I can only conclude, Your Honor, that she has not yet had an opportunity to talk with her colleagues in the district attorney's office with whom I have been in almost constant contact over the last year, including Mr. Yokelson, Patty Jo Fairbanks, Ken Lynch, and Mr. Hodgman himself, who told me as recently as last Tuesday, in essence, that he appreciated our many efforts to date. All of these subpoenas may well be invalid. They are issued by a California court for the appearance of a witness who works and lives in New York and for footage located in New York. As I'm sure the court is well aware, there are specific provisions in the California Penal Code in 1334.3 for securing the attendance of witnesses in foreign jurisdictions. The district attorney's office, for reasons that I am not privy to, Your Honor, has made no effort to comply with any of those provisions here. We, I believe, respectfully would have been well within our rights to decline to respond to the subpoenas, but we have not done that. We have responded promptly. We have knocked ourselves out to get them 3 boxes full of material. And the only thing that we have respectfully declined to do is to fly a witness voluntarily in response to an essentially invalid subpoena, to fly a witness 6,000 miles to testify that a piece of footage of an NFL game is what it appears to be, a piece of footage of an NFL game. Until yesterday at about 4:30, when Ms. Clark mentioned the January 1992 game, we did not even know which specific footage in those 19 lengthy tapes in 3 Beacons boxes full we were being requested to produce a witness to authenticate. And the reason that there is not a person who is the person that we could bring out here to do that is because of the way these copies were made. Because the prosecution wanted them on a very expedited basis, and because we had people working literally around the clock in New York in videotape edit rooms making these dubs, there were a variety of people who worked on the dubs, many, many different videotape engineers working night shifts and so on. They were supervised by different managers of the videotape library. So my concern, which I have expressed many times to Mr. Yokelson, with whom I've had a very good relationship all these many months, and to Mr. Hodgman last week, is that my concern is that if we were to fly a witness out here, that witness might not be able to say, that witness would not be able to say, I made these copies myself. Under NBC's contracts with unions and guilds, that work is done by represented employees. They may be supervised by others. So what we have repeatedly said is we don't understand, quite frankly, why the prosecution couldn't simply say to the defense, these are the clips we want to get in. These are NFL games at which Mr. Simpson himself was present. No one can really dispute that these little clips are what they appear to be, clips of games at which Mr. Simpson was present. So I have a motion to quash that I have prepared. We're not going to file it, Your Honor. If the court wants us to bring a witness 6,000 miles to testify to this simple foundational fact, we will do that. As I say, there has been no compliance with 1334.3. Why that is, I don't know. We get subpoenas every day, sometimes 3 or 4 a day, from lots and lots of people who all think their case, federal or state or civil or criminal, is as important as this one. We try to respond to all of those. Most of those people follow the rules. Now, why some of the rules aren't being followed here, I don't know. But the bottom line is we certainly don't want to be blamed for the prosecution's not going through the Uniform Act. And if the court says to me, you want us to fly someone out here, that may mean we have to redub the footage, because I'm not sure we can identify the person who in the middle of a night on a Tuesday last June made that little piece of tape that I understand the prosecution now seeks to introduce. We will put that person on a plane and we'll bring him out here.
Mr. Yokelson.
Your Honor,
we're spending much too much time on something that could have been handled in a perfunctory manner. Yes, NBC has provided videotapes whenever we've asked for them. What they have not provided us with is the guarantee of a live witness if necessary, or a custodian's declaration of records, which was not received until yesterday. We now have a custodian's declaration of records, and we are prepared to go forward on that. With respect to the specific tapes that were going to be introduced in court, at Ms. Edgerton's request a week and a half ago, I sent her a chart detailing specifically what segments we were using, and I asked her to try to make efforts to ascertain who dubbed these and who would be the live witness. Those results are still not forthcoming. Regardless of any of this, the fact of the matter is we are seeking to introduce footage at this time from one football game played on January 5th, 1992. Now, I agree with counsel that this is a matter that parties could easily stipulate to, but frankly, counsel from NBC is not trying this case. The lawyers here are trying this case, and we have asked the defense to consider a stipulation. That has not been forthcoming, and frankly, we can't force them to accept a stipulation. We are going to ask the court today to take notice of the declaration of records that has been filed. We can explain this. It covers the segment of tape that was played in court yesterday, and we believe that this will suffice, and this will settle the matter.
What is this? Is this a new declaration from the one that was submitted yesterday?
It's the same declaration, but I believe we can point out to the court that the videotape that was offered in court is videotape that came as a result of this declaration. That declaration refers to a pre- and post-game show, which they were unable to locate. However, the declaration also states that the remainder of the tape was provided by NBC for the game and the halftime shows. The segment of tape that we are offering is a brief segment that came at the end of the halftime show and the beginning of the third quarter. And it came from the 3/4-inch videotapes that NBC provided. In fact, I have them here in court. There does remain a matter of a second subpoena, which we take up in a moment. But let's cover this. We believe that Evidence Code Section 1560 has been fulfilled and that the foundation has been laid with respect to this one piece of video.
All right, I thought the declaration from Mr. Laplace yesterday indicated that he could not vouch for that particular videotape. Did I misread that?
Your Honor, Mr. Laplace's, he did 6 different declarations because we received the subpoenas which were sort of oddly framed. Some of them would call for, one would call for the halftime show, another would call for the pregame game and postgame. In another set of subpoenas for another date, one would call for the pregame and one would call for the game. Anyway, so we tried to frame the language of the declarations to respond to each subpoena. The one that is at issue here, as Mr. Yokelson said, called for the game, the pregame and the postgame, not including halftime. What we were unable to locate was the pregame and postgame, even though we had a retired person even check at his home for tapes. That is not, as I understand it, what the prosecution seeks to introduce. So the bottom line is that we have authenticated all footage we produced. Needless to say, something we could not locate and did not produce, we wouldn't presume to authenticate. So the language the court may have been looking at yesterday, which is at lines 17 and 18 of that declaration, refers only to the pregame and postgame footage, which, again, I understand is not now at issue.
And that is not what we were offering.
So paragraph 2, Your Honor, which...
I'm sorry, which affidavit are you
Well, the
referring
problem
to?
is they're all dated July 5, so it's a little hard to tell, but it's the one, if you look at line 11, it's the one that says, that refers to the Chiefs and Bills played on January 5, 1992. And it says the videotapes that were produced contain a true copy of the broadcast footage of the game. It was prepared by NBC personnel in the ordinary course of business at or near the date, et cetera.
All right, any other comment, Mr. Blazier?
Yes, Your Honor. As I understand it, and I think it's important that the papers that we got from NBC indicate that the first subpoena for these football games was July 11th of 1994. I think that's relevant to the issue of whether they had adequate opportunity to prepare this issue. Nonetheless, I think what the court's being asked to do is to take some sort of notice of what NBC says is a legally invalid subpoena with a declaration that says we can't provide you everything that you subpoenaed. We don't know where the rest of it is. We object to that. It's the very reason why a custodian should be here to clarify that. We're not prepared to stipulate to anything, and we think this is an invalid subpoena, an affidavit that tells them I can't give you what you asked for, and we object to it.
Mr. Yockelson, any response?
Your Honor, if NBC, we believe that the provisions of Evidence Code Section 1560 have been complied with. If counsel is willing at this time to provide a custodian of records to fly out here, we'll pay for it and we'll deal with it.
All right.
But we want to use the evidence now, and we're indicating that this is our good faith representation that we can establish a foundation for this tape.
All right. Is the matter submitted?
Yes, except for there remains a second outstanding subpoena with respect to testimony from the witness yesterday, Deborah Gadara.
We received yesterday, shortly before 5 o'clock, Your Honor, an 11th subpoena from the district attorney's office. This one says that we are to provide a live witness tomorrow morning at 9 o'clock in this court and to bring with that witness another 5 or 6 of the big 3/4-inch tapes of now a 1993 game. Because of what we've been through on this, Your Honor, frankly, I would like to just seek the court's guidance. If I don't want to file a motion to quash. There are the same problems with this subpoena as with all the others, the noncompliance with 1330 and 1334.3. But frankly, Your Honor, I have spent hours and hours and hours. I want to be done with this. If the court wants us to bring a live witness tomorrow for that, we'll try to do that.
Your Honor, for that, we don't need a live witness. We can do that later. If we could simply have that tape, even in a VHS format, we'll accept it, along with an appropriate custodian's record that will meet the requirements of Evidence Code Section 1560 and the foundation that's been laid in the form of the testimony of Deborah Gadara.
All right.
We can do that, Your Honor. I'm just not sure we can do it by 9 o'clock tomorrow morning. Typically, under Evidence Code 1560, we get 5 days.
I understand.
We'll do our best, as always.
All right. I'm going to direct you to make your best efforts then to provide the tape and declaration of a custodian of records by the close of business tomorrow. All right. Thank you. I'm sure you can get it FedEx today.
On the, now on this January 92 game, we are to bring a witness tomorrow morning?
As to the January 92 game, I'm going to find, on the basis of the explanation given to me, that the declaration that is page 13 of 16 of your letter to the court dated September 11 is sufficient for the purposes of the California Evidence Code, so the objection will be overruled.
Thank you, Your Honor.
All right, Mr. Blazer.
You know, as to this next videotape, we have not been provided with that. We have not been provided with 3 Beacons boxes either. But the one that we're talking about now is central to Mr. Rubin's testimony, and I cannot cross-examine him on the Gadara picture until I see the videotape. If you'll notice, the Gadara picture does not show a lot of detail. I can't cross-examine him on that without seeing this videotape.
And Your
So
Honor,
it can't be
we haven't seen it either, and we're attempting to get it, and when we get it, we'll evaluate the evidence. But the fact of the matter is, we don't have
Well,
it either.
given the offer that it's going to take 20 minutes to direct examine Mr. Rubin, Mr. Rubin may be on and over before any of this stuff shows up.
Well, if that's the case, we will still move to present the videotape and let the jury evaluate it for themselves.
Well, that'll be something we'll take up later.
Well, Your Honor, tactically, I can't cross him on something when there's other evidence out there that I don't know what's in it. I have certain questions I want to ask him about that picture. I can't do it this way.
All right, Ms. Edgerton, I think your duties are done. Thank you. Mrs. Robertson, may I see the board again from yesterday? And Mr. Hayden will take up the Pitchess matter as soon as we conclude this. Excuse me, counsel? All right, the Gadara photographs are the, what appear to be brown gloves, and Mr. Simpson appears to be adjusting microphone control. All right, thank you.
I would be happy to make an in-camera showing at sidebar as to why I can't cross without the video.
All right, I don't think that's necessary at this point. We may have to adjourn the cross-examination at that point, as to Mr. Rubin. All right, as to the Pitchess matter, we'll conclude this, and then we'll bring the jury down. I'm sorry? All right, Mr. Scheck, you filed a supplemental memorandum of points and authorities.
It really is, frankly, nothing more than the case that I said there was a Pennsylvania case from the Supreme Court. It was Pennsylvania versus Ritchie. And I would commend to the court's attention that these are cases directly on point with respect to statutory privileges, and I'm sure the court is familiar with other related case law concerning informants' privileges, but the point is simply that our Brady rights trump any absolute prohibition here. And we think there are a number of different ways that the court can pursue these records. Obviously, it's futile to pursue a Pitchess motion that limits us to something that goes back, limits us to 5 years, when the material that arose in the course of the investigation in this case by Internal Affairs indicates that what we're all interested in is something that's over 5 years old. And I think the Constitution and due process requires that these records be ordered, turned over to the court for its inspection and possibly turning over to the defense. And therefore, the statutory restrictions of Pitchess have to be overruled.
All right. Any other comment?
Thank you, Your Honor. The statute speaks for itself. The requested materials by the defense in this case have no bearing whatsoever to the issues in this case. My client hasn't worked with Mark Furman since 1989. There's no showing he had anything to do with anything that happened at Bundy or Rockingham. As counsel has still not addressed 1047, and even if one were to expansively view 1047 of the evidence code, you still get to the situation where my client wasn't there. He has absolutely no connection whatsoever. Counsel submitted a hypothetical and a footnote in the brief that he submitted. That hypothetical has no bearing whatsoever to the facts of this case. There's not even a suggestion that my client had anything to do with anything that happened on June 12th of 1994. I would also note that in the defense's purported search for the truth, they haven't exactly engaged in a rush for discovery. The information related to this matter was known to them as early as possibly February, certainly as early as April. They've sat on it. They have not attempted to get arrest reports and transcripts, which they are seeking from my client's personnel file. If there are any such materials like that in my client's personnel file, Your Honor, they have to show first under Pitchess they have made a good faith effort to find those materials. They haven't. They certainly haven't given us anything in their declaration to show that they have made a good faith effort to find any of these materials. The whole essence of the Pitchess statute, Your Honor, is a balancing. It's a balancing of certain constitutional rights. The defendant's constitutional right of confrontation and my client's California constitutionally based right to privacy. And in this particular case, before they can invade my client's personnel file, they have to show there's a necessity for it. And they haven't done that. They have not met the requirements of the statute, and they should be denied access to the file. Thank you.
Thank you.
As to the relevancy of this case, I think it's clear that this officer, in the course of an investigation for Brady material in this case, indicated that he burned a diary that contained information about misconduct of Detective Furman because he knew it was being sought. That this officer, with respect to the swastika incident and with respect to this incident where he could if we got the records, help us prove that Detective Furman had falsified evidence and asked a police report and asked this officer or got this officer to conform his testimony to prove the code of silence, I think it's all potentially highly relevant, and there might have been more in that diary. We think that this officer, in the answers he gave us, in light of what we found on the McKinney tapes, was not telling us the truth. And we had we did not know, and we still don't know, whether the internal affairs reports that the court has reviewed in camera contain anything about this diary and this information. So we think it's relevant, and we still think that it's extraordinary that the legislature has this statute. Here's Mark Furman in the Furman tapes bragging about all the different internal affairs investigations that he has been able to beat in terms of his own misconduct. And when we make a pitches motion for Furman and we make other related pitches motions, not one thing came out. The only reason we even became clear that Detective Purdy had relevant information as to Furman's racial attitudes, perhaps, dealing with the swastika incident and other misconducts in terms of fabricating evidence, is because of the statements that Detective Purdy himself made to a district attorney in this case who Ms. Clark told to get out of her office. And only because we continued to pursue that, and in light of the new evidence in the McKinney tapes and an additional interview with Detective Purdy and others, are we now on the trail of something that we think will be additional exculpatory evidence. And if Internal Affairs interviewed him in relation to those materials in this case, how can they rely upon a statute saying that we're not entitled to see what files Internal Affairs might have reviewed or ought to have reviewed when they interviewed Purdy in this case within the 5-year period, just because it relates to something 5 years back? I think that's nuts. But besides that, we have the Constitution to rely upon, and that's where we place our faith.
All right, thank you, counsel. All right, the request under pitches for discovery of the personnel file of Detective Purdy will be denied for the following reasons. One, the issue goes to a collateral matter, which is the credibility of Detective Furman. The conduct and contact between Detective Purdy and Detective Furman dates back to 1989. It is unlikely that their contact would lead to exculpatory evidence in this particular case. Also, the file that has been suggested here, that information is a matter of public record in the records of the court. It is accessible to counsel. Also, the court is restricted by Evidence Code Section 1047 from going further on this. I agree with you, Mr. Scheck, that appears to be in conflict with certain rulings of the United States Supreme Court, and I would encourage you to take a writ on the matter. All right.
I realize your 8:30 calendar is overly burdened, so to save you some time, I've written a letter that I'll have copies made of concerning our request for relief concerning further test impressions of Ronald Goldman's genes without an opportunity.
I know,
for...
Mr. Goldberg's here. I thought we were going to try to discuss this today at 8:30.
Well, to save you time, I have written a letter, and you can read it, and then you can ask him to address it. I just don't want anything to happen before you have an opportunity to deal with it.
We have a letter, Your Honor?
No, I didn't get
I'm making a copy of it right now.
All right, we will take a recess for 15 at this point, and I'll see counsel in chambers with a court reporter right now. All right, back on the record in the Simpson matter, the defendants again present before the court with counsel. People are represented, jury is not present. The court has had an in-camera hearing with defense counsel concerning the ability to go forward with cross-examination of the people's next proposed witness, Mr. Rubin. And Mr. Darden. And is Mr. Yokelson gone already?
Yes.
All right, on the basis of that offer, my inclination at this point is to require Mr. Blazier to go forward with the cross-examination of Mr. Rubin. However, he may reserve cross-examination as to one or two of the items pending further revelations and discovery, which will require Mr. Rubin, unfortunately, probably to have to return one more time in the next week to 10 days.
Mr. Blazier has Mr. Rubin's home number. Right. Mr. Rubin says he is amenable.
All right, let's proceed.
May I be here, Jim?
As to what?
A couple of motions, a couple of things that took place.
Motions be at 6 o'clock.
Okay. One thing, Your Honor, we are very concerned about what took place back in chambers, and we need an immediate conference with Your Honor. We talked to Mr. Dershowitz, and we have a perspective that we want to bring to Your Honor's attention. I want to give Your Honor a heads up regarding that, so we need to talk to you right now on that matter. We think it's very, very serious.
You can be heard.
Proceed now. With regard to the juror problem, Your Honor. I can address it? All right. Your Honor, in chambers during the last break, one of the jurors who shall remain nameless has a potential problem and brought that to Your Honor's attention with regard to, shall I proceed? With regard to some rental property that she's having. And I understand she wanted to go.
I think you can be a little more oblique in how you discuss it. I understand what we're talking about.
All right. You understand? All right. And the court's offer to this juror, we find totally unacceptable to the point that it would be, I think, would have a tremendously adverse effect if that is done. And we think it's unprecedented. We took the step of calling Mr. Dershowitz and our other appellate lawyers. They feel so strongly they want to take a writ on it right away.
Take a writ?
We will do that. We will do that. I want to let you know we'll do that. But I think I should try to talk you out of this process, because what it does, it will taint that particular juror. The rest of the jurors aren't getting that benefit, and those are public funds, and I don't think we can do that. It's over and above someone's salary, and we don't think it's appropriate. And I think I should bring it to you in the strongest possible terms. We feel really strongly about this. Furthermore, this jury will be even more beholden to Your Honor from a standpoint of, not that you give her any cues or clues or whatever, but I think it would be...
You realize there's precedence for this.
No, I don't. I don't think there's been precedence for that particular thing, for what's happening in this case. I don't think so.
Take your writ, counsel.
All right, we will take the writ, Your Honor, but we'd like to be heard further because we think this is unfair to the other jurors, it's unfair to this particular lady, and it's just, I think that it sends a message that's just, it's hard to express. And so I wanted to at least indicate to the court how strongly we felt about this, and I'd like for you to reconsider this, because I think it's going to be a real dangerous precedent to do this when we're not doing this for other jurors, but more importantly, what it says about the system. To pay a juror basically above and beyond that, I think is inappropriate.
All right.
All right, so I mean, will you entertain further discussion from us?
Well, I've noted your objection.
All right, okay, well, very good. Hold on a second. The other thing is, and the other motion I can bring, we have a motion regarding sequestration of the jurors, and you want to hear that at the end of the day?
6 o'clock.
All right, and we have a motion regarding scope of the rebuttal, which the balance of the scope
We'll
of the
take
rebuttal.
care of that after we finish with Mr. Rubin.
All right. And then we may have some further remarks regarding this juror problem at that time if the court would allow us.
All right, let's have the jury, please.
I need to get a video monitor into the courtroom.
A video monitor?
Yeah.
For what purpose?
Clarity. Videotape of Mr. Rubin describe some of the...
Is there a reason we didn't do that during all this downtime?
Yeah, I forgot to bring it to your attention and ask your permission.
Is it on its way?
It's right outside the door.
Bring it in. Budget include WD-40? The indication by Mr. Darden was that he felt that this monitor had greater clarity.
Can we preview it first? We haven't seen this.
I think this is the same thing that we looked at yesterday.
Well, it has different quality. It's not the same thing.
And this is just another feed off of Mr. Darden. This is just another feed. In other words, you're just directing the same feed to this particular monitor. Which video? The Boomer Esiason video? Which video?
The one we saw yesterday. The video, J46 magazine video.
All right.
Bringing in special equipment because what we've been using for 8 months is not adequate. Is that my understanding?
Well, Mr. Rubin is going to be pointing to stitching and other very, very small items and details on the glove, and that's why we brought a monitor. Clarity.
All right, let's have the, I'll have this played for Mr. Blazier and council so they can see if there's any difference on how it's displayed on the direct view monitor. All right, if we're gonna use this, Mr. Darden, you're gonna have to use the central podium. If you're gonna use this, you're gonna need to use the central podium. All right, Mr. Fairlow, just leave it there. All right, would you play for Mr. Blazier, please, the video on the new monitor?
Yes, sir.
All right. Let's turn the monitor around so we can all see. All right, 90 more degrees. Stand over next to Mr. Darden. All right, so Mr. Harris, this is so Mr. Simpson can see. Swing it around some more. Thank you.
the additional feed is causing us to lose a little too much signal, so I don't think we're going to end up losing. It's just not, it's not giving the sort of image quality that we hoped it would.
All right, break it down. All right, Deputy McNair, let's have the jury, please. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, the people may call their next witness.
Richard Rubin, Your Honor.
All right, Richard Rubin recalled. Mrs. Robertson.
Testimony may give in the opinion before this court to be the truth, the whole truth, and nothing but the truth to help you God.
Yes, I do.
Please have a seat on the witness stand and statements by your personal opinion for the record.
Richard Rubin, R-I-C-H-A-R-D, R-U-B-I-N.
Mr. Darden.
Thank you, Your Honor. Good morning. Mr. Rubin, you testified before this jury on June 21st. That was the last time. Is that correct?
That's correct.
Okay. And you visited me in my office last week, or rather the 30th or 31st of August?
August 31st.
And prior to that date, had you been sent some videotape and or photographs by a member of my office?
Yes, I did receive some.
Was that both videotapes and photographs?
Yes.
And what was shown in those photographs?
There were various still photos and videos of a group of NFL football games where Mr. Simpson was announcing.
Okay. And you weren't present in the courtroom yesterday afternoon, is that correct?
I was not.
Okay. But did you watch on television the photographs and video tape that was displayed to the jury?
I saw some of it.
Okay. Did those videotapes and photographs appear to be videotapes and photographs that you have seen before?
Yes, they are.
And having had copies of those same videotapes and photographs, did you have an opportunity to study them carefully?
Yes, I did.
Okay. And you and I talked about your observations?
Yes, we did.
Okay. And have you also spoken to the defense about your observations of that videotape and those photographs?
Yes, initially I was contacted at my home by Mrs. Blazier on September 1st, where I was told I would be coming back, which was news to me at the time. And then yesterday morning, during a break, I spent some time with Mr. Blazier, and then yesterday at the conclusion of court, I spent some time with Mr. Blazier.
Now, when you were here on other occasions, you took a look at the Rockingham glove, which has been marked 164A. Is that correct?
Yes.
Okay. And you also had the opportunity to take a look at the new Aris leather-like gloves marked 372C. Is that correct?
I'm not 100% sure what that particular style glove is. Yes, I've seen this before.
You were here for both glove demonstrations?
Yes, I was.
Okay. You told us that the style number of the glove at Rockingham and Bundy was an Aris 70263. Is that correct?
That's correct.
And you also told us that the new pair of gloves tried on by the defendant were also 70263s?
That's correct.
And the videotape that you looked at and the photographs that you also looked at, why were you looking?
I was asked to look at these various photos and videos and try to establish whether or not they were the same.
What was the purpose of looking at them, sir?
To determine whether or not they were the same style as what was shown to me as part of the crime scene gloves.
And were you able to make a determination?
On some of them, yes.
And you also told us when you testified here in June that you in the past had actually manufactured, sold, marketed, and designed gloves for Aris. Is that correct?
Yes, I did.
Okay. You actually helped build factories, glove factories.
Yes, I have.
And you also told us that the Aris style number 70263 was a unique glove. Is that correct?
It was quite rare by comparison to all the gloves that I was involved in as far as production, design, and marketing. It was very limited in quantity and extremely difficult to make, very slow production. It was very distinctive by nature due to some of the characteristics of the glove, yes.
Okay. And are there certain characteristics of the glove that help you, as an expert, to identify the glove when you see the glove?
There are certain characteristics of the Brasser sewn style 70263, which in the design of the glove were built to make sure that it really didn't look like gloves that were less expensive. It was stated on the record, I believe, that the gloves were retailing at $55, and while to the average layman, a glove is really 4 fingers and a thumb, we had to be able to justify the fact that this glove was going to be retailing at $55.
Next question.
Okay. Well, the Brasser stitching is unique to the glove.
Very.
Okay. How about the vent, the palm vent?
The palm vent is the least unique characteristic of the specific style in question.
Okay. But does the palm vent help you to identify the glove when you see it?
In conjunction with other characteristics, yes.
Okay. Is there something called a blind hem?
Yes, there is.
And what is a blind hem?
A blind hem is where at the end of the glove, at the wrist, the leather is turned over. A seamstress, usually very skilled, actually sews through the lining, through the hem on the inside, and then catches a little bit of the leather that would be toward the outside of the glove without going through the leather, and then comes back through and closes the seam,
okay,
creating a very smooth, clean look at the back of the glove.
So it doesn't leave a hem on the outside of the glove?
It's not supposed to leave any identifiable marks on the outside.
Okay. And what about the leather used to make this particular glove?
The leather that was used in the Aris Lights program exclusively for Bloomingdale's was approximately 33 to 40% lighter weight than the conventional leather used in all the other production of men's gloves. It was approximately 0.55 to 0.6 millimeters in thickness.
Was there anything unique about the lining of these particular gloves?
This was the only leather glove style that was ever produced with a 10 gauge, very thin lining, which was one end of cashmere yarn, so that the entire glove package itself was extremely thin. All the other linings that we used were twice as thick.
Now let me direct your attention to the stitching on the back of 164A. Is there needlepoint stitching on the back hand or the back of the hand?
There are 3 decorative points called draws on the back of the glove, yes.
And is that unique to the style 70263?
It's part of style 70263. Most men's gloves do have 3 points on the back or 3 draws. This particular draw is a 1, 2, 3 needle configuration without cord underneath to raise them. It's a flat point, but they are used on other men's gloves.
And you told us a little while ago, or a few moments ago, that you were able to determine whether or not some of the gloves worn by the defendant in those videos and photographs.
State a question, counsel.
You were able to determine whether or not some of those gloves in the photos and videos were in fact Aris 70263s?
Yes, I was.
And if in fact they are, they would be the same model and style as the crime scene in Rockingham glove, is that right?
That's correct.
I'm going to show you some videotape to start off. I'm going to start off, Your Honor, so the record is clear, with the Bengals versus Bills game on January 6, 91. Now, I'm not going to show you the entire tape. This is Exhibit 608, I believe. But I am going to ask you to take a look at certain frames, okay? For the record, the frame number is indicated on the video.
All right, Mr. Dart, if you would call those out when you start to examine Ms. Rubin as any particular frame, please.
Let's start at frame 248.
All right, Mrs. Robertson tells me that must be 607.
Sure. 607, Your Honor.
607.
Okay.
Yes, 1691, Bengals.
Okay. Let's go to frame 2090. Seen this frame before, is that correct?
Yes, I have.
Looking at that particular frame and the gloves shown in that frame, can you tell us whether or not that glove, the glove the defendant is wearing, is a 70263?
Of the key features that would be part of identifying style 70263, on the right hand, the fine ridge stitching along the fingers, primarily the second finger, as well as the 3 needle point configuration to the left of it, are the 2 identifying factors that I would use to say that this is style 70263. This particular Brasser sewing machine creates a stitch with approximately 22 to 24 stitches to the inch and creates a continuous ridge, which, when I eliminate the other kinds of sewing that I know about within the glove industry, that to my way of thinking, this can only be a Brasser seam.
Looking at that glove, do you see any water stains at all?
Mr. Darden, on this particular monitor, I can see a little bit, but as you know, I've had the advantage of looking at these photos and videos on small monitors and
Non-responsive. Next question.
Have you seen other, strike that. Have you seen the same videotape on a smaller monitor?
yes, I have.
Overruled.
Yes, I have.
And did that smaller monitor provide more clarity?
Yes, it did.
And when you looked at the same frame on that smaller monitor, were you able to see water spots or water
Yes.
stains?
Yes, I saw water that had been stained on the left hand, yes.
Could you tell whether or not the glove was absorbing that water or those water stains just by looking at it?
Yes, I could. In certain spots, it was absorbing water.
And how could you tell that?
Well, this particular glove is made out of naked leather, and at this point in time, it was in a position to absorb water or stains. And literally, the staining of the water droplet made the leather in that area appear darker.
By the way, there was rainfall throughout this interview, was there not?
I've seen the video roll. Yes, there has been rainfall, and he's holding an umbrella.
And how about the fit of the glove? Can you tell us anything about the way the glove fits in this particular frame?
They're snug, but they appear to have fit fine.
Can I have one moment, Charlie? Could you direct the arrow to the brochure stitching that you referred to on the second finger a moment ago?
On the right hand, if you go down to the second finger and you see that fine ridge from left to right, right across the finger, it's about a 3-inch curve.
And you also mentioned the 3-needle point on the back of the glove?
Right to the left of it, it has the image of a 3-needle point.
Which hand are you referring to?
All right, 607A.
Okay. We'll next go to frame 1541. Here we are at frame 1541. Can you see the brochure stitching in this frame?
This is another version of the first picture. I can see some ridges on the top left finger that concur with what brochure stitching would look like in a photograph.
What characteristics are there that relate to brochure stitching that are different from other kinds of stitching that are done?
It's really the most continuous seam that has ever been utilized within the glove industry, to my knowledge. The other sewing techniques create high-lows or raw edge effects or continuous curved effects, whereas this is clearly a seam that is created by the sewing machine grabbing the two pieces of leather and putting them together.
Okay. And is that reflected in the crime scene glove, or rather the Rockingham glove?
Yes, it is.
Is that also reflected in the new pair of gloves marked 372C?
No, it is not. This particular pair was the pair that they produced with the same style number after they went out of production.
Oh, so that pair of gloves right there is not the same kind, the same type as the crime scene gloves?
No, it is not.
How'd you know that?
That's what I did for 15 years, and it's quite easy for me to recognize it.
What is the difference between the Rockingham and Bundy glove and this later model, the later model glove that you have in front of you?
Even though it was manufactured with the same style number, 70263, the sewing technique is actually what is called 1/2 PK sewing, and it has a totally different effect both on the palm and on the back of the glove. And in this particular case, this isn't even the same leather that was utilized in the original gloves.
What is, let's strike that. How many stitches per inch are there to a brochure stitch?
Approximately 22.
And is that unique?
It's almost 100% more than all the... It's almost 100% more than the other conventional sewing techniques that exist, and in the case of a hand sewn, it's approximately 4 times the amount.
Let's go to frame 2425. Let me ask you to take a look at the fingertips, the ends of the fingers in that particular photograph.
Yes.
Does it appear that the defendant's hand, or rather that his fingers are fully and completely into the glove?
Objection.
Overruled.
In this particular picture, one of two things have occurred. Either the gloves are not completely pulled down all the way onto his hand, or there's a little excess in the fingertip.
Now, when you were here last, you spoke to us about the length of the fingers in the crime scene and Rockingham glove.
Yes, I did.
And you also spoke to us about the length of the defendant's fingers.
Yes, I did.
And the size of his palm.
Yes, I did.
What size palm did you say the defendant had?
Mr. Simpson has a size extra large palm, and the fingers on both of his hands are size large. Technically, his real size is a cadet extra large, and this is where the actual fingers are approximately 3/8 to a ½ inch shorter than a conventional perfect extra large.
And so would you expect that if the defendant fully placed his hand into a glove, that his fingers would not reach the end of a traditional extra large glove?
In this particular case, as I stated for the record in my previous visit, there are definitely 3 different size extra large gloves, one being slightly undersized, one being exactly standard, and one being a little bit larger than standard. And for this exercise, I would say we have to use standard. In a standard extra large glove that was perfectly made for a perfect extra large hand, the fingers in that glove would be approximately 3/8 of an inch longer than Mr. Simpson would require.
And you do see excess finger space in these gloves?
In this particular photo, yes.
Let's go to 2585. So this frame depicts the defendant's left hand, is that correct?
Yes, it does.
Can you see any excess finger space in the left hand?
My monitor is very, very cloudy on this one.
So you can't tell?
Not in this particular one, on the monitor.
Let's go to 3357. In frame 3357, you can see the defendant's right wrist area. Is that correct?
Yes, I can.
Is there a bunching up of the leather at the right wrist?
It appears to have somewhat of a gathered look.
And is that significant to you at all?
This would be consistent with a lighter piece of lightweight leather. The leather is not that rigid or firm, and you easily get a gathered up look in a lighter weight leather.
And so this bunching up or gathering up at the wrist area, is that consistent with this glove being style 70263?
Yes.
Let's go to 4060. Okay, again, you can see the right glove, the right hand.
Yes, this is a closer shot.
Does the glove appear to have a snug fit?
Yes, it does.
And can you see the needle point on the back of the glove?
This particular shot shows me the 3 needle points on the back as well as the blind hem.
And is that consistent with this glove being a model 70263?
Yes, it is.
Let's go to 4443. Take a look at this frame, if you will. Can you see the defendant's left hand in this?
Yes, I can.
What, if anything, did you notice about the hem area, the palm area?
This pair of gloves appears to have a palm vent.
Is that consistent with the model style number 70263?
Yes, it is.
Can you also see the needle point on the back of the right-hand glove?
Yes, I can.
And let's go to 4582. And what do you see in the left-hand wrist area?
This is a slightly larger shot of the opening of the palm vent on the left hand.
And 6777. You see any identifying characteristics in this photograph?
3 points on the left hand as well as the blind hem and the palm vent on the right hand.
You described for us a little while ago some of the characteristics unique to style number 70263. Is that correct?
Yes, I did.
Did you see each of those characteristics exhibited in these frames of this particular video?
I've seen 4 of the possible 6.
Okay. You saw the brochure stitching?
Yes, I did.
The palm vent?
Yes, I did.
What are the other 2 characteristics that you saw?
The palm vent, the blind hem, the 3 needle points, as well as the brochure stitching.
Did you see the cashmere lining?
I did not.
Okay. Now, this videotape is from January 6, 1991.
Question?
Next question.
If so, no foundation.
Let's assume that we've heard testimony that this videotape is from January 6, 1991. At that time and on that date, did this glove come in a double extra large?
No, it did not.
And do you have an opinion as to whether or not the gloves worn by the defendant in this video are Aris leather lights style number 70263?
Based on what I've seen, I would say that this is styles 70263, size extra large brown, knowing that I had measured the defendant's hand.
And how certain are you of that?
I'm 100% certain.
Let me show you some photographs. I believe it's 605, the Rinker photographs. Your list of the Rinker photographs, 605 or 606.
I have 605 as being Mark Kruger. Rankin I have as 606.
We're going to go to 606, Your Honor. May I ask Mr. Rubin to step down, Your Honor?
Yes. Mr. Dart.
First, let me ask you to step to the side of the photograph, if you will, the photo board, no, to this one, between Ms. Clark and the board. Now, do these appear to be photographs also taken from that January 6, 1991 game?
They appear to be.
Okay. And looking at the first photograph of the defendant with the umbrella,
Yes.
do you see water stains on the gloves?
Yes, I do.
Can you see the brochure stitching?
Yes, I can.
Can you see the needle points you described?
I see the image of the needle points.
Is there a blind hem?
Yes, there is.
Is that style number 70263?
Yes, it is.
And would you also take a look at the photographs just to the right of the first one you just looked at?
Yes.
And if you will you turn around, please, and take a look at the photograph Ms. Clark is holding? That would be 606. 606.
Yes.
Are the gloves worn by the defendant in these four photographs the same style as the gloves found at Bundy and
Yes.
Rockingham?
Yes, they are.
One moment, Your Honor. Thank you. You can retake the witness stand. Can I leave the board in the...
Yes.
I'd like to go to the Kansas City Buffalo game, January 94, which is on laser, Your Honor. Go to the Stewart West photos at 12/29/93. Let me show you the photograph shown on the screen here. Those are black gloves, is that correct?
Yes, they are.
Looking at that glove, can you tell us whether or not there are any characteristics that are consistent with an Aris style number 70263?
This is a very clear picture of the brasso stitching on the right-hand forefinger, as well as the three needle points. There's a blind hem. And in addition to that, it confirms that this leather is very lightweight, the way it's actually folded over in that one spot where it's bunched up. You can see that they're very close to each other, so it's a very, very thin glove. within lining.
This is frame number 31175 for the record, Your Honor.
Yes.
And if you'll just step down for a moment. Take a look at the photographs taken by Stuart West on December 25, 1993. Yes.
Yes.
Looking at those photographs, can you tell us whether or not the glove worn by the defendant in those photographs is style number 70263?
Yes, it is.
And your opinion is based on what, sir?
The fact that the three most important elements of the design of the brush fit into 3 points of the blind hand, and those are the 3 elements I can see in this picture.
And while you're here, let me direct your attention to the photographs taken by Michael Romano. There are 2 photographs to the right of the board depicting the defendant wearing black gloves. Is that correct?
That's correct.
You're also on frame 30706, Your Honor.
Yes.
Do you see the 3 needle point that you described earlier
Yes.
in both photographs?
Yes, I do.
And in both photographs, do you see the brochure stitching?
Yes, I do.
Is there a blind hem?
Yes, there is.
Can you see the cashmere lining?
In the blow-up on this photograph on the right, the beige lining of it is cashmere.
Now let me show you the gloves the defendant tried on, the new gloves, People's 401.
Yes.
Is there an heiress tag in those gloves?
Yes, there is.
And how does that tag compare in appearance to the tag that we see on Michael Romano photographs?
Yeah, I'm going to object to that characterization of what that is.
Rephrase the question.
Well, on the Michael Romano photographs, do you see a tag?
Yes, I do.
Can you tell us whether or not that tag is an heiress tag?
I believe it is.
Okay. And what is it about the tag that leads you to believe that it is an heiress tag?
All of the Irish leather gloves that were made in production for many years contained a printed Ross patch, printed label with beige material with burgundy printing, which determined the, it had the size, the country of origin, did not include the style number, and it had the Irish logo with double chevrons, and it was framed in a box in burgundy, just as this is. And this one, says 100% cashmere made in the Philippines, size extra large.
Okay. He's referring to 401, Your Honor, for the record. Does the tag shown in the photographs taken by Mr. Romano, how does the tag in the photograph taken by Mr. Romano compare to the tag on People's 401, the heiress glove that you're holding in your hand?
It has the same characteristics of the beige background. I can see some printing. I can see some burgundy printing, but I can't read it in this photo. But there's definitely something with a burgundy cast in it, which is, this is what it is.
I'm sorry?
It's basically, what you're seeing is this.
Okay. For the record, the witness is holding up 401, Your Honor, to the Romano photograph carrying these tags in each.
Yes, thank you.
Now, when you first came out here to testify, you were made aware that Nicole Brown purchased 2 pairs of 70263?
Yes, I was.
Sustained.
Well, let me show you the receipt, 372B.
Yes, I'm familiar with this.
Okay. By the way, did you have any discussion with Mrs. Brenda Bimich regarding this particular receipt?
Briefly?
You don't work for Bloomingdale, is that right?
No, I do not.
Now, we accounted for 2 pairs of style number 70263.
Objection, vague, argumentative.
Sustain.
Oh, have we accounted for one pair of brown style number 70263 gloves?
Objection, argumentative.
Sustain.
Are the black gloves that you just saw in the Romano and West photographs style number 70263?
Yes, they are.
I'd like to show you a frame from a football game played on January 5, 1992, frame number 25862.
All right, which exhibit is this from?
It is a new exhibit, Your Honor.
Next in order.
Okay, it's part of
614.
okay, it's part of the same disc. Okay,
This doesn't help me.
all right, 614, Your Honor. Is this a frame that you've seen before, sir?
Yes, I have.
Okay. And have you examined it?
Yes, I have.
Have you examined it carefully?
Very.
What characteristics, if any, do you see in that glove that is characteristics that are consistent with style number 70263?
This is the clearest and best shot that I have seen of the Brosser sewing on the fingers, but I can also see the image of the 3 points, but just the two characteristics. But this clearly is that continuous ridge of sewing that is indicative of style 70263.
And to go back to the tag for a moment, you pointed out the tag in the Romano photograph, and you also pointed out the tag on 401, the gloves, the new gloves the defendant tried on here in open court. Is that right?
That's correct.
There's only one tag on a pair of Eris leather lights?
In the left hand.
Show you the left-handed glove. I don't see the evidence tag. The glove recovered at Bundy's. Does it also have an Eris tag
Yes, it does.
in the left glove?
Yes, it does.
And how does that tag compare in appearance to the tag on the Michael Romano photographs?
Same location, same size.
Can you tell us whether or not the glove worn by the defendant in Steel 25862, People 614?
Objection, vague.
Finish the question.
Finish the question. Can you tell us whether or not the glove depicted in People 614 is an Eris light?
The key feature of the sewing on the fingers indicates it is style 70263.
Showing you the glove tried on by the defendant, 401. Both the crime scene glove at Bundy, the glove found at Rockingham, and directing your attention to the glove shown in People 614 here on the screen.
Frame 25862.
Are each of these gloves same style number?
They all appear to be the same.
Are they each Eris gloves?
Yes, they are.
Style number 70263?
Yes.
Size extra large?
All of them.
The two gloves in front of me are marked extra large. They are extra large, and I believe that the gloves in the picture are extra large, knowing the fact that I did measure the defendant's hand.
Let me ask you to step down and take a look at the photographs marked 612. A and B, the photographs taken by Deborah Gadara on December 23, 1993. And that would be a little over 6 months before the murders, is that correct?
Objection.
Sustained.
Are these photographs that you've seen before?
Yes, they are.
You've examined these photographs before?
Yes, they have.
Do you see any characteristics of these particular gloves that help you to determine whether or not the defendant is wearing style number 70263?
On this particular photo, there doesn't seem to be any decorative stitching on the hem or any stitching on the hem. There are 3 needle points. And on the left hand, you see a little bit of the ridge on the tip of the finger, very fine ridge, continuous sewing. There's a slouchiness in the leather, which is characteristic of that particular style. It's not as good a photo as some of the other photos or videos, but there's nothing here that leads me to believe that it would be another style in 70263.
Direct your attention to 612, the first photograph, to your left, as you face the board. This slouchiness, to what do you attribute that to?
Well, I think a lot of it has to do with the way you hold your hand. When you move your fingers back, the glove gets a little slouchy. When you curve your hand, you seem to tighten up in the glove. But basically indicates that the gloves had been moved back and forth, and you're going to get some of that slouchiness because every time you wear a pair of gloves, they're going to stretch a little and compress a little. So when you move your hand back and forth, you're going to get a little bit of that bagginess.
So the more you wear them, the more they stretch.
Objection.
Sustained. Rephrase the question.
Can you tell us whether or not the gloves stretch? That is, the more you wear.
They will stretch somewhat, but these particular gloves do have memory. A lot of it comes back, depends upon how the person holds their hand. But they do have a lot of stretching.
Does it also depend on what the person does while wearing the gloves?
Yes, somewhat.
Objection.
Hold on. That's her stand.
Now, let me ask you to retake the stand. When was it that you were sent copies of some of the videotape and some of the photographs you've seen here in court?
I received the first set of photographs, I believe it was July 3rd.
And when was the first time that you saw the Gadara photographs, 612?
I believe that the Gadara photograph arrived September 5th. They called me to notify me that they were sending another photo to me after I left here on the 31st.
Sustained. Next question.
Okay, so you received the Gadara photograph around September 5, correct?
Yes.
Is there anything about the brown gloves that you've seen the defendant wearing that would suggest to you that they are anything other than 70263?
Question A. Phrase the question.
Are all the characteristics that you've observed in the brown gloves worn by the defendant consistent with style 70263?
Ask and answer.
Hold on.
Yes.
Can I have one moment, Sean?
Sure.
I'm about done.
take our recess at this point. All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 o'clock. Let me see counsel without the court reporter. Mr. Rubin, you can step down, 1 o'clock.
Keep the noise down.
All right, back on the record in the Simpson matter, the defendant's again present before the court with counsel. People are represented. Jury is not present. All right, Mr. Darden, are you ready to conclude your direct examination of Mr. Rubin?
Yes, Your Honor, I am. Thank you.
All right, Deputy McNair, let's have the jurors, please. Record reflect that we've been rejoined by all members of our jury panel. Good afternoon, ladies and gentlemen. All right, Mr. Rubin, would you resume the witness stand, please? All right, let the record reflect that Mr. Richard Rubin is again on the witness stand undergoing direct examination by Mr. Darden. And Mr. Darden, you may conclude with your direct examination.
Thank you, Your Honor, and I will. Good afternoon. Mr. Rubin, I wanted to ask you some questions about the wear and tear, if any, on these particular gloves. If we assume, we'll strike that. Now, there's been testimony in this case that Nicole Brown purchased 2 pairs of gloves on December 18, 1990.
Yes.
Okay. And I believe you offered some testimony with regard to the style numbers Bloomingdale's carried back in December 1990 when you were first here. Is that correct?
Thank you. Yes, I did.
Okay. And they did carry this model, the 70263.
Yes, they did.
We've also shown you today photographs and video of brown gloves worn by the defendant on January 6, 1991, correct?
Correct.
And December 25, 1993.
I don't think it was December 25th.
I'm sorry, December 23rd, 1993.
Correct.
Okay. And that would be the Gavera
Yes.
photos shown here.
Yes, that's correct.
Where would you, we'll strike that, where would you first expect to see wear on those gloves, if any?
Speculation, no foundation.
Foundation.
Well, you told us that you manufactured these gloves?
Yes, I did.
You helped design these gloves?
I designed this particular glove, yes.
You also sold it?
Yes, I did.
You handled the marketing?
Yes, I did.
Did you attempt to assess the life and durability of the glove once it was sold into the general public?
Life expectancy and wear and tear was a major concern of our company because it was our reputation. And in regard to this particular pair of gloves, the wear and tear would show up first in the lining.
You wouldn't expect to see the wear and tear first on the outside leather portion of the glove?
You would not.
And you looked at the lining of the crime scene in Rockingham glove when you were here last, is that right?
I've seen the linings many times.
In fact, I think you removed the lining from those gloves, didn't you?
Yes, I did.
Okay. Did you note any wear or tear or any evidence of any wear or tear on the cashmere linings of the Rockingham and Bundy glove?
In both articles, there actually is no excessive wear and tear whatsoever present.
Okay. And what does that indicate to you in terms of how often those gloves were worn?
They were not worn every day in the winter for year after year after year at all.
And were these gloves sold $55 on sale at Bloomingdale's during December 1990?
The original price was $50.
Sustained.
Well, you sold the gloves to Bloomingdale's, is that right?
Yes, I did.
They were exclusive to Bloomingdale's.
Yes, they were.
And did you discuss with Bloomingdale's the price at which the gloves would be sold?
Sustained. I think we've already had testimony, though, from the people at Bloomingdale's as to the manufacturer's suggested retail price, the sale price.
Thank you, all right. And with regard to the black gloves that you've seen, okay, the Stuart West photographs, the Romano photographs, you were shown photographs taken December 23, 1990, and in January 1994. Is that correct?
I'm not sure of the exact dates of the photographs on the black gloves.
The date indicated 12/25/93 on the West photos,
It is.
and on the Michael Romano photographs, the date indicated to be January 15, 1994.
Yes, it is.
And on the Mark Kruger photograph, the dates indicated there,
Oh,
is that December 29, 1990?
Yes, it is.
What would you expect to see the wear and tear in that particular glove?
No foundation.
I don't really see any.
oh, excuse me. Overruled. You can answer that.
Could he rephrase the question, Your Honor? Could he state the question, please? What was it again?
Where would you first expect to see the wear and tear in the black gloves?
Initially, the wear and tear would show up in the lining.
Now, is there a certain machine that sews this brochure stitch?
It is a Brosser sewing machine that was made by the Singer Sewing Machine Corporation. To the best of my knowledge, the model was 46K30, and it was produced around World War II for the last time. So to my knowledge, there has been no Brosser sewing machine produced in the last 45 to 50 years.
Okay. And you've told us that this particular type of stitching is rare in gloves, men's gloves.
It's very rare.
Okay. And how rare are these machines nowadays?
Overruled.
Currently, I was able to find out that Aris Philippines had 37 machines.
Overruled.
Has 37 machines, of which approximately 20 to 25 of them are operational. And of my personal knowledge, going back to 1990, of the 11,000 employees of Aris Philippines, only 10 people were qualified to sew that stitch on a glove.
Oh,
Thank you. Nothing further.
Mr. Blazer?
Good afternoon, ladies and gentlemen. Mr. Rubin?
Mr. Blazer?
Mr. Rubin, have you tried to be completely impartial in this case?
Absolutely.
You haven't been currying favor with one side or the other?
Absolutely not.
You don't have any agenda here for one side or the other?
I do not.
You haven't tried to shade your opinion in any way to favor one side or the other?
Absolutely not.
Now, on July 3rd, you were sent pictures from, in fact, all the pictures here, you were sent back on July 3rd before the prosecution finished their case, correct?
That is incorrect.
You were sent pictures from Mr. Renken, from Mr. Kruger, Mr. Schott, Mr. West, and Mr. Romano, correct?
I believe that's correct.
Okay. And you were told beforehand that you were going to be getting some pictures that the prosecution wanted you to look at, correct?
Someone left a message in my office that a package was forthcoming, yes.
Now, I'm sorry. Had they shown you a videotape prior to that time?
No, they had not.
Had they told you there were videotapes?
I don't recall the conversation regarding videotapes at that point in time.
And you answered that letter before the defense started calling witnesses, didn't you?
I'm not.
You answered that letter on July 6th, didn't you?
Yes, I did.
Before July 10th, I'm sorry. And you FedExed that letter to the prosecution?
Yes, I did,
FedEx generally takes 1 day.
to the best of my knowledge.
Now, in your letter to the prosecution of July 6th, you told them at that time that the pictures from Renken, Kruger, Schott, West, and Romano, that it was your opinion that those were the Aris Leatherlight style, correct?
I believe I did.
You didn't equivocate on that, did you?
I actually, either in telephone conversation, I'm not 100% knowledgeable of the letter because I haven't seen it, but I did ask them, at least over the phone, that I wanted to see enhanced blow-ups, and I'd like to look at some of these things in the negative or on a small monitor.
Did you indicate in your letter on all 8 photos, none of the detail that can be seen indicates that the gloves could be a style other than 70263?
I did.
You were indicating unequivocally that in your opinion, from those pictures that you had last July, it was an Aris glove, correct?
That's not the case. What I meant by that statement categorically was that I did not see any features in any one of those photos that would indicate that it would be any other style that I had knowledge of. That's what I meant by that statement.
Remember us asking you yesterday what you meant by that statement?
Yes, that's exactly what I said.
You didn't indicate to us that what you meant by that was that it was your opinion back then that from those pictures you could make an identification that those are Aris 70263.
I felt I could, but in context, I wanted to see more detail.
All right. Did you tell us yesterday that you had decided that what you meant by this sentence in here, that you decided back then that your expert opinion was that those were the same style glove?
I was not 100% sure at that point in time.
Did you tell us yesterday that that's what you meant by that sentence?
What?
Sustained. Phrase question.
Did you tell us yesterday that what you meant by that sentence is what it says, that you could, that in your opinion, these were the Aris style gloves?
What I meant,
Excuse me. Oh.
what I meant by that statement categorically was that the features that I could see in the pictures, not one feature would lead me to a non-70263 Aris Light style. That's what I meant by the statement.
By the statement you made yesterday to us?
Yes.
Now, when you wrote that letter to the prosecution back on July 6th, did you include as part of that letter
Oh.
If you should have any questions, please feel free to contact me at any time. Please thank everyone for their hospitality during my visit. Maybe I can make it to the victory party! Exclamation point, exclamation point.
Correct.
Now, is this party being planned before the defense started?
This statement was made in jest, no differently than on the first day that I testified here. As I walked out, I wished Mr. Simpson and the crowd the best of luck. It meant nothing.
Had the victory party been planned before the defense started?
Absolutely not.
Were you expecting an invitation to it?
No, I was never expecting an invitation.
Do you consider yourself a member of the prosecution team at that point?
No, I do not.
Now, did you also indicate in that letter, in a PS, at your convenience, could you obtain business cards from all the members of your staff, as I want to make one, only one, piece for my office as memorabilia of my experience? Please include Mr. Harjman and Ms. Clark.
Yes, I did.
Now, you were planning to construct some sort of memorabilia for your office, for your customers to see?
I have probably 300 envelopes that have been sent to me around the country regarding this testimony. Most of them I haven't even opened yet, and I was planning on actually taking one article, putting some business cards in it, and framing it and putting it in my office as a remembrance of this experience. That's all it was.
Cards from the prosecution?
Yes, yes.
Now, Mr. Rubin, you were with Eris from what year to what year?
I started selling Aris gloves in 1976. I left in 1990.
So that was 14 years?
A little bit longer.
And you're primarily in sales and marketing, correct?
No, I was actually part of the management team. I ran the men's glove division, the wholesale division, and had some other responsibilities.
Now, you said you actually manufactured the gloves yourself, I think, on direct. Did you mean that?
Not physically.
Were you part of the manufacturing process where you'd get in there and see and work the machinery and see how it worked?
I spent approximately 300 days in the Philippines during my career there.
Now, you have been completely out of the glove business since the middle of 1990, haven't you?
That's correct.
And would you agree that your primary experience with Eris was in sales and marketing?
That was the primary function of everybody at Aris Isotoner.
You weren't there running the plant on a day-to-day business, right?
I was not responsible for the day-to-day operations of Aris Philippines.
Now, have you ever been asked to testify as an expert in any other case?
Never.
You've never been disqualified as an expert?
Never.
Now, would you agree that there are many, many people in the glove business that have far more experience with gloves than you?
I would not agree with that.
Oh, well. You know Mr. Richard Zuckerwar?
Yes, I do. I know him personally.
You think you have more experience than him?
In regard to men's gloves?
In regard to gloves?
I would say that in the overall glove industry, Mr. Zuckerward is one of maybe 4 or 5 people that has tremendous experience. As far as men's gloves in sales, marketing, design, and production, I feel that my experience regarding Aris product is very excessive as far as his knowledge, and in the overall production, sales, and marketing of men's gloves, I feel that my knowledge is excessive of his.
Gloves in general?
No, men's gloves.
How many years' experience does Mr. Zuckerwar have? Do you know?
Probably,
oh,
I don't want to date the gentleman, but I would say that 35 years experience.
And by the way, do you have any other glove experience other than...
Counsel.
I'm sorry.
Spell his name for the record for us, please.
Zuckerwar,
Thank you.
I believe. Do you know Mr. Joe Alusi?
I do not.
You know who he is?
I do not.
Now, do you have any other glove experience other than the 14 years with Eris?
Can you be more specific regarding glove experience, as far as from a manufacturing point confined to Aris or to other outside facilities? Or
Right.
what do you mean by this?
Let me rephrase that. Do you have any experience at all with respect to other facilities besides Eris? Have you ever worked for a glove company other than Eris?
No, but I have worked with many outside sources of glove manufacturing outside of the controlled and owned operations of Aris.
Now, when you say work with, you mean attend conventions with and talk in terms of sales, that sort of thing?
No, I mean actually going to their factories, developing product, planning production, designing new styles, taking customers to certain facilities, very wide scope range.
What other companies have you designed styles of gloves for?
Well, specifically in the casual end of the business and some dress styles, a company called Palace Industries, which did have operations in Thailand, still does, has operations in China, now Vietnam, and also Taiwan. And then I also had experience in working with the Hungarian government in approximately 7 different factories throughout Hungary. I've worked in Czechoslovakia. I've also bought and visited factories in Taiwan and Korea, and actually was part of the team that set up a factory in India.
Now, this is part of your employment with Aris, correct?
Yes.
It's not separate employment.
No.
You've never worked for another glove company, have you?
No, I have not.
Now, one of the parts of your testimony here is that the Brosser stitching that you've described that Aris uses is unique, is the word that you used. Did you mean unique to mean it's only one of a kind?
It is not one of a kind. These machines were produced from approximately the early 1900s up until World War II, and I'm sure that their machines exist all over the country. I just don't know where.
How many gloves are manufactured in the world in a year, roughly?
In today's times,
Yes.
I really don't have any idea.
How about when you were in the business?
On a worldwide basis, I really don't know. I did know what we manufactured, and we had estimates of what other manufacturers in the United States sold.
Give us your best estimate.
In men's gloves, my best estimate in 1990 was there were approximately 6.5 to 7 million pair out there.
And that's not counting any foreign producers.
Well, excuse me. All of these gloves were produced outside the United States.
Okay.
But they were for sale here in the United States.
Okay. How about gloves for sale throughout the world? Do you have any idea how much more that would be? Oh.
I really have no way of judging that number.
Presumably a lot more than the 6.5 or 7 million.
I would assume so.
Now, would you agree that brown is probably the most common color for
No.
gloves, men's gloves?
No.
What's the most common color?
Black.
Now, would you agree that the vast majority of men's gloves have 3 lines on the back? They're called backing, aren't they?
I've never heard that phrase.
Silking,
That's better.
okay? Vast majority of men's gloves have those 3 lines on the back, don't they?
3 decorative points of some configuration, yes.
Now, you indicated that one of the reasons that Aris used that particular stitch was to separate those Aris gloves from the run-of-the-mill gloves that you might find in Target or Kmart or other large retail outlets. Is that fair?
That really wasn't the basis for it at all.
Well, I think you said that it was to distinguish that glove from the less expensive gloves.
In general, the combination of the sewing machine used, the point configuration, the blind hem, and the weight of the leather and the weight of the lining was what was put together as a package to create an exclusive product. But it wasn't just the one element.
It's for a high-end market, wasn't it?
The $50 and over market is very, very small.
It was a high-end market, wasn't
Yes.
it? Now, there are a lot of exclusive stores throughout the world, in New York, all over the place, that sell high-end leather goods, like gloves, correct?
I don't know how many of the stores would carry high-end leather goods, including gloves.
Okay, so you don't have any information on that.
No, I do not.
There are other more expensive high-end gloves out there besides Aris, correct?
Absolutely.
Now, you made some effort to try and find out what other manufacturers in the world might have used Brosser stitching and produced gloves without stitching, correct?
Yes, I did.
And how many different companies did you check with?
I only checked with 2.
There are a lot more companies than that in the world, aren't there?
In the world, yes.
Now, did you ever check with any glove companies in Europe or Italy?
No, I did not.
In Europe?
No, I did not.
Other glove companies other than the 2 that you've told us about?
No, I did not.
And what are those 2 companies?
Founds Gloves, Fownes, and Mr. Zuckerwar's company, Grando Gloves.
And Grando does produce a glove with Brosser stitching, doesn't it?
They told me that they had produced a glove with process stitching a couple of years ago in small quantity.
And they had it in stock.
They didn't mention that to me.
Okay. So the only two companies that you checked with, one of them does this stitch, correct?
1 out of 2.
Now, do you have any idea how many other glove manufacturers there are in the world?
I have no idea.
Would you agree that there's over 100 other glove manufacturers, various parts in the world? I'm sorry, go ahead.
When you define glove manufacturer as anybody who is manufacturing quantity and distributing it on their own, a person who has 6 employees in a small shop technically is a glove manufacturer. So I would say in places like Italy, Hungary, and certain other Eastern European countries, there could be hundreds of manufacturers. They would relatively be quite small as far as production.
How many of those have Brosser machines?
I have no idea.
Now, you know that you've seen this stitch on an Italian glove some years ago, didn't you?
Yes, I did.
From a small company?
I don't know what company it was from.
Have you made any effort to contact Singer to find out how many other machines there are throughout the world?
No, I have not.
Are there any other machines that can make a stitch that looks like this stitch?
This stitch is a very fine whip stitch, and the machine that I am familiar with that does make a stitch that's similar is called an Osan sewing machine, and the one I'm familiar with was made by a company called Treasure.
And can that make a stitch that looks like this?
Similar, but not the same.
Different in what way?
The Osan sewing machine normally runs at about 10 to 12 stitches per inch. The Brosser sewing machine runs at twice that, and the difference is in the bite. It's a whip stitch, both of these are whip stitch type machines. In the bite, you get a high-low effect on the Osan stitching machine, and you get a larger seam than you would on a continuous seam and fine seam on the Brosser. But to a layman, the stitches would appear to be somewhat similar.
Can the Osan machine do a 22 stitch per inch stitch?
I'm not a technician. I am not sure if it's capable of making a stitch that tight or not. I've never seen Aris production or some other people's production with Osan do over 12 stitches to the inch on an Osan machine.
Did you ever make any effort to find out? And incidentally, Osan machines are fairly common, aren't they?
Within Aris, the largest amount of gloves that were out on the marketplace were Osan.
Other companies have Osan stitching machines, don't they?
I believe they do.
It's a common machine, isn't it?
It's a common machine readily available.
You familiar with the Bonus Golden Series Never Stop machines?
I've heard the name Bonus, but I'm not familiar with the machine.
Let me show you a flyer for that machine.
Objection. Familiar with it.
I'm sorry?
Not objection. Anything relying on it's not familiar with it.
Oh,
I see the flyer.
oh.
You take a look at that and tell me if you're familiar with that machine.
Oral. The question is he familiar with the machine?
Since I never really looked at the numbers on the machines that were at Aris Philippines for style, I've seen similar machines to this with the wheel. I'm very familiar with that.
Okay.
It's very common. But I don't know for a fact that it was a Bonus BG12 machine.
All right, so the machines you've seen, they can do 25 stitches an inch, can't they?
I've never seen them do 25 stitches to the inch.
Can they do 25 stitches an inch?
I could not state that to this court if I had not done it myself.
Can that machine do 25 stitches an inch?
According to the flyer, this...
Hold on, it says sustain.
You know where I have that marked, please?
Yes. Mrs. Robertson? 1372.
So I take it then, other than calling two companies and asking them specifically about the Brosser machine, you've made no effort to find out what kind of other machines might make a stitch that fine?
I have not.
Now, the two companies that you contacted, did you just ask them about the Brosser stitching?
Well, in regard to Founds, I asked them if they had any of the equipment. They told me no, and that was pretty much the end of the conversation. And I do have friends that work there, so we may have discussed other things that I'm not aware of. In regard to my conversation with Mr. Zuckerwar, a technician within their company was in the room and mentioned the style number or the...
Objection, non-responsive.
Ask your next question.
I don't remember what I spoke with them about.
You didn't ask anybody about the 3 lines, the silking on the back, did you? In terms of how other people may or may not use that.
I did not discuss anything other than the Brosser.
So you've made no effort to find out how common or rare the silking is, and that's the 3 points on the back.
I think I earlier stated that it's very common.
Now, you're asked some questions about glove wear, and I think you indicated that they wear out from the inside first.
This particular style.
Okay. And is that because of the cashmere lining?
That's because the cashmere lining was underweight by design, and cashmere is a little bit more fragile than most materials that we use for linings, and only using 1 thread of cashmere versus 2, we were concerned about wear and tear on the lining, and that's why in this particular style, the wear and tear would first show up on the lining.
Now, you live in New Jersey, I believe, don't you?
Yes.
Is that very close to New York?
Yes.
Gets real cold and wet in New York in the winter, doesn't it?
Unfortunately, in the last couple of years, it hasn't, but on occasion it does.
Snows there, rains there.
On occasion.
People wear gloves there, don't they?
Yes, they do.
It's a much more intemperate climate than Southern California, correct?
Yes.
Would you agree that people that live in New York in the winter wear gloves more often than people in California?
I would agree with you.
The more you wear gloves, the more you would expect to have indications of wear, correct?
That's correct.
On the inside, on the lining.
On this particular style.
Now, you indicated to me yesterday, did you not, that you were surprised at how little wear there was on the inside of the Bundy and Rockingham gloves?
Yes, I was, considering the condition of the gloves on the outside.
And is it not your opinion, or isn't it your opinion, that is probably because whoever wore those gloves on a regular basis had relatively small hands?
Objection, no foundation.
Oh, that's not exactly what I said. What I said to you out in the hallway was that the person that wore the gloves either wore them on brief periods of time or they fit that person very comfortably. They were not the wrong size.
You didn't make a comment to me about someone that didn't have large hands, wore those gloves because of the almost no wear on the lining?
No, I stated to you that the person that wore these gloves fit into these gloves without any strain on the lining, which would cause excessive wear. I spoke to you more about what would cause excessive wear versus what would cause less wear.
What did you tell me about large hands?
Regarding what? Regarding what?
Regarding the lack of wear in the lining of the evidence gloves and your statement that that's an indication, one of the inferences you can draw from that is that they were owned by somebody with smaller hands. It didn't stretch them out.
The person that I stated to you, that the person that wore the gloves did not have larger hands than the glove size itself.
All right, was the point you were trying to make that a person with larger hands is going to fill out the gloves and there's going to be more wear on the lining than someone whose hands are smaller?
Yes.
Now, there were indications of wear on the outside of the gloves, correct?
On the right hand, very much so. On the left hand, some.
And you testified to that before. You recall that?
Yes, I did.
So your experience is that gloves should wear out from the inside out, correct?
There's no way to determine the exact time frame of how long a pair of gloves would last, but it's a personal thing, the way a person uses the gloves, the way the gloves fit. You could wear them 1 or 2 times, get caught in a snowstorm and change a tire, and the gloves are pretty messed up. There's no way of telling.
You're speculating now, aren't you?
Yes.
Isn't it fair that one reasonable inference from the fact that these gloves are more worn on the outside than the inside is that a person who owned them had small hands that didn't fill them out and cause the inside to wear?
I couldn't. I couldn't confirm that statement.
You can't make that inference at all from what you told us?
No, I can't.
Mr. Rubin, when did you get here, by the way? Last night or 2 nights ago?
I arrived here Sunday at noon.
And from the time that you arrived here until you were in court yesterday, some of that time was spent with prosecutors looking at pictures and videos again?
Yes.
And while you were in the process of doing that, you noticed on one picture that there appeared to be a defect on one of the brown gloves in the pictures, didn't you?
That's not correct.
Did you not see what you thought might be a defect?
Now, what I stated to Mr. Darden was thought I saw a shadow, that I would like to look at the gloves in person to see if I could detect a defect.
Right. You saw a shadow that you thought might be a defect, correct?
Not a defect, just a marking.
Well, you told him it might be a defect, right?
I think that's his terminology, not mine.
Did you ever use the word defect?
I'm not sure.
You might have, right?
I could have.
That's what you came down here to look at the gloves for, to see if you could find a defect, correct?
I wanted to see if there was any marking in a specific part of the glove that corresponded to a shadow on one of the videos. I wasn't sure whether it was lighting, whether it was a mark, just wanted to look at it.
To see if there was a defect on the evidence gloves that corresponded to what you saw in the picture.
Correct.
Wasn't there, was it? There was no such defect on the evidence gloves, was there?
I didn't see anything that I could definitely re-identify in any photo.
Now, which picture were you looking at where you thought you saw shadow, defect, or whatever you want to call it?
I don't think that picture was actually used here. It was one of the photos that was thrown out. It was a right hand.
Are you referring to one of the gloves the prosecution decided not to use?
I believe that in an effort to save time, they just started to arbitrarily knock out different photographers and photos.
So the one where you thought you saw a defect, they didn't show to the jury?
Sustained. Sustained.
All right. Now, you've indicated from many of these pictures that it's your opinion that you can identify the 3 points on the back as being the same type of 3 points that is on the ARIS 70263, correct?
That's correct.
Now, you've indicated that's a common backing, correct?
It's very common, yes.
Are there other backings that can be mistaken for that?
Overruled.
I'm not quite clear as to what you mean by that.
Well, let me show you a sheet.
Or will,
Drew, but take a look at that.
do you have some foundational questions on this?
Yes. You recognize that as a document that shows various different kinds of stitching that can be used on gloves.
Yes, I do.
Are you familiar with all of those?
I recognize many of them.
You're not going to have that marked and put on the Elmo, please?
Need a little more foundation than that.
Are all those, there's different kinds of backing stitching, correct? The 3 points we're talking about?
Yes, these are different configurations of what I would call 3 decorative points on the back of the glove.
And you recognize all of those, do you not?
I actually don't recognize all of these.
Okay. So there may be some out there that even though you have a lot of experience with gloves that you're not familiar with.
Well, there's many that are out there, but not necessarily used.
My question was,
Could be.
that some out there that you don't know.
Could be.
And the top part of that diagram indicates different kinds of stitching for fingers, right?
They do, but they're poorly represented in these sketches.
Okay, but you recognize each one of those? I mean, they're described underneath them, are they not?
Yes,
They're all stitches you're familiar with?
I'm familiar with all these.
And may I have that marked and put on the Elmo, please?
That's 1373. Mrs. Robertson, 1373.
Can you see those sample stitching? Because those are the silkings that we've been talking about.
Right.
The 3 points on the back. Which of those, if it's up there, is on the ERA 70263?
These sketches are actually so poor and not really indicative of what they say compared to what's on a glove. If you want me to pull out a glove to show you, like as an example, the bottom right, it says 4 needle stitching. If you want me to pull out a glove and show you what 4 needle stitching looks like, it doesn't look like this. I can't tell. I can't tell from this.
You can't tell from those stitches which one is on the Eris?
The way the draw machine works, there are 5 positions, there are 5 needles. You can configure them to do things in different formats. What's on the back of 70263 is needle number 1, 2, and 3 with thread, without cord. I don't know where it is on here. It's a blur.
Now, if I put this one, the on the output.
Yes.
Mr. Rubin, you recall identifying this picture, this is the Gadara picture,
Yes.
and identifying the backing on the glove?
Yes, I did.
Can we back it out, get a little clearer, please? Your testimony that you can tell that backing was made with a particular configuration of 3 needles?
It appears to have a ridge in the middle. The reason I came up with that is it appears to have a ridge or a high-low in the middle of each point, and that's what gave me indication that it was 3 needles. There has to be a needle on the right, a needle on the left, and because it has a ridge look, I think there's a needle in the middle, and that's what gave me that conclusion.
You see that as 2 lower lines and a ridge in the middle?
Objection, Your Honor. You didn't look at it in the Alamo.
Well, is there...
You have to remember, I've had the opportunity to look under this photo with a magnifying glass.
Mr. Rubin, we're talking about these pictures that the prosecution offered. Are you telling me from that picture you can see 3 lines of stitching?
Objection, Your Honor.
From this picture, I can't see anything.
How about from the picture itself?
From this picture, I see a ridge in the middle of the point, which indicates the third needle.
You're saying that in that picture, or are you saying that you can identify for each of those 3 lines in the backing that for each line has 3 needle stitches in it?
Left, right, and center, yes.
Now, is that something you can see in that picture?
In my opinion, I can see it.
Do you accept how other experts might differ with that?
Sustained.
Now, in one of these pictures, in the Renkin pictures from '91, you identified water spots on the gloves?
That's correct.
There are no corresponding water spots on the evidence gloves that correspond to the water spots on those gloves, correct?
I'd have to relook at it again, but I don't think that I could even make any judgment regarding to those particular water spots as to how they relate to a glove today.
Well, all right. I asked you yesterday, did I not, that if you got water spots on a glove like that, they might stay there, right?
For a brief period of time.
Did you say brief period of time?
Yes, I said to you that as the gloves were worn again and stretched out, they would dissipate.
You didn't tell me that sometimes they would stay?
To refresh your memory, Mr. Blazier, I also pointed out that if someone with these Aris Lights gloves, which were truly naked leather, were to wipe their brow and get oil on their finger, the oil would stay on the glove for a brief period of time. But gradually, as the person wore the gloves or moved their hands back and forth, the oil would dissipate.
You didn't tell me that water spots like that, you told me that they might dissipate, but they also might stay there, didn't you?
I don't remember saying that.
Now, could we have frame 4748? I'm sorry. I think I may have given you the wrong number. 4582, I'm sorry.
Mr. Harris, do you need Mr. Fairlow's assistance on finding that?
Well, they're not in any order.
Mr. Ormond, let's take this down till we find the right frame. Thank you.
Yes. All right. Remember looking at this frame before, Mr. Rubin?
Yes, I do.
Now, I believe on your direct testimony, you testified that from this picture, you can identify the Brosser stitching on the fingers. Am I correct in that?
I don't believe I would have used this one for the Brosser stitching.
Okay. But you would use this one for the 3 lines on the back?
I believe this one was used for the palm vent on the left hand.
Okay.
Was the primary purpose.
Now, would you agree that the picture on the monitor is a lot better than the big screen?
Surely better from here, but not as good as the monitor in the back.
Do you see, looking at the monitor, what appears to be a bulge in the palm of Mr. Simpson's left hand under the glove?
I don't detect a bulge.
You cannot see a raised area, what appears to be a raised area right in the palm between the thumb and the fingers.
There's a shadowy effect. It could be slightly raised. I don't know. I really don't know what it means.
Do you know what a heat pack is?
Yes, I'm very familiar with it.
And people use heat packs to put in the palms of their gloves to keep their hands warm, don't they?
I'm familiar with it.
And that's going to cause a glove to stretch, isn't it?
It could. I'm not familiar with what size heat pack we're talking about.
Okay. You can take that down, please. I take it, Mr. Rubin, you would agree that you can exclude the gloves in the West pictures as being the evidence gloves in this case.
Due to the color, yes.
And you can exclude the Romano gloves, correct?
They appear to be black also.
And you can exclude the Kruger pictures, can you not?
Same thing, yes.
Now, I think your testimony was that you can read writing on whatever this is in the photograph?
You can answer the question.
I clearly stated that I could not read the writing on that tag.
Right. But you can see printing on it?
I can see that there is something on it. It appears to be printing. The tag, what I stated is in the shape of the Aris Ross Patch label tag. It appears to be beige in color. It appears to have some kind of burgundy printing on it, which is the same as what was used on all Aris tags.
Now, looking at the Gadara picture again, can you see it from there? You indicated on direct, did you not, that you thought you could identify the Brosser stitching on the fingers in that picture, did you not?
On the left hand, on the top ridge of the finger is a very fine ridge, and that would be the only spot that I could detect it from that glove.
Can you come and show me where you're pointing, where you're indicating?
Is that the index finger?
Forefinger.
Forefinger?
Do we have one of your arrows or? May I put a stick on there? I'll put it right above here. You're talking about the first finger, where you see a ridge that you can identify as the Brosser stitch?
At the end of the finger, there's a very fine ridge, fine line, which appears to be similar to a Brosser stitch.
Well,
And that's why I'm saying it's a Brosser stitch.
okay, so from my arrow, we're actually looking at the end of the finger itself?
No,
I would put the arrow over here with this edge,
But I mean, yeah, the end of the finger.
the end of the finger.
Okay. And you can see a ridge there that enables you to identify that that's 22 stitches per inch.
I cannot see 22 stitches in that one specific spot, no.
But you've identified that as the Brosser stitch, have you not?
It is similar to what a Brosser stitch looks like, yes.
Now, you indicated before that you were able, in your mind, you were able to make a positive identification of that style glove from that picture alone, did you not?
I didn't say that. What I said was the elements that I could see were part of the elements that make up style 70263. And once again, there are no elements that lead me anywhere else.
Is it your testimony that that a Brosser stitch is the only stitch that would look like that in that picture, in the Gadara picture?
Any other whip stitch would look similar, but to someone like myself or someone who made a lot of Brosser sewn gloves or was very cognizant of what a Brosser sewn stitch looked like, it would look slightly different.
Is it accurate that you cannot offer any opinion at all as to the shades of the colors of the gloves in the pictures, the brown gloves, vis-a-vis the evidence gloves?
I can make no attempt whatsoever to determine the photographs as far as colorations due to the fact that in my own experience in making packaging as well as all the advertising that we did with various stores that we never really were able to get the color of the gloves correctly in print, packaging, etc. I wouldn't make any conclusion regarding color in these photos.
Now, in this particular style, Eris actually had two different kinds of brown, correct?
That's correct.
And one was called a brown, the other was called a mink?
That's correct.
Were there any other terms used for those?
Mink or medium brown.
What colors are the evidence gloves?
Brown.
As opposed to medium brown?
Or mink, yes.
And how about did you see any pictures? Well, let me ask you this. Can you tell whether the pictures that you saw, that you testified about, are brown or mink?
They're all within the brown family, but no two pictures are alike from any of the photographers.
So from the brown pictures in the photographs, you can't say that they are the same shade or necessarily the same color as the Evans gloves. Is that correct?
To my best recollection, the color mink was so reddish and lighter in color that it would not be, in any of the photos, would they be mink. These photos all reflect brown gloves that I've been shown.
Okay, so none of the photos that you've seen, in your opinion, could be mink.
That's correct.
You remember when you gave a statement to the prosecutors on August 29th?
Over the phone?
Yeah.
That's correct.
Did you know that was being taped?
Yes.
Did you know that they made a transcript of it?
Yes.
Have you seen that transcript?
I have not seen the transcript.
Do you remember when they were asking you that you had one of the Renkin pictures, that's the umbrella pictures?
Yeah.
Brown glove?
Right.
They asked you what color it was? Remember what you said?
That color is the closest to mink of what mink would look like.
Do you remember what you said?
I don't remember 100%.
Do you remember saying, I am not quite sure whether they are really what was called mink or dark brown, but they are definitely a shade of brown?
I'll stand by that.
So when you were looking at these pictures on August 31st, you weren't sure whether they were mink or brown, were you?
Objection. Picture.
The Rankin pictures.
Rephrase the question.
When you were looking at the Rankin pictures, you had them on your end of the phone, you were talking to the prosecution on their end of the phone, you told them you couldn't tell whether that was brown or mink, correct?
That's what I said.
Now you're coming here in your testimony, you're now saying can't be mink. Is that right?
Well, the reason I'm saying that is because I actually called the photographer myself to ask him about the coloration, and he more or less led me toward the indication that his color could be slightly off.
You thought they might have been mink when you saw them before. The same picture, isn't it?
Could be.
It is the same picture, isn't it?
I believe it's the same. Or a copy.
You testified on direct here today that, in your opinion, the gloves in these pictures are a snug fit on Mr. Simpson?
That's correct.
Let me ask you to look again at the Gadara picture. Would you agree that the leather seems to be bunched up around the fingers?
On the right hand in that particular picture, his hand is arched slightly backward, and that's the effect you would get on a leather glove. On the left hand, it appears to be more like a normal snug fit.
Would you agree that between the Gadara picture and the Renkin picture 3 years earlier, the gloves appear to be bigger in the Gadara picture on Mr. Simpson's hands?
I think I would be speculating.
You're not willing to make any kind of assessment for looking at the photographs on that point?
It appears that in the Rankin picture, Mr. Simpson has his hand a little farther around the microphone. His knuckles are a little bit more to the left of the photos. It would be difficult to say that I could tell the difference between the exact fit between the two photos.
Isn't it your opinion that the gloves in the pictures that you've been shown in this case are either a regular extra large that fit Mr. Simpson or an oversized extra large?
That's correct.
So from the pictures, they appear to be possibly too big for him.
Yes.
There are no pictures where the gloves appear to be too small for him. Would you agree with that?
The only thing that you see in the pictures regarding small is on the shortness where he wears the gloves, but I don't see anything in the finger area that indicates they're too small or around the back of the palm.
Have the Bloomingdale's receipt. Do you still have it?
All right, Mr. Glazier, what exhibit is that?
This is 372B. What? Actually, let me use 372. Trying to figure out which one's better. Let me try 372B.
$230.
Okay. Now, Mr. Rubin, you've seen this receipt before, have you not?
Yes, I have.
And can you tell from that receipt, let's assume they were gloves, what color they are?
No, I cannot.
Can you tell what size they are?
No, I cannot.
There were, I think you testified, 1,000 dozen or 12,000 pairs of gloves that were ordered by Bloomingdale for this particular season, correct?
That's correct.
All that had the same style number?
That's correct.
And you had been producing those gloves with those same characteristics for 10 years?
Not 10 years.
From 1982, I'm sorry, as of 90, it had been 8 years, correct?
Yes.
And then they produced them for several years after that.
I believe about a year and a half.
Now, I think you indicated when you testified before that they started slow and then increased to 1,000 dozen a year for a period of time. Is it fair to say that a rough estimate of the number of these gloves sold to Bloomingdale's during that period of time? 40, 50,000 pair?
No, no. I would
30,
say, if I had to speculate, that the quantity was more in the range of around 2,500 dozen for the 8-year period, with the bulk of it being in the last two.
2,500 dozen is
30,000 pair.
30,000 pair. And 10,000 pair, 12,000 pair in the last year?
That was what was originally contracted for. I'm not sure if they took them all in for sale.
So are we talking 40, 50,000 pair, maybe?
Overall,
I think it's closer to 30, 35,000 pair totally from the time they started buying them until the time I left in 1990.
And how many different colors are there?
I believe we made 5.
And how many different sizes?
4.
So would it be fair to say that there were 20 different combinations of that style number that you could get?
There were 20 SKUs.
Okay, so 20 different possibilities that someone could purchase if they bought these gloves.
Size and color.
Only one of which would be extra large brown.
That's correct.
The other 19 would be something different than the evidence gloves, correct?
That's correct.
And you had no way of knowing whether these are receipts for that 1 out of 20 or something in the 19 out of 20, correct?
I do not.
Now, this receipt doesn't even have the style number, 70263, does it?
No, it does not.
So if you accept that the receipt is accurate, these aren't for Aris Isotone or leather lights, are they?
I think that this has been covered in previous testimony
I'll give you a chance to explain, but the question is, if you look at the receipt and look at the numbers, that's something other than Aris leather lights, correct?
overall. Oh, the jury sat through this.
That particular style.
Hold on. Ask another question.
You can't tell these are Aris leather lights from this receipt, can you?
I actually can, but no one else except the buyer and myself could. Because the receipt states the manufacturer, the fact that it's leather, and the price. And the only thing sold at Bloomingdale's that year at that price happened to be the Aris Light style.
How do you know that?
Upon review with the actual buyer of all the styles that were sold to Bloomingdale's by Aris that year, all the gloves retailed at different price points.
Did you hear Ms. Bemich's testimony about whether there were other gloves on sale for that price?
Yes. After she testified, though.
Would you agree that she would have more information about that than you would?
Not necessarily in regard, no, I would not.
In order to assume that that receipt is for Aris leather lights, you have to assume that some mistake was made, correct?
That's correct.
And you have to assume that what should have been on there was something other than what was put on there.
That's correct.
You cannot say, can you, Mr. Rubin, that whatever this receipt is for is the evidence gloves in this case, correct?
No, I cannot.
You cannot say that whatever is in that receipt is in any of these pictures, can you?
No, I cannot.
You have no information about the habits of Nicole Brown Simpson with respect to buying gloves for other people, do you?
Absolutely not.
You cannot say, can you, Mr. Rubin, that the gloves in the pictures that you've seen are pictures of the gloves in evidence, can you?
I can only state that they are the same style and color. I cannot state that they are the same pair.
Now, I believe you identified the lining in the Romano gloves. I'm sorry?
Romano photos.
Romano photo. You've identified that lining as cashmere.
Yes, I did.
Doesn't 100% wool look very similar to that?
No, it doesn't.
How about a combination of wool and cashmere?
It would look slightly lighter.
Slightly lighter in color?
Yes.
So you're stating unequivocally this is cashmere because of the lighting in this photograph?
It appears to be a darker shade of brown than I'm used to seeing in a combination wool and cashmere blend, and for sure it is not a wool blend.
So now you're giving us an opinion based on the shades in a photograph.
I'm only comparing the shade to the shell of the glove. If we're going on the basis that the glove is black, I'm comparing the shading of the lining to the glove.
Could it be a synthetic acrylic?
I have not seen acrylic that looks like that, but anything is possible.
You have made no effort other than contacting 2 glove companies to find out if there are other gloves out there that have the same characteristics as these Eris leather lights, have you?
Oral.
I have not contacted, I don't know, let me just say this, I do not know of any other people to call, other than the 2 largest competitors to Eris.
You don't know how to find all of these 100 or so other glove companies around the world?
If you want to pay me to do that, I'll be glad to do it.
You know where they are, don't you, Mr. Rubin?
I really do not know where they are. I would go to Milan, I would go to Naples, and I would start to find out where all these companies are, but I'm not going to do that on my own.
And you made no effort to do that, did you?
No, I did not.
No further questions.
Thank you. I put 372A on the Alamo gun. Can you zoom back? Let's focus on the right-hand side of the, looking at your monitor, sir, do you see where it indicates muffler? Indicates that a muffler was purchased? At Bloomingdale's on December 18, 1990?
Yes.
At the same time that Nicole Brown purchased 2 pairs of gloves?
Yes.
But I'm going to check in this case. I don't see muffler on it.
Yes,
All the way
it's
to
on
the right, MUFF.
It's on there. Hold on. There was testimony to that. Next question.
Okay, you understand that as an exhibit in this case?
Yes.
Okay. Take that down, please. Let's go to frame, hold up. Hold up. Let me ask you to look at that photograph.
Yes.
You understand this is a photograph from January 6th or 5th, 1992?
It's a video.
Right, has frame number 25862.
Is the defendant wearing a muffler in this photograph?
Yes, he is.
That's the thing around his neck?
Yes, it is.
Does it appear to be brown?
Yes, it is.
And the gloves he's wearing, do they appear to be brown?
Yes, they appear to be.
You don't know whether or not Nicole Brown purchased the defendant a muffler and 2 pairs of gloves on December 18, 1990 at Bloomingdale's, do you?
Sustained.
When you first saw the photographs that you were shown, and those photographs that were sent to you, you looked at those photographs under a magnifying glass, is that correct?
Yes, I did.
You wanted to be certain of your opinion?
Objection, please.
Sustained. Rephrase the question.
Did you want to be sure that you were correct when you gave an opinion?
Yes, I did.
And toward that end, you called a couple of manufacturers, glove manufacturers?
Yes, I did.
You contacted one of the photographers, Mr. Rankin?
Yes, I did.
And why did you contact Mr. Rankin?
I basically just wanted to find out how accurate his color was, if it could vary, because the gloves were like a medium brown. They weren't as light as what mink was, but then again, if it was really mink in the picture and his color was dark, they could have been mink. But basically, he indicated that he could be slightly off, so I just ignored it, plus or minus.
And this is information you wanted to have so that you can make sure that you provided this jury the most accurate testimony you could. Okay. Were you interested in providing this jury with the most accurate testimony that you could?
Absolutely.
And the most honest testimony that you could?
Yeah, yes.
Would you agree that the best test to determine whether or not gloves in the photograph are mink or brown is to have the jury take a look at those photographs, compare them to the crime scene gloves and the new gloves tried on by the defendant?
Objection, no foundation.
At this point in time, the crime scene gloves are almost unrecognizable as far as color, size, texture. It would be very difficult to compare them. However, newer gloves or less used gloves, I think it would be important that the jury see the stitching up close on the gloves.
Let me show you what has been marked 401. One of the new gloves the defendant tried on. What color is that glove?
Brown.
Can you have the jury take a look at 401 as well as one of the Rankin photographs?
Which Rankin photograph?
Which one would you prefer? This would be 606B.
All right, and you want the jury to look at the photograph and compare the brown glove?
Yes,
401.
yes.
All right, hand it to juror number one, please.
And before I do that, the crime scene gloves, do they appear to be brown also?
Yes, they are.
All right, and after we complete the view and examination by the jury, we'll take a brief recess. Mr. Dark.
Sorry.
As soon as the jury completes their examination comparison of the photograph in 401, we'll take our mid-afternoon recess. All right, Mr. Darden, would you collect those items from Deputy Long, please? No, I was just asking you to collect the items from Deputy Long. All right. Ladies and gentlemen, we're going to take our mid-afternoon recess. Remember all my admonitions to you. Mr. Rubin, you may step down. You're ordered to come back in 15 minutes.
We're talking about 3 gloves that are
All right.
very, very similar.
The exhibits shown to them, no, and they further testimony out of check to further demonstration.
Well, the issue of color has clearly been brought up, though. All right, let's have the jurors, Deputy McNair. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Mr. Richard Rubin is again on the witness stand undergoing a redirect examination by Mr. Darden. And counsel, if you recollect, we need to conclude before the jury today at 4 o'clock due to some doctors and dentist appointments.
I only have 5 or 6 more minutes, Your Honor.
All right, Mr. Darden, you may proceed.
Thank you. Mr. Rubin, you testified regarding the issue, or on the issue of whether or not you saw any defects or anything unusual in the gloves shown in the photographs. Is that correct?
That's correct.
Did you see anything unusual on the gloves shown in the photographs?
No, I did not.
You saw a shadow, you say?
On a video.
Okay. Was there any defect at all in any of the brown gloves shown in the photographs shown to the jury that you saw?
Nothing that I could see.
And was there any defect that you saw in the Rockingham glove?
Nothing that I could see on the back.
How about the Bundy glove?
Nothing.
Okay, so there's no defect that you saw on the Rockingham, Bundy, or gloves shown in the photographs here in court today?
No, nothing.
But you were checking to see?
I was looking, yes.
You've been careful?
I tried to be as careful as possible.
Do you have anything to gain? Have you spoken to the press or to any tabloid?
I've chosen really not to do anything in that manner whatsoever. I'm really just here to tell about the gloves in respect to all the details of the gloves, and that's really all I can bring to the table here.
Okay, and the Rankin photograph that we just passed along to the jury, that was the photograph that when you were concerned, or where you were concerned about the mink or brown coloring, is that correct?
Since day one, you're well aware that I've worked with you in regarding my testimony here, and I've
Sustain. Ask another question. The answer was non-responsive.
When you saw photographs back in July, did you ask to see other photographs or additional photographs?
yes,
Did you ask to see additional videotape?
yes, I did.
Did you ever ask to see photographs with more clarity?
Yes, I did.
And why did you ask to see those things?
I wanted to be as accurate as possible in any statement that I might make before this court.
Now, you are from the state of New York, is that right?
I live in the New York area. That's correct.
And when you said that that the crime scene gloves seemed to have been worn infrequently, what did you mean by that exactly?
I was somewhat surprised that with the wear and tear on the Rockingham glove, that the lining seemed so close in similarity to the Bundy glove when I first saw them for the first time, because the Rockingham glove was very distorted and somewhat mutilated. I was actually somewhat taken by surprise when we did open up the glove and found out that it was a pair, and the only thing that connected the two was the same wear and tear in the lining, because there is a big difference currently between the Rockingham glove and the Bundy glove.
Now, you don't know what testing procedures or what tests were applied to the Rockingham and Bundy glove, do you?
I do not.
You don't know whether or not samples were cut out of the gloves.
Sustain.
At any event, you don't know what, if anything, any criminalist may have done to these gloves. Is that right?
No foundation.
I do not. My observations were just part of the linings that I could see clearly certain areas of the lining on both gloves.
Now, when you testified that the brown gloves shown in the photographs and in the video were Aris style number 70263, were you forming those opinions based solely on a single characteristic of the gloves that you saw?
No.
Was it based on two characteristics?
Many characteristics.
And was it based on all the photographs and all the video that you saw?
My complete analysis of these photos was a collective effort. As we well know, there were many that I rejected because I couldn't see enough, and some of them were included in evidence here today, which was sufficient enough for me to state that these photos represent the characteristics that are part of style 70263.
Mr. Blazier asked you about heat packs.
Yes, he did.
Will the use of a heat pack cause the gloves to shrink or expand? That is, assuming they would dry.
Technically, the worst thing that can affect the size of a glove is a combination of water and heat. Generally, water first, heat second. If the gloves were wet at any point in time and a heat pack...
Foundation.
Sustain. Foundation.
Okay, well, what would happen if there was a heat pack in the glove and the glove was wet?
Foundation. Counsel.
You've already testified about shrinkage and what causes gloves to shrink. Is that correct?
Beyond scope.
Yes, I have.
Testified to the effect or impact water would have on these gloves. Is that correct?
That's correct.
We see that in the January 6, 1991 photograph, and in the photograph we just showed the jury, the brown gloves are wet. Is that right?
Slightly wet.
Let's assume for a moment that there was a heat pack in the glove, one of those gloves on January 6, 1991, while the glove was wet. What effect would that have on the glove in terms of shrinkage?
Depending upon the amount of liquid and the location of the heat pack and the actual temperature of the heat pack, it could speed up some slight shrinkage.
And you can't tell us what effect blood will have on a glove in terms of whether it will cause it to shrink, and if so, how much? Is that right?
Objection.
Do you know what effect blood will have on these gloves in terms of shrinking?
Sustain.
Objection.
Sustain.
I'm sorry, can I have one more? Ms. Clark has asked me to ask you when football season ends. Do you know?
I'm very familiar with the football season since we advertised during it.
It's around late January, does it?
Starts middle of September, goes through the end of January.
Now, when we passed around that Bill Rankin photograph, did you want the jury to?
Sustain, not an appropriate question.
I observed.
Hold on, hold on. Not an appropriate question.
Well, the photograph that was passed around, did you select that photograph?
Yes, I did.
Let me show you the photograph that was taken by Deborah Gadara, exhibit number 612. As well as the glove the defendant tried on, exhibit 401. How do they compare in color?
This particular photograph and this particular glove are extremely close in actual color.
And showing you what has been marked as 164A. Glove found at Rockingham. Glove found behind the defendant's home. Are both of the gloves in your presence and in front of you, as well as the glove shown on the defendant's hand in these photographs, are they all brown?
Yes, they are.
They appear to be mink at all. That is, any of the gloves, as well as the glove shown in the photograph.
No, these three gloves are categorically brown.
Now, the glove was exclusive to Bloomingdale's, correct?
That's correct.
And there's no Bloomingdale's west of Chicago, is that right?
Yeah.
You don't know how the 70263 got here from back east?
Calls for speculation. Yes, sustain.
Your Honor, I have nothing further. I would ask, however, that the jury be allowed to take a look at the Gadara photograph as well as the crime scene. Comparison.
All right, my concern, though, is still the, how do you propose we do that?
There's a...
Put all three in a bag.
Well, no. Ms. Clark, I'm sorry, Mr. Darden, let's loan me the Elmo gizmo. All right, you lay them on the Elmo gizmo there. Lay them out, please.
Here, Marcia.
All right, and would you hand that, please, to juror number 1? All right.
There's no adhesive on the gloves.
Madam Reporter, gizmo. All right, Mr. Darden, would you collect the exhibits from Deputy Long? Mr. Glazier, do you have any requests?
Mr. Rubin, it's your testimony that, in your opinion, the evidence glove is the same shade as this other glove?
Very, very close.
And you can tell that much about the color of the evidence glove?
The back of the evidence glove I was using as a reference.
You feel you can tell that much about the color of the evidence glove?
I can only tell you what I see.
You remember when Mr. Darden just started his redirect before the break? Do you remember stating, at this point in time, the crime scene gloves are almost unrecognizable as far as color?
That's correct. That's what I said.
Now, right before the break, we passed to the jury the Renkin picture and 401. You recall that?
Yes, I do.
And is your opinion that the shade of gloves in 401 is the same as the Renkin picture?
From this photo, the actual shade is a little washed out because of the flash, but I can detect a little bit more of the color by seeing the difference in the raindrops and whatever, but it's not exactly as, it doesn't appear in the picture to be as dark as this in the picture.
This is picture number 4758 that you were shown, is it not? It's written on the back.
That's correct.
On August 31st, when you were interviewed by the prosecution, which picture was it that you thought might be mink?
I believe it was 4758 and 4748.
Same picture, right?
Yes.
Heat packs. If I understand your testimony, you think that if you have a heat pack inside the palm of your glove, that would cause the glove to shrink if it was wet?
I'm not qualified or knowledgeable enough about heat packs to tell the effect. If there is X amount of excessive heat and the gloves were wet, the two worst elements that would make a glove shrink are being wet and then having excessive heat. And what I mean by excessive heat is anything above normal 68 to 72 degrees.
The gloves are on your hand and the heat pack is in the palm and it causes the gloves to dry before they're taken off. They're not going to shrink while they're on your hand with the heat pack in there, are they?
Objection, no foundation.
Are they? I'm sorry.
You can answer the question.
I wouldn't think so.
So wouldn't you agree that the heat pack is going to cause the gloves to dry quicker before they're taken off so that they're not likely to shrink when they're taken off?
No foundation.
Can you answer the question?
It's possible.
Now, the Rankin pictures and the Gadara pictures are 3 football seasons apart, aren't they?
I believe they are.
And there's no sign of any shrinkage at all. In fact, the Gadara picture, the gloves look bigger, don't they?
Objection, I call for speculation.
Overrule.
Calm down.
It is. Rephrase the question. Hold on. Rephrase the question.
The Gadara gloves, at least from the picture, look bigger than the Rankin gloves, don't they?
It's very difficult for me to establish the exact size of the gloves in the Gadara picture. I've seen many Rankin pictures, so I have a better feeling. And I also have seen video of the same game of the Rankin pictures, so I have a much better grasp on that particular date and time.
Now, you've testified that you've been the most accurate and the most honest that you can.
I've done my best.
Now, in your search for accuracy and completeness, you've been trying to be as complete as possible?
Objection, I call for
Sustain. Rephrase the question. It's vague.
After you called the second glove company and found out that they had this equipment, you stopped looking, didn't you?
Do you want me to?
Sustain. Sustain. It's already been asked.
Were you concerned that if you looked any further, you might not be invited to the victory party?
That's ridiculous.
No further questions.
Anything else, Mr. Darden?
Subject to
Well, let me see counsel over the sidebar with court reporter, please. All right, thank you, counsel. All right, ladies and gentlemen, we've completed Mr. Rubin's testimony. Mr. Rubin, you may step down. Thank you very much, sir. All right, ladies and gentlemen, at this point, I have, with regard to the next witness, I have a couple of things that I need to resolve with the lawyers. And as I mentioned to you, we have a couple of juror activities that need to be attended to this afternoon. So I'm going, as far as you're concerned, we're going to quit at this point. As far as lawyers are concerned, though, we'll be in session probably till about 6 o'clock tonight. So we'll be here working. Remember all my admonitions to you. Don't discuss the case amongst yourselves. Form any opinions about the case. Using a lot of notebooks there. Don't let anybody communicate with you with regard to the case. What did I forget? Oh, don't conduct any deliberations till the matter has been submitted to you. All right, as far as the jury is concerned, then we'll stand in recess. We'll stand in recess for about 10 minutes, and then we'll reconvene on some of the other legal issues. All right, thank you, counsel. All right, after we have finished with Mr. Rubin, and I take it that concludes the prosecution's representation regarding glove evidence, is that correct?
With the provision we indicated at sidebar. Your Honor.
Okay. And it's your intent then to move on to Mr. Sims, and you wish to present evidence regarding the RFLP testing and the Bronco, correct?
Yes, Your Honor.
What do you intend on going after that?
After that, we're going to present, and we have points of authorities, Hank will be coming down, to present the videotape of final apparatus pursuant to evidence code section 1202.
All right, we'll have to have a hearing on that.
I think it went so long. The video itself, Your Honor, is I think 15 minutes.
Okay.
And we need to be heard on the Bronco fiber evidence.
All right, well, I'm sorry.
And Dante.
All right. Dutton, I take it the defense is going to present their P's and A's Friday?
Yes, I indicated to the court that Dean Ullman was returning to the Bay Area to present his P&As for Friday. We thought we'd argue that on Monday, if necessary.
Your Honor, that's not acceptable with people, because we expect to rest before then.
If they're true to that, I'll ask Dean Ullman to fly down here Friday afternoon. But as you said, they're being overly optimistic. The court gave him till Friday, said his materials were up there. If they are moving along, if the court excludes any evidence in this case, we'll move it up. But he needed until Friday. Besides that, we haven't rested anyway. We'll have some witnesses for him by Thursday anyway.
All right. All right, so we have the hearing on Dunton, or is it Dutton or Dunton? D-U-T-T? Okay.
Dutton.
All right, I have not concluded my examination of the RFLP issue. I had all the exhibits that were referenced brought up. I have them in my chambers now, and I've been busy all day, so I haven't had a chance to look at them yet. I mean, I've looked at the exhibits. I have not reviewed the Gertie's testimony that was referred to. So I'm not prepared to rule on that at this exact moment. If we break early before 6 o'clock today, then hopefully I'll be able to get to that and issue a ruling by the end of the day.
All right, Your Honor, we
All right, then we might as well move on to the next issue that you wish to present is the Paratus issue.
Correct.
All right, you ready to proceed to that?
Well, yeah, a couple of them. Can we say something here?
Your Honor, in terms of ready to proceed, I don't think I can be ready to proceed when I'm just told for the first time now that the people are about to present to the court points and authorities. I'm going to want to respond to the points and authorities.
This is asked to Paratus?
Yeah, they just said to you, I never heard it until 2 minutes ago, they just informed you that they intend to come down here with points and authorities.
No, we intend to argue orally. We broached this issue
I'm sorry.
a month or so
There are no
ago.
written points and authorities?
No.
Oh, then we're ready to argue.
All right.
There's a another issue at least that would be of some relevance to us with regard to the problem I spoke to Your Honor about earlier, the jury problem, and I need to address that as soon as the court will allow me to. We filed one motion, and there's another one that's coming in now that we want to file regarding this because this will require some immediate action on our part, so it's some urgency.
Well, we've had our discussion.
Well, no, we've had a nice discussion, but you said I could bring it up again at 4 o'clock because there's some remedy I wanted to ask the court for before we take our next step.
All right. Well, we'll take it up as soon as I finish these other evidentiary matters. All right.
Your Honor, given the fact that the prosecution may well rest its rebuttal case on Thursday, and at which point we would urge the court to urge the defense to proceed and complete its case, we would like some discovery of the proposed witnesses.
Let's
I want to end
finish.
this case this week, Your Honor.
Why not?
This jury is
Understand.
tired. We're all tired. It's enough monkeying around. We've got our witnesses ready to go.
Counsel, all I'm doing is saying what issues I need to resolve so you can conclude presenting your case. All right, I'll hear argument on the Paratus issue.
Okay, Mr. Goldberg is prepared on that, Your Honor. I didn't know you were going to proceed with that at this moment.
Just one thing you should put into the scheduling, and that
Yes.
is we still not have, I'm fairly astonished that Ms. Clark truly believes she's going to rest her case when they haven't turned over the materials that's supposed to be the subject of Mr. Diedrich's the report, and we have a pending application to have an opportunity
Well, that
to look at it.
indicates to me that since today is Tuesday, we may not see it.
Well, I mean, if we never get to see it, they want to rest, it's over with, so we'll move. That's fine with me.
We turned over Mr. Diedrich's reports, Your Honor.
Well, counsel, no, we're not litigating this now, counsel.
Right. It's just an issue for you to consider.
All right,
that
get
I have
Goldberg.
a pending application.
Get Goldberg down here.
You also mentioned earlier today that we could also address the scope of rebuttal issue. Carl Douglas is prepared to address that issue. Remember,
Well, we're taking this issue by issue, counsel.
oh, okay, I just wanted you to include that in the
Oh, no,
basket of
this-
issues for this afternoon.
All of these issues are scope of rebuttal issues.
Thank you, Your Honor.
While we're waiting, does the court want me to proceed on the other end? Do something? While we're waiting for Mr.
No.
Goldberg?
Actually, why don't we take the time, while we're waiting for Mr. Goldberg to arrive, why don't we at least view the proposed videotape? Because we're going to have to do that anyway. All right. Do you have it? Ms. Martinez, do you have that? All right. We'll mark this People's Next in order. 6:15. Are you offering an instruction with this, Ms. Clark? Are you offering an instruction? Are you offering a limiting instruction with this?
Yes, and that's why Mr. Goldberg's coming down. It's an instruction that limits its use for impeachment, not for the truth of the matter, I believe.
All right, this will be People's Exhibit 615. All right, Ms. Martinez, do you have that? All right, let's see it.
Ramirez, and this is going to be a videotaped interview. Thano, Thano, Paredes, P-E-R-A-T-I-S. It's July 27th, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to be taping.
It came from 3:30.
Okay, tape read on the video for 30 seconds.
Very good. Basically, what I wanted to do is just ask you about 3 statements that you made at the preliminary hearing, and we'll go through those one by one. And the reason for videotaping, as I said before, is because there was a certain demonstration that you had wanted to show us. We thought it would be better if we got a videotape than if we just did it with an audio tape or some other way. If you want to stop at any time or you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah, that,
okay,
that was an estimation.
All right.
Because that's what we all think we draw at that time.
When you say we, you mean?
The nurses.
And when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what the vat container tube pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this sort.
That you don't measure it?
No, we never measure any blood.
Okay. And when you said not the sort, what do you mean by that?
Well, usually I draw blood for people that are arrested on blood.
Okay.
Speaking of different tube and different method, we just draw it, and that's given to the officer, and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day.
Okay. How did that come about?
I heard from a friend of mine who heard on television that there were approximately 2 cc's of blood missing. So I took it on my own to find out, well, did I really draw 8 cc's or not? So I took an empty vial.
Okay. Just before we get into that, when approximately in time was this? Do you know when that was?
It's so long out, I would say about a week, maybe 2 weeks later. No, I can't swear to this, but it was at some time when it was mentioned on television that there were a couple of cc's missing. At that time, it was the next day.
Well, was this around when the trial was in progress?
Yes, I believe it was when the trial was.
Do you know when it was in relationship to Mr. Cochran's opening statements? Okay, so were you watching the trial?
No, I just got a phone call.
Okay, but whenever this was, it was when the trial was going on.
Yes.
Okay, and you got this call from your friend, and then what did you do?
Well, I don't think we want to hear on television what I said, but the next day I went to work and started pulling out test tubes, and I pulled out a syringe, and I got some water, and I started measuring 1 cc in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's was in the test tube, that was more than I drew. So I took Another test tube kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimate that that's what I really had drawn.
Okay, can you repeat for us now, using some of the things that you have here with you, this procedure that you went through in order to figure out that it wasn't the ACC's?
No. Well, I can empty out one of these test tubes and...
Okay.
Sure. I need to basically throw some.
Oh, okay, let's take a break while he wants to throw that water away.
Now, when I did this experiment myself, I used a 1 cc syringe, which I don't have here. So we're going to have to go on the 10 cc's, and this is a 10 cc syringe. It's definitely not the way to take off a needle. Okay, the way I did it, I drew 1 cc at a time. Here's 1 cc. Pull it all out there. Okay, there we have 1 cc. And at that point, I put little lines, a piece of paper with little lines, and marked 1 cc. Okay, then. Two cc's. Keep going.
Sure. Yeah, just repeat what you did.
Three cc's. This isn't the ideal place to be doing this.
Okay, what were we on? 2 cc's or 3 cc's?
4 cc's.
Careful sticking a needle back in the cup.
Oh, this needle isn't really contaminated. 5.
I just don't want to be stuck.
12.
Shoutout.
This is 6 cc's here. Seven. That's approximately 8 cc's right there. That was more than I knew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point. If we take that out, we'll know about what it was. So I could take out 60 and a half. There you go. Which should be 6.5 cc's. Short measure.
And sure.
Approximately 6.5. There we go. Approximately 6 cc's and a half.
So, after you had done this, what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw any cc's, that I knew about 6 to 6 and a half.
Is that an approximation?
That's still an approximation.
Yeah. Now, incidentally, you said that you talked to this friend. Was this someone who was watching the trial, or?
Oh, he wasn't watching the trial. He got a phone call from another friend of mine who was watching the trial, who called him and said, "Hey, Paratus goofed up." And this was something that had been harassed Paratus on. And so Paratus decided to straighten it out right away. That was, but he, per se, was not watching it. He just got the call, and then he called me.
Okay. And then after you had straightened this out in the way that you just described for us or demonstrated for us, did you then call the DA's office to tell us what had happened, or to try to tell us what had happened?
Yes.
And then I spoke to you.
And you spoke to me the day you brought me the subpoena. And that's the day I told you.
I think I have a copy of that. February 3rd?
February 7th is the Dean's.
Oh, it's for February 7th. But at any rate, it was in February. First week of February.
Bottom. And so it was that day that, because I had called you, and in the meantime, I had heard from Patty Joe that you wanted to talk to me. So I asked you to come down to the dispensary.
Okay. And did you go through the same demonstration that you just showed for the camera today when I was at the dispensary? Can't remember. That's all right. Now, there was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
that
that
statement. which I shouldn't have made. I looked at it, I should have said, it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drawn? Mr. Simpson.
Here. Okay, the blood was pulled out. I pulled it out. I saw that. What it was, I squirted the blood in the tube and trash. I just looked at the syringe.
Okay.
I didn't turn it over.
There is a part of the syringe that was calibrated.
Yeah, but I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, we just don't do it. I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No, about 8 cc's. Now, you want to make a bet and we'll check next time? Nobody wants to take the bet. Take me on that bet.
So where did the figure of the 7.9, it could have been 7.9 or it could have been 8.1 come there?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have an order exactly, then you're very careful. We don't have any special orders of how much you draw. If somebody should request a certain amount of blood, then I would be extremely careful to draw that much. So far, I've never had a request like that.
Okay. I think if there's anything else to know. Oh, you indicated something to the effect that when you had this telephone conversation, you made some comment to your friend, but it was using language that wouldn't be polite to repeat. Were you upset at that time when you learned that someone was
No, it's usually when you goof up, what's the first 4-letter word you say?
Okay.
Okay, so that.
All right, I guess. Sure.
No, I really, well, I was upset, I was just kind of upset with myself that I made the goof up. And I realized that I had made an error then, which might create problems. And I wanted to rectify it as soon as I could.
Do you usually take blood with a syringe, a hypodermic syringe like the one that...
Most of the time we use, most of the time I use the Vacutainer. But when I get someone as big as OJ, with big arms, big muscles, I myself have found I can control it better when I use a syringe. It's like, you just go in, get my finger on that vein and go bang without a problem. Other times, I can do a lot better just by using the other, you for example, without a tourniquet, I could just go bing on you.
Yeah, that's something there. Now, when you say that you usually use the Vacutainer, what's that?
The Vacutainer is, this is the Vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put it has a needle on this end too. You screw it in here. Then you put this in here, and you inject into the, and then when you're in the vein, you push on this, and it just sucks the blood through it.
Okay, and that's based on the vacuum that's in the tube.
Yeah, on this now, nothing would happen, because if there were any error in there, we just suck it out, that's all. This is made for a different type of thing. They usually have a needle on the other end. Just inject the needle. Yeah.
How often do you use a syringe as opposed to a Vacutainer?
Oh, not very often. It's just when I get a big person. And I make an evaluation of the arm, and that's, you get in the habit to evaluate. You look at the other, I look at him, I have no trouble. If he came in for anything, I'd immediately go for a vein right like that. I saw his arms, and they have veins like that. Oh, these never hurt here. And I just, right there, bing bang at it. With anything on him, because those are nice big veins. I used to have those until I had them ruined on this side. When you get something like OJ is arms are pretty big. I've had other big people like that. But I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around. You just hit them, and that's it. And I haven't had any complaints of an ouch.
Did you have any problems when you were drawing blood from the defendant?
No. I just, at this one certain point, as I was pulling, the bevel of the needle hit the wall of the vein, and that's when it stopped. And so you either turn your syringe and draw more. But at this point, it appeared like I had enough. So that was it. I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, I was surprised the needle hit the wall. It's the only reason it would stop. Oh, it was the blood would stop. And I said, well, that's enough. In fact, every time I draw blood and I reach that point, it just, well, you've got enough blood. There's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's the slightest chance that you may damage the nerve. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe? Oh, that was when it was?
Mm-hmm.
But you looked at the part that's opposite from...
Yeah, the calibrations were on the bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we've never had no blood.
You know, where they came back, you said you didn't draw enough blood.
Yeah, I've never had a case where we need more. I don't know any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. I think that's about it, unless you have something else you want to ask, Steve. All right. Well, thanks a lot.
Well, you sure what?
I'll hear from the proponent.
Well, Your Honor, there's not really a whole lot to say. I thought that we'd already argued this once before, and the court had indicated that we could use inconsistent statements from the witness, and under 1202, we are entitled to use inconsistent statements from a hearsay declarant, and that's what this is. It is inconsistent with his testimony that he withdrew between 7.9 and 8.1 cc's of blood. And it is also inconsistent with the inference that was contained in his testimony that he looked at the syringe, although it was a little bit unclear from the testimony that was read into the record. He did seem, the inference that the defense wanted to be drawn from it is that he looked at the syringe, and that's how he knew exactly how much was drawn.
Your Honor, this issue has never been argued before. In fact, it was deliberately postponed for this particular purpose because you decided that the appropriate time to raise it would be during the course of the people's rebuttal case. And we could all stand here and we could laugh at some of the jokes made on that tape. And I agree, at times it seems pretty funny. And if it wasn't for the fact that Mr. Simpson was on trial for his life, I would sit here and laugh at it. But if the prosecution actually thinks that they can offer a tape like that, full of rank, staged hearsay, completely concocted solely for the purpose of this litigation, after they knew we were going to introduce the grand jury testimony and the preliminary hearing testimony of this witness, then what they have done is set back notions of due process maybe 50 years, taken the Sixth Amendment and stood it on its head, and suggest for a moment that they can somehow take a notion of unavailability and use that as some kind of license to put any kind of charade forward to this jury. It is absolutely absurd. All the court has to do initially, Your Honor, is to start thinking back about the history of Thano Paradas. And what we have with Mr. Paradas is someone who, as you may recall, the defense urged the prosecution to call as part of their case because we thought it was an indispensable witness to lay a foundation for the introduction of Mr. Simpson's blood vial. They refused. However, one of the things that I learned on this tape for the very first time is that they had subpoenaed Mr. Paradas to testify on their direct case, but at some point obviously changed their mind. So at that point in time, Mr. Paradas was healthy, was available, could have testified, and we did everything to urge his live testimony before this jury, where he would have been subjected to this type of examination and cross-examination that most witnesses are subjected to in an adversary system. In any event, they didn't do it. Sometime in late June or early July, Mr. Paradas had a massive heart attack, and as we learned in court, went through a quintuple bypass, and apparently it was his third bypass surgery in his adult life. As a result of that, he was then deemed unavailable. Now, when it was determined he was unavailable, we at that point informed the court that we intended to introduce his grand jury testimony where he was called as a prosecution witness, his preliminary hearing testimony where he was called as a prosecution witness, and that was going to be our offer based on the unavailability. And we're entitled to do that not simply based on the California Code of Evidence. We're entitled to do that based on the United States Constitution and a series of cases which have defined appropriate remedies when there's an unavailable witness. And that's what we did. One of the things that's really interesting, Your Honor, in Mr. Goldberg's statements is that on July 27th, the morning before this outing occurred at Mr. Paradas' house, and this prep session occurred, and these questions and answers ensued, is that Mr. Goldberg came into this court and said on the record at page 39085 that what he wanted to introduce were prior inconsistent statements of Thano Paradas. That's what he said. I can actually, the exact words are that if Paradas came into this courtroom during and testified, we would of course be allowed to introduce, to impeach him, prior inconsistent statements. Well, we should be entitled to do the same thing if he's not here, if he's unavailable. That was the representation Mr. Goldberg made the morning of July 27th. Well, he didn't have this tape the morning of July 27th. He went out at apparently 3:30 in the afternoon and collected these statements during this rehearsed interview with the witness, Thano Paradas. They're not prior inconsistent statements. The statements that we introduced by Thano Paradas were made back in June and I believe early July of 1994. That's the historical background to what happened here. We submit, Your Honor, that there are three separate reasons why this kind of rank hearsay is inadmissible at this point in time in these proceedings. First of all, Your Honor, although 1202 says that hearsay can be introduced to impeach a hearsay declarant, it does not cover all circumstances. It is not something which overrides the U.S. Constitution, nor did the legislature intend it to. In fact, in Section 1204, two sections later, in the same evidence code, it says unambiguously that a statement that is otherwise admissible as hearsay evidence is inadmissible against the defendant in a criminal action if the statement was made either by the defendant or by another under such circumstances that it is inadmissible against the defendant under the Constitution of the United States or the state of California. So clearly the legislature was aware of the fact that not all hearsay is going to come in under all circumstances. And if in a criminal case the statement is to be used against a defendant, which Mr. Simpson is obviously in these proceedings, then it has to be done in a way that's constitutional. And there's something in the Constitution called the Sixth Amendment, which gives the defendant the right to confront witnesses who wish to give testimony against him. And the Sixth Amendment, Your Honor, has been construed most recently on this particular issue in 1980 in the case of Ohio versus Roberts, which can be found at 448 U.S. 56, 1980. And in it, what Roberts says is that there are two requirements that have to be met before something like this can occur. Number one, there has to be a finding of unavailability. I can only assume that he was unavailable, although he didn't look that ill in the course of this videotape on July 27th. But let's assume for the purpose of this discussion that they can demonstrate unavailability, as we asked for unavailability 2 months ago in these proceedings. What Roberts says is that that's not enough. What you then have to find and make a finding of is there is sufficient indicia when you do some kind of balancing test that these statements are trustworthy for their truthfulness. That's the finding that the court has to make before you can find an exception to the hearsay rule that would pass constitutional muster under the Sixth Amendment right of confrontation. And I would suggest to the court, Your Honor, that in this particular case, they don't come close to meeting any of those indicia. Number one, what he's saying here on this tape is that in his unsworn testimony on this tape, is that his sworn testimony was false, and that it was false in two very substantive, important regards. Number one, he's saying his sworn testimony was false because he said that he had drawn 8 cc's. Now he's saying he hadn't done that. And two, he's saying it was false when he testified a year ago that he had, by looking at the syringe, you know how much blood you draw. What's extraordinary and completely unbelievable in this statement made a year later is a suggestion that, notwithstanding the fact that the syringe is calibrated, and it does have numbers on it, and it does have lines on it, that he never turned it around to the side that had the lines on it and the numbers on it. Although that is in marked contrast. In fact, it contradicts the sworn testimony he gave before another court at a preliminary hearing. So that's one indicia of reliability that is absent in this particular statement. A second indicia of reliability, Your Honor, is that there is no defense attorney present to participate or sit in on this particular interview that occurred on July 27th. There isn't even an independent party. There is an advocate, there is the prosecutor, there is Mr. Goldberg, and I would point out at this point, Your Honor, that Mr. Goldberg is participating on this videotape as an unsworn witness. This is not testimony in a courtroom where a lawyer gets up and is cloaked in certain privileges being an attorney. This is Mr. Goldberg, the private citizen, out there with an unsworn witness, and he's unsworn, asking certain questions, making statements about what this witness may have said to him off camera or on other occasions, and then getting the witness to confirm or affirm those statements. He, too, at that point is an unsworn witness. So there's no defense attorney present. There's no independent person present to assess the reliability of this staged reading that we just saw. The statement is not made under oath, and in fact, the statement is made after, not as a prior inconsistent statement. The statement is made 6 months, or I'm sorry, the statement is made a year after he testified under oath. The statement is made 6 months after the trial begins. The statement is made 3 weeks after we tell the court that we intend to introduce the preliminary hearing testimony and grand jury testimony of this witness. What better motive is there to fabricate at that point? Now, the other indicia that's often relied upon by courts in this context is that, was the statement made, was it some kind of innocent hearsay? Was it a situation where this witness, Mr. Parada, simply said to a friend X, God, I made a mistake about something, or something like that? Is it that kind of statement? As opposed to a statement that is made explicitly and exclusively for the purpose of litigation. There is no question at all that this statement was made for the purpose of litigation. And when statements are made purely for the purpose of litigation, Your Honor, that indicia of reliability is lost. and it's very difficult to compensate for it. Certainly, it's not compensated for in the facts of this case. Now, what's another indication? Well, does it sound right? They have the temerity to suggest that this man who is drawing blood on a regular basis, a year later, remembers when he looked at a blood vial on June 13th of 1994 how full it was. When he said that he prepares blood vials on a routine, regular basis all the time, be it in drunk driver cases or any other kind of case, he does it routinely. And he is suggesting that all of a sudden now, a year later, he can remember how much blood was in that particular vial as opposed to the other vials that he drew.
Yeah.
It's extraordinary.
It's not often OJ Simpson comes in and asks you to take a blood sample, though.
Well, if it's exactly, and that's why when he testifies under oath at a preliminary hearing and in the grand jury, Your Honor, that there's 8 cc's of blood, and it could have been 7.9 or it could have been 8.1, and I looked at the syringe, and that's what the syringe says, that's exactly why he knew it then. And that's exactly why the Constitution prevents the prosecution from coming in later on and going out to a man's house after he's declared unavailable and putting on a charade like this, where there's no defense attorney present, where it's unsworn, it's not even a deposition, and he can say anything he wants, and it can never be challenged. That's not what 1202 had in mind, and that's why the Constitution gives you those protections, Your Honor. Now, I'd also point out, one moment. In that regard, Your Honor, I would also point out that there is no independent basis for admitting the statement, because even though the statute 1202 envisions that hearsay will be admissible, there still has to be some basis for it. This is not a prior inconsistent statement. This doesn't meet any of the other criteria for ordinarily impeaching this kind of witness who was offered sworn testimony. And the sworn testimony that was offered here was sworn to back in June and July of 1994, not July 27th or 28th of 1995. That's when it became, it would have to be prior to that, Your Honor, because that's when he made the statement. In terms of a motive to fabricate, he said it was when I heard during the trial that there was 2 cc's, although I think the testimony was really that it was 1.5 cc's that the vial was short, that I thought I may have screwed up the prosecution's case and decided I had to look into this. Now, if that's an indicia of reliability, that's extraordinary. It would be stretching all the rules of evidence, Your Honor, to allow something like that to pass muster legally or constitutionally before this court. Finally, Your Honor, the tape in and of itself, apart from violating the Constitution, apart from not falling within the confines of 1202, its content itself would render it inadmissible under any kind of 352 consideration or the court's own inquiry as to whether or not this would be a fair and just thing to do. And remember, Your Honor, that's what you have to come back to. Is it fair and just to allow this kind of staged Q&A by Mr. Goldberg to come in to rebut their own witnesses' sworn testimony that he gave on 2 prior occasions? And in that regard, you have this individual on the tape describing double and triple hearsay. Says that I didn't even see this statement on television. I heard it from a friend who heard it from a friend. And, Your Honor, I can offer testimony right now from Robert Blazier or from Joellen Demetrius, who were both with me at the infirmary interviewing Thano Paratus on April 11th, 1995, about this issue. And we walked into Mr. Paratus' office. He had in the infirmary a television, and the television was on. And we asked him why he has a television in the infirmary where he works. And he says he has the television in there so he can watch the OJ Simpson trial each day, because it's often slow in the infirmary, and there's nothing to do. We asked him then, did anybody in the prosecutor's office tell you that you're not supposed to be watching this? And he said, no, no one ever told me that. Maybe that's the reason why he came up with a new explanation on this videotape on July 27th. But I can offer sworn testimony from Joellen Demetrius or from Robert Blazier on that particular point. And what he said was, and this is what triggered it all in his mind, is he was listening to Mr. Cochran's opening statement when he heard about the 1.5 cc's. and he became alarmed that perhaps he was going to hurt the prosecution's case. And at that point in time, for the very first time, he began to reconsider this whole thing. Now, on the one hand, he's admitting to us that he's watching this trial every day, has a TV in the infirmary, and then all of a sudden he completely changes the basis for how this information came to his attention to cover his own behind for being caught watching this show every single day. I'm telling you, Your Honor, this is not somebody who you can trust under those circumstances when we don't have a sworn witness here. Number two, Your Honor, he's describing in the course of this Q&A an experiment he conducted. And that brings us back, Your Honor, to something that came up.
He doesn't describe it, he replicates it.
Well, he does. That's the point, is does he substantially replicate it? In fact, he even says, listen to this, it's an experiment within an experiment. Because what he says is, I'm doing it now one way. This is not the way I did it. In fact, when I did it in my own infirmary after hearing Mr. Cochran's opening statement or hearing the reference to the missing 1.5 cc's. So you don't have substantial replication, number one, on the video of an experiment that he did in his own infirmary. Neither experiment substantially replicates the manner in which he drew blood from Mr. Simpson on June 13th. So none of those experiments or description of them would meet the case law criteria that they have asked for in keeping out other experiments that our witnesses have tried to introduce. This certainly falls way short of the glove drying experiment that Mr. Scheck tried to introduce that had been performed by Henry Lee. It doesn't come, he even says so. So if the content...
Swatch drying.
I'm sorry, the swatch drying experiment. The swatch drying experiment. What did I say, gloves? It's a day of gloves, Your Honor. So just to recap very briefly, Your Honor, it doesn't meet the Constitution.
We don't need to recap.
Okay. Your Honor, I'm just saying that there are so many reasons why this can't be permitted at this point. It's almost as if we could have just turned off the tape and not had to have any argument at all. It's that shocking, frankly, to even to think that the prosecution would believe that his asking hearsay questions to a witness under those circumstances, based on what's happened in this case, could possibly be screened before this jury.
Thank you. May I respond? First of all, I don't understand why this type of hysteria and advocacy is necessary, especially when we're dealing with a very straightforward evidentiary issue and the types of aspersions that counsel likes to cast. I don't know what he's talking about when he says this was staged. You may not appreciate, once again, my directorial abilities, but clearly this is not staged or rehearsed in any way, mean, shape, or form. Not that is necessarily what's relevant here legally. When we discussed this the last time, if I'm paraphrasing the court's comments correctly, and I believe I am, I think what the court said when counsel expressed amazement at the idea that we could get inconsistent statements of a hearsay declarant is the court said, well, it's something that we have in the state of California called the evidence code. So we did discuss it before. I don't know whether the court formally ruled, but I think the court has a very clear understanding of this issue and what the laws in the state of California. Now, what is admissible under 1202? It is not prior inconsistent statements that are admissible under 1202, the credibility of the hearsay declarant. It is evidence of a statement or other conduct by a declarant that is inconsistent with a statement by such declarant, period. It doesn't say anything about prior inconsistent statements. This is the kind of shorthand that we attorneys often use that gets us into trouble because we're used to saying prior inconsistent statements, and in actuality, the code does not speak to prior inconsistent statements. It talks about inconsistent statements. Evidence Code Section 1235 says that evidence of a statement made by a witness is not inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing. Again, it doesn't say prior inconsistent statements. And the commentaries to these sections make it absolutely clear that there is absolutely no requirement, and never has been one, in this state or any other state, that the statement has to be a prior inconsistent statement, merely that it must be inconsistent. And this is inconsistent. The next thing that I'd like to point out is that counsel makes a constitutional argument that is entirely misplaced and stems from his misunderstanding of California evidence law. The section that we are relying on, 1202, is not contained in the hearsay exception section. It's contained in Chapter 1. Hearsay exceptions start in Chapter 2. Why is it that the legislature put this in Chapter 1? Because it is not an exception to the hearsay rule. And in fact, and perhaps I should not point this out to counsel because he apparently doesn't know this, the defense...
Well, counsel, now we're getting into the same kind of conduct that you were...
Well, I'm just criticizing his legal analysis. I'm not criticizing any other aspect of what he said. They would be entitled to a limiting instruction that this is coming in only for the purposes of analyzing the credibility of Mr. Paradas. It is not coming in for the truth of the matter asserted under this section. It is coming in for the purposes of showing that someone who has made an inconsistent statement on the points to which he previously testified cannot be trusted with respect to those statements. So there are no trustworthy requirements. It is not being offered for the purposes of proving that those statements... I thought maybe Mr. Cochran wanted to add something. It is not being offered for the purposes of showing that those statements are true. It is being offered for the purposes of showing that his prior sworn statement is not reliable. And that's why you do not need to satisfy any other requirements of trustworthiness or anything other than what is provided in the code itself. This is a very simple problem of mechanically applying the evidence law that is very well established. There is no issue. There's no 352 issue. If counsel wants to introduce other inconsistent statements of Mr. Paradas, maybe he can, maybe he can't. I think we should take those up when it is appropriate. And if the court were going to rely on any conversations that he has, those should be reduced to a declaration rather than relying on his representations, because he has not correctly stated even what Mr. Paradis' former testimony was, because he did not say he looked at the calibrations on the syringe. He said he looked at the syringe, and no one ever asked him whether he looked at the calibrations or not, although that is one possible inference. So I don't think that we can necessarily represent at face value counsel's paraphrasing his conversation with Mr. Paradas. And it's not relevant anyway. It's just not, it's beside the point as to this issue. Now, as to the question of the so-called experiment, this is not an experiment that is being offered for the purposes of illustrating what actually happened. This, again, not coming in for the truth of the matter asserted. This is simply explaining how Mr. Paradas came to the conclusion that his former statements were incorrect. If Mr. Paradas testified that he looked up in the sky and saw clouds in the shape of a 6.5, and that's how he came to the conclusion that he really drew 6.5 cc's, that would be admissible too. We don't have to prove that looking in the clouds is a reliable way of figuring it out. All we're trying to show is that he's made an inconsistent statement, and that is part of his inconsistent statement, and why he believes that his previous testimony was not correct. So it is not coming in as an experiment, but simply as part of his inconsistent statement, and some explanation for how he came to the conclusion that what he previously said was incorrect. So all we are asking the court to do is follow the evidence code. It's very clear. This is an inconsistent statement. Comes in. I think we were the moving part.
That's correct. All right, counsel, you've argued to the court Ohio versus Roberts, which is Justice Blackmun's opinion from 1979 that I don't recollect, frankly. It was just handed to me. I'd like to read it. So we'll take a couple moments and I'll rule. I want to read this before I rule, since you cite it to me. And I have not read this recently. I don't recollect the facts or circumstances of this case. But let me just make an observation, Mr. Goldberg. There's a lot of stuff in that tape that is not specifically a statement inconsistent with Mr. Paradas' testimony at the preliminary hearing before the grand jury, and there's a lot of surplusage there. Also, I think the court's rulings regarding demonstrations and experiments are pretty clear and pretty consistent. So may perhaps, I mean, do you have an edited version of this tape available, or solely the statement as to what he drew?
No, Your Honor, because it would be difficult to ferret out exactly what portions those are, because in every portion, almost every portion, it seems to me he is explaining why it is that what he said was incorrect and how he determined it to be incorrect. There may be certain instances where I could see the court saying that those statements do not do that directly or indirectly, but otherwise it seems to me that everything else is either directly or indirectly inconsistent with his testimony in the prior hearings.
All right. Well, I'll read Roberts and I'll rule. All right, we'll take 15.
For the record, counsel did not cite to me Roberts in advance. I'd read it before, but I did not have the opportunity to read it for this hearing.
Oh, it's been a long time since I've read it. All right, take 15. Had the opportunity to read the State of Ohio versus Herschel Roberts, 448 U.S. at 56. Court's ruling is as follows as to the admission or non-admission of the statement by Mr. Paradas. Record reflects that the court previously made a finding of unavailability of Mr. Paradas as to be on the basis of his medical condition, that medical condition having been prior heart bypass surgeries and now a quadruple bypass surgery. I believe this was his third bypass surgery. His doctor had indicated that he was not available to testify in court. Neither side has chosen to challenge that finding at this time. The prosecution offer is that of a statement as evidence of impeachment of a hearsay declarant under Evidence Code Section 1202. This is not an offer under 1235, an offer of a prior inconsistent statement or of an inconsistent statement. For the truth of the matter stated is merely for impeachment purposes. It is therefore limited in its use. The cite to the Roberts case is not applicable to this particular fact situation. The court has found previously unavailability of this particular witness. The court allowed the defense to then present prior testimony, both before the grand jury under oath and before the magistrate at the preliminary hearing. And under any circumstance, a statement made by a witness which is inconsistent with their, not under any circumstances, but under most normal circumstances, an inconsistent statement would be admissible for the purposes of impeachment. The troubling part of the proffer is that this videotape contains the demonstration of an inadmissible experiment and contains extraneous double and triple hearsay information given to Mr. Paradas by other persons. Court will sustain the objection to the experiment part of the tape. Anything that is irrelevant or extraneous, the people may offer an edited version of the videotape where Mr. Paradas specifically discusses his testimony regarding the amount in the syringe. However, the remainder is excluded as being superfluous, and the court will see the videotape in its final form before it's exhibited to the jury. All right, that's the order. All right, any other issue we can take up before we recess for the day?
Yes, Your Honor.
Mr. Shapiro.
All right. Important matter, the letter memorandum and request for relief concerning the testing of Mr. Goldman's blue jeans and the state of discovery with respect to the testimony of, proposed testimony of Mr. Diedrich, I have to bring to the court's attention.
All right, we have Mr. Goldberg present at this point in time.
Yes. Now, Your Honor, Yesterday, it turned over what appears to be a report from Mr. Diedrich, wherein he indicates that he is going to testify based on experiments that he's already done, that the imprints on the blue jeans of Mr. Goldman came from Mr. Goldman's shirt, and the imprints on the letter and the piece of paper came from Mr. Goldman's blue jeans. Okay? Now, the prosecution turned over to us a few photographs and statements about how on August 21st, the day before Dr. Lee testified, and this is very curious because Mr. Goldberg was saying it all came as a big surprise to them, but on August 21st, they went and did test impressions, too, of Mr. Goldman's jeans. And the way the test impressions were performed is apparently using something they call an identicator, but from the pictures it appears to be something that they ordinarily use to roll palm prints. And they would press this yellow, what they call in the reports, a yellow piece of paper onto the jeans. And then they would roll it with a roller. Then they place a white piece of paper on top of that, and then they roll that over the jeans, and then they get some kind of what they're calling impression. They apparently did 2 of those on August 21st. We have a small picture of one of those, but nothing that we can show an expert that they can do anything with, and we have no idea whether this is what Mr. Diedrich's using. Then, on August 31st, they took 5 more impressions of the jeans, and they took impressions from Mr. Goldman's shirt, and they took impressions from the shoes. The shoes have been ruled out. Apparently, all these documents were then sent to Mr. Diedrich in Washington, where he made an analysis and came up with a report. This was done without notice to the defense. Now, what I can show the court, and the pictures, they have P numbers of 4971 and 4967. And I would like to mark these as exhibits, if I could. Why don't we deem them defendants next in order A and B?
All right.
And what the court can see, and these are apparently the impressions that were done.
1374.
1374A and 1374B. 1374A
Those to Mrs. Robertson.
shows the piece of paper that presumably has an impression on it. And 1374B shows the jeans before this process was done. Now, we haven't seen the jeans since they went through this process, but I know from their own reports that they did 5 more impressions on the jeans since then. And what you see there is the results of only the first 2 impressions. And I think the court can see that on the jeans itself, there is a triangular impression that must come from the other side of the jeans being impressed onto the front side of the jeans. In other words, you can see an imprint pattern or a pattern on the jeans after they went through this process that wasn't on the jeans beforehand. Now, that is a matter of serious concern under Griffin and Arizona versus Youngblood. The reason it's a matter of serious concern is Dr. Lee testified to the imprint patterns on the jeans. And those imprint patterns, I dare say, were favorable evidence to the defense. That's clear. It's the subject of their rebuttal. This court had already issued an order that we're supposed to be given 48 hours notice if the prosecution is going to conduct any potentially destructive tests so that we can have an opportunity for an expert to be there and also to litigate the reasonable necessity of doing that evidence. It seems absolutely clear to any sensible person that the process of taking this test impression as they went about it would create a risk of altering the genes. What's worse is that it's plain from the photographs of August 21st that they altered the genes with the first 2 test impressions they took, and we haven't seen the genes since, and there are no pictures of them that I see here, but they did apparently 5 more test impressions. Of course, they've done the same things to the shirt. So it seems to me that there is an issue here that we will have to litigate with respect to a bad faith alteration of exculpatory evidence. I mean, this is a classic because there was an outstanding order. It could be anybody could see, even particularly after the August 21st impressions, that they were going to alter the evidence. So there's really no good faith justification for doing this in secret. And anyway, they were under orders to do it, and any responsible prosecutor would have given us notice. And in fact, quite the opposite was going on. We were sitting here with Mr. Hodgman and Mr. Jokelson looking for Mr. Goldberg to get various data from him about contact sheets and something else, and there were 1054 proffers to the court. I don't know what they were, about what they were going to do, but they shouldn't have been doing this in the fashion they did without giving us notice. We cannot fully litigate how much these genes were altered or the other items. We haven't seen them yet. I don't have experts available to look at them yet, particularly since we don't have the underlying data that apparently is going to form the basis of Mr. Diedrich's testimony. That is, we don't have the actual test impressions. Now, I asked Mr. Goldberg yesterday when we were going to get this data and when we were going to have an opportunity to look at the genes, take a look at their test impressions, compare it with one expert, so we can make copies of the test impressions, see which ones or which part of this pattern Mr. Diedrich is claiming matches something on the envelope, the piece of paper, or how something from the shirt matches the genes. And we have to see what he's actually done. And I asked him what was going on and would they give us notice if they were going to do something else. He told me, well, he takes the position that nothing gets altered, it's not a destructive test, and that Mr. Diedrich is going to arrive here sometime tomorrow afternoon, and for the purposes of only having one witness testify, he's already finished a report, for only having one witness testify rather than bring in these people from the LAPD who actually rolled the impressions, he was going to have Mr. Diedrich do more test impressions. So only one witness would have to testify, and they wouldn't have to bring these other people in. And I asked him, well, are you going to give us notice and a reasonable opportunity to bring an expert there to even observe this and to litigate the issue of whether you can go about and do yet another set of test impressions even after he's finished his report and alter the evidence some more? And he said, well, I'll tell you when he's coming, but we won't wait for you. Now, I've done my best to try to get somebody here who's knowledgeable in the area. I've spoken to Mr. Morton. He can be here on Thursday if Mr. Diedrich is going to come and bring his materials. But we want to just basically have an opportunity to look at the genes, review with Mr. Diedrich the test impression sheets that he has, see exactly what the basis of these experiments are. Have Mr. Morton review it, make copies of it, send it to Dr. Lee and Professor McDonald so that we can have an evaluation of it. And I can tell you this, we won't be ready to either litigate the issue, the Arizona versus Youngblood issue, or another extraordinarily substantial issue I see, and that is, I don't think there's a sound basis, just from what I've seen so far, to get these experiments into evidence under the substantial similarity test and the way the court has been ruling on these experiments. It's a very serious issue. I can't even adequately litigate that until I see the underlying data from these reports. So I'm, really quite flabbergasted that Ms. Clark, who apparently is going to put on these witnesses, can stand up here and say, well, we're going to rest on Thursday. We're calling Mr. Diedrich in the next 2 days. When they're not even making an effort to give us discovery, and worse than that, they're spoiling the evidence. Hey, this is a railroad. This has to stop because this is completely inconsistent with the discovery law in this state. It's inconsistent with positions they've taken. It's ridiculous. So the relief that we're asking for, and I think it's one that's reasonably designed to try to get this trial over with in a fashion that's fair, is that we can bring Mr. Morton down and he can look at this data. we can evaluate it. We can file our motions with respect to any alteration. There is no need for them to take yet another test impression just so Mr. Diedrich alone can testify, because that is on its face gratuitous. He's already filed his report based on the data that he has. And we need an opportunity to evaluate the evidence, to make our Griffin motion with respect to that evidence, whatever prejudice has ensued, and also to file a fully informed motion with the court objecting to those experiments, because I can see right now that there are serious problems there and something I'm sure the court's going to want to look into. If we're given that opportunity to get the data on Thursday, I can send it Federal Express to Dr. Lee and Professor McDonald. We can evaluate it over the weekend. We'll file the papers on Monday. The court can consider it. After rulings, we'll see whether or not Mr. Diedrich can testify, and we can proceed from there. That's my proposal, to do this expeditiously. And we want, as indicated in my letter memorandum, we want the relief of having the discovery that we're entitled to by tomorrow, or certainly by Thursday, I should say, an opportunity, an expert to look at the shirt, the pants, et cetera, and what Mr. Diedrich's done, and then an opportunity to have our experts look at it before they do anything else to this evidence, so we could proceed in an expeditious manner. People?
This is remarkable, Your Honor. I don't know whether the court's had an opportunity to read our motion yet for discovery sanctions relating to Dr. Lee. I hope the court perhaps will take a look at that before dealing with this issue if Your Honor feels you have to take this under submission, if you feel that you cannot summarily dispose of it right now. I learned for the first time on or about August the 21st, when I spoke to Dr. Lee, that somehow he had excluded the genes as having made the impressions in this case. I did not learn that as a result of defense discovery. It was not documented in any report. I learned it as a result of my conversations with Dr. Lee. He was cooperative with me. I learned for the very first time on this witness stand that he also excluded the shirt. That was not documented. That was not in any defense discovery. And now they are claiming that somehow we have violated our discovery obligations and our legal obligations because upon learning of these violations and of this evidence, we expeditiously went about being able to confront it and present a rebuttal case as quickly as we can. I do find that to be remarkable. Now, Your Honor, just so the record is clear on some of these factual points, on August the 21st, or on or about August the 21st, this was around the time that I learned from Dr. Lee, I believe, his statement about the genes. I caused an impression to be made pursuant to the instructions of Mr. Bodziak, who I also consulted, in order to be able to cross-examine Mr. Lee on this point. I was working very rapidly. I didn't have any real notice on this issue by the defense. I wanted to know in my own mind before cross-examining Dr. Lee whether or not the genes could have been involved and possibly had that impression to be used as an exhibit for cross-examination. I had tentatively planned on using it, but elected not to during cross-examination. I felt that it was tactically not necessary. On the 31st, after learning that Dr. Lee had also excluded the shirt, I wanted impressions to be made of an examination quality of both items immediately, so that that material could immediately be sent to the FBI, so that we could rapidly perform tests, so that we'd be able to present evidence in our rebuttal case. And as it is, we're probably just going to get this in under the wire. I mean, we've really been pushing things as a result of not having had discovery and notice of this. When counsel says that we took 5 or 6 impressions, just so the record is clear, and I don't necessarily think this misstatement is material on his part, there were only those 2 dates in which impressions were taken, and only one set of impressions was taken from the shirt. When impressions were taken from the jeans, when he says 6 impressions, what he means to say, as I explained to him, is that the genes were impressed on a single piece of paper more than once. To quote Mr. Paradas, we went bing, 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 bing 6 times. But it was not 6 different occasions that these impressions were taken. But there are a total of more than one impression on a single sheet of paper that's approximately 10.5 inches by 9 inches, something in that order. Now, to respond to the so-called relief that counsel is requesting, first of all, in his letter brief, counsel says that I informed him that Mr. Diedrich was going to perform experiments involving the use of Mr. Goldman's genes, and he characterizes what happened to the genes as being an experiment and suggests that that's the way I characterized it. I specifically said to him the same thing that I'm going to say to the court right now, and that's that taking a test impression or an exemplar is not an experiment. Whenever we conduct comparative analysis or impression or present evidence regarding impressions, regardless of what class of evidence we're talking about, we always have to have an exemplar. If it's handwriting, we get an example of the person's handwriting. If it's a footprint, we make an impression of the shoe on a piece of paper. If it's a tool mark, we make an impression of that. If it's a rubber stamp, we make impressions of that, and so on and so forth. We do that with all impression evidence. And in the case of clothing, we have to do the same thing. That's common sense, and that's also what experts will tell you. So we wanted to have these impressions, these exemplars, for the purposes of them being able to perform a comparison. That is not an experiment. It is not a test of any kind. It is not a test if I took the court's finger and made an impression for the purposes of being able to compare it to some other fingerprint. That's what we do with all comparison evidence. We take impressions, and that's what we did here. That's all we did here. And to characterize it as a test or an experiment is simply a complete mischaracterization of what I said to Mr. Scheck, a complete mischaracterization of what common sense and scientific experience would tell us. Now, for the requested relief of precluding us from taking these impressions or suggesting that we're somehow legally not entitled to take these impressions, we have a tremendous amount of experience in our legal system with the obligations of defense attorneys and prosecutors. Our legal system is very old. We have been conducting court trials and jury trials for about 750 years. Our common law is extremely old. And I would ask counsel to point to the court any statute from any jurisdiction, any case law from any jurisdiction in those 750 years that suggests or implies that the prosecution has any obligation whatsoever to refrain from investigating a case, from doing the tests that we require, experiments that we require. We don't. There is no such authority. And I think the court's orders recognize that, because when Your Honor made your ruling on August 26, 1994, in discussing People versus Griffin, you said that the prosecution must be allowed to investigate and prosecute crime, and due process does not require that it forego investigation in order to avoid destroying potentially exculpatory evidence, citing the Griffin case. And you also said that for the proposition that the prosecution is to be prevented from performing scientific tests that destroy evidence, that there was no authority to support that proposition, and that although it could not be condoned, that Your Honor was not going to decide prospectively what tests we could do and could not do. Under the authority that counsel cites and that Your Honor reviewed in your order, if the prosecution were to destroy exculpatory evidence in bad faith, then the court could apply a sanction retrospectively. But as the court recognized in its previous rulings on this issue in a different context.
Well, let's examine the specifics here rather than the general legal principles. What we have was testimony regarding impressions made by either the jean material or the shirt material, correct? That was from Dr. Lee.
Dr. Lee said that the jeans could not have made the impressions on the piece of paper in the envelope, and also said that the shirt could not have made the impressions.
All right, so in response to that testimony, you've asked your people to test the shirt and the Levi's or Levi type material to see if that is in fact true, correct?
Well, I wouldn't call it a test. I'd call it, they made an exemplar of that, which will then be compared to the impressions on the envelope and the piece of paper. In fact, that comparison was done.
All right, now, my concern, what was raised, is that one of the issues that was raised that causes me some interest and concern is whether or not the manner in which the impressions were taken from the Levi's and from the shirt in any way obscure or destroy any of the evidence that was on there.
Well, those impressions were some of the impressions were taken in my presence on August 31st. And those impressions that were taken from portions of the garments that did not have any observable blood or impression evidence on them. And although I believe it is possible to see a very slight yellow staining on the areas where the impressions were taken, it does not obscure or obliterate. Even if it had been done on areas of the jeans that contain some blood pattern, it would not obscure or obliterate that, but it was not, Your Honor. It was done from portions of the garments which are not at issue in this case, which have not been testified to, which did not contain any observable evidence in this case.
All right, the other issue I'm concerned about is whether or not you've turned over all the notes that you have in your possession concerning this exemplar taking or comparison, whatever it is you have, and the photographs.
Yes.
When was that accomplished?
It's been done in stages, Your Honor. And I don't know if I'm prepared to cite all of the dates now, but it was completed by yesterday. There were notes of Ron Raquel as to his taking of the test impressions that were turned over yesterday, but I actually turned over photographs of Mr. Raquel taking the impressions, and I turned over a statement from our investigator who witnessed taking the impressions significantly before then.
So since you intend on offering this testimony, what is it likely to show? What's your expectation of what Mr. Diedrich's testimony is going to be?
Your Honor, also yesterday afternoon, Mr. Diedrich faxed me the report, which I also sent to counsel as soon as I got it. And incidentally, I've been giving all of this information to the defense as quickly as I've received it, with the exception, as Mr. Scheck indicated, of the exemplars, which I immediately sent to the FBI. And those are on their way back to Los Angeles. To answer the court's question, what Mr. Diedrich is going to testify to is that he has done a comparison between the eyeglass envelope and the paper and the test impressions, and that the jeans can be included as having made the impressions on those items, that the shirt can be included as having made the impressions on Ronald Goldman's jeans. Your Honor, just to address the last issue of the question of, I don't know whether the court wants me to say anything further about the prosecution's right to conduct tests, even destructive tests, because I don't think it's really all that pertinent. This is not a destructive test, and even if it were, we could still conduct it. And even if we destroyed exculpatory evidence, the only remedy would be for the court to look at that retrospectively. In other words, after it had been done, and then impose a sanction. But I think the court recognizes, or at least did recognize, that prospectively, the judicial branch does not get involved in deciding what tests and what experiments the prosecution can conduct. But I don't know whether the court needs to, or wants to hear anything further on that issue.
Oh, I just wanted to know what it was we had here and where you're going with it.
Okay. As to notice, Your Honor, I said to Mr. Scheck, first of all, when I spoke to him, if you guys want to see the jeans, you're welcome to them. We'll arrange that. We'll be accommodating to you as we have in the past. You want to take your own impressions? Have at it. Have fun. Take impressions if you want to take impressions, and that is our position now. As for the issue of notice... I think
that includes the shirt as well.
Yes, the shirt. Your Honor, as to the issue of notice, what I said to Mr. Scheck on that score is that Mr. Diedrich is going to come into Los Angeles. I believe he is going to be arriving here tomorrow in the late afternoon or early evening, so he may not have time to go to the Los Angeles Police Department. But as Ms. Clark has indicated, it is our intention to put this evidence on very rapidly. And we are trying to get everything done rapidly, and we are trying to turn over discovery very rapidly so that we may do this. And we could have done this a lot faster if we had had the discovery, which we don't have.
Have you received the exemplars back from the FBI yet?
No.
Do you have any of them left? You indicated there were 6 impressions from the Levi's.
But they're all on a single piece of paper, and that was sent to the FBI. And similarly, there's a single piece of paper containing the impressions from the shirt, which was also sent to the FBI. Your Honor, on the question of notice, I said to counsel we would give notice, but I did not want to. I did not want to hold anything up because I want Mr. Diedrich to take these impressions as quickly as possible from the genes so that he can testify. For some reason, my suspicion is that counsel wants to make what I would think to be an entirely inappropriate and frivolous argument that the manner in which the impressions themselves were taken is a substantive issue as to the admissibility of those impressions. I think it's frivolous because we take impressions all the time of all kinds of things. We have to do that whenever we're talking about a comparative type of analysis or impression evidence. But if they wanted to make an issue of that, I would like Mr. Diedrich to have taken the impressions himself so that he can answer all questions and be cross-examined and examined as to how they were taken. Actually, I don't think that legally that is necessary. But if that is the direction which counsel is prepared to go, and I suspect it is, as frivolous as it may be, we want to be in a position to meet it, and we can meet it best by having Mr. Diedrich take the impressions himself. And also it cuts down on the number of witnesses, it saves time, it cuts down on the amount of direct and cross-examination.
Well, Mr. Diedrich comes into town tomorrow, which is the 13th, late in the day, is not available to examine the items until early on the 14th. Then he probably won't be available to testify till late on the 14th, correct?
Ms. Clark tells me that he may be coming in earlier, in which case, if he comes in at any time prior to 5 o'clock, it is our intention to have him go to the Los Angeles Police Department, if necessary, directly from the airport, in order to be able to accomplish this. So that is the people's position. In terms of the defense saying that they need more time to deal with this, well, you know, this is a very tiny part of Dr. Lee's testimony, really. When he testified that he excluded these items of having made the impressions, it only took about a minute for him to say that. I did not cross-examine him at all on that for tactical reasons. And we are putting this evidence on to rebut a minute of testimony that we could have been in a better position to confront had counsel given us notice. They knew they were going to put this on. So I just do not see any basis whatsoever for them asking more time to confront testimony that the people did not have an adequate opportunity to be able to fully prepare for, and where we have been doing everything that we possibly can to be able to confront this testimony or to respond to this testimony as expeditiously as possible.
All right. Any brief response, Mr. Shaw?
Your Honor, just so the court completely understands the facts, is that, as Mr. Goldberg is now conceding, we do not have these imprints from the pants and the shirt. I should note that from the discovery pages labeled DA 5365 and 5366, on 5365 they say that with respect to the jeans, that one sample was taken from the right knee area of the jeans, the other impression was taken from the left lower rear area of the jeans. He made the impressions by taking the yellow pad and applying it to the jeans, etc. So on the August 21st, they indicate 2 impressions from the jeans, and then the report says they took 5 samples, impressions from Goldman's jeans on August 31st. So I count 7 from their reports. That's where I come up with it. They gave us 1 unusable picture that you see. Now, what we need to do, as I indicated, is to evaluate what they're proposing to put on, is take a look at the actual sheets of test impressions and compare that to the envelope, et cetera, and the jeans and the impressions from the shirt to the jeans, so our experts can have an opportunity to look at that. In terms of the timing of this, I think what I proposed is reasonable, because we're going to have to get copies of what they don't have here to give us, and send that out. Now, it's going to be adding even more time, and it's totally unnecessary to have Mr. Diedrich make another test impression just for the purposes of him testifying alone. They concede the single purpose of it. And then we would have to take that test impression and send that out to our experts and have them look at it, and it would only prolong the process, not shorten it, in terms of getting an adequate opportunity to evaluate what he's saying. So we don't have adequate discovery to deal with this. I would point out, incidentally, that Dr. Lee turned over all experiments and raw data that were a predicate before his testimony. I don't want to get into that issue. Mr. Blazer briefed it. We've dealt with it. That's not the point. I'm glad that I don't understand. He calls it experiments. He doesn't like the term experiments. He doesn't like the word test. He only likes the word test impression. Call it test impression. The photograph that the court has from A21 shows that it alters the genes. Now, I want to see the genes myself. We want our experts to look at the genes. We want to determine for ourselves whether or not that altered the areas that Dr. Lee testified about. As for this absolutely extraordinary argument that this court has no power to prospectively restrict the unreasonable alteration of exculpatory evidence, and that you're powerless to restrict them from doing that, even though you've already issued an order saying they have to come before you and give you 48 hours notice. I mean, this is remarkable that they can actually take the position, and it's the position they've been taking all along, that we have a right to discourage.
Do you have anything new?
I don't need to tell you.
All right.
But I would ask the court to permit us to proceed in the fashion that I've outlined. I think that what that will do is give us an opportunity to present the issues to the court for a ruling on the substantial similarity of these experiments. Mr. Goldberg, even though he's talking about what we do, my information is that nobody's ever heard of what Mr. Diedrich is doing before, and I'd be real curious to see if he's ever done imprints made in blood with two different fabrics on these receiving surfaces in the fashion that he's done in this case. I suspect he's never done this before.
All right, but we're talking about a pattern impression here of a fabric. So this is not exactly rocket science.
Ooh. We're talking about imprints in blood, fabric on fabric, jeans onto shirt, and then jeans onto envelopes. We've just got to see what he's done, but it's imprints in blood.
Mm-hmm. Thank you, counsel.
Your Honor, just
All right.
quickly, I just let the court know Mr. Diedrich will be in tomorrow. He should be arriving in this court building by about 11:30. And what we can do is.
Will he have with him the impressions?
He will.
All right.
I'd also propose this, that they have Mr. Diedrich do the impressions, meet in court, and then they can have their expert here to examine everything Mr. Diedrich has done, question him about it, and then everybody can be ready to proceed on Thursday.
All right, thank you.
Your Honor, Mr. Morton, I called him and asked when he would be available. He's got a court appearance. He won't be available till Thursday. He's canceling another court appearance so he could get here Thursday. And they told me he'd be here tomorrow afternoon. And we object. We want a ruling that he not be allowed to make any other impressions until we see all these objects and have an opportunity to brief the Griffin question. And from the
Well, the Griffin question's already been raised, counsel.
No. I mean, we want to look. As I'm indicating, I don't know what the genes look like. I can't adequately present this to them.
All right, thank you, counsel. All right, the prosecution is ordered to make available for inspection by the defense and their experts, if such be available, the test impressions currently in the possession of Mr. Diedrich. That's to be accomplished no later than, assuming airplane connections, no later than noon tomorrow. The issue of fabric impressions was raised by the defense. The court notes that both sides have had access to both the jeans and the shirt. Either side had the opportunity any time that they have wanted since June of 1994 to take any impressions in whatever manner they want. The defense had prior opportunity to look at these items. It's apparent from Dr. Lee's testimony that he did, in fact, examine carefully the fabric patterns of both these items. Defense experts have had access to it. I find no discovery violation. The objections are overruled.
We need time to, if they're going to deliver these test impressions to us tomorrow, I have no expert to look at them. I have to make copies of them in a way that is usable for the experts. I have to send them out, and I don't believe I'll be able to cross-examine this witness until Monday.
Well,
or
counsel,
present
the issue
arguments.
was raised by your witness. So your witness has already seen impressions, knows about these imprints.
No. Never saw an impression.
Yes.
He never saw the test. I want an opportunity to look at their test impressions and their results.
You can have the opportunity to look at it, counsel. I've directed that. All right, that's the end of that issue.
To a sitting juror. And the motion that I bring before Your Honor is to have that juror excused because of the conversations that took place on the record in this case with that juror. And although we have great empathy with the court as trying to do everything humanly possible to make the conditions for this jury tolerable, livable, and in a way that this jury can eventually hear all the evidence and reach a verdict. We are compelled under the law to bring to the court's attention what we believe was a violation clearly of the constitutional rights to an independent and fair jury of our client, Mr. Simpson. And we believe that the court, although noble in its desire and purpose to try to alleviate any potential financial hardship that this particular juror has suffered, has in fact created a legal condition that now has put this juror in a special place. And what I am...
What action has the court taken that puts this juror in a special place at this point?
Well, the court's indicated action. The court has taken no action whatsoever. But
the court said to the juror, give me a couple of days to look into this.
That's right. But the court also indicated, I believe, that there would be some effort made on the part of the court that would, in fact, result in a financial hardship of this juror being relieved. And since that financial hardship has been discussed amongst other members of the jury by this juror, we feel now that that juror, just from the conversations with Your Honor and from Your Honor's indication that the court would be willing to look into financial aid as well as other support from the court regarding a rental income property, that has now affected this juror in a way that it might cause other jurors to feel that they are entitled to similar types of consideration, to similar types of compensation. The court has not made any ruling whatsoever, nor has the court done anything yet. However, I think it was clear to that juror who was very comfortable at the end of the conversation that this court, as it always has towards jurors, was going to do everything possible to try to alleviate that hardship. And we believe just in doing that, this juror now may feel a special kinship to Your Honor.
Well, I've done this for a number of jurors. I have gone out of my way to make sure jurors have been transported out of state to attend families' funerals and gone out of the way and spent county funds to do that. Juror 247 the other day had a problem that we had to deal with, that the court made special efforts to do that. Are you suggesting that every juror for whom this court has made efforts, special efforts, unique to that juror, that those jurors should be excused? If you're making that motion,
No, I am not.
because your position is inconsistent with the court's treatment of all the other jurors.
No, and we commend the court, and in many instances joined with the court and acknowledged that those things were justified. What this case and this issue, we believe, is different because this involves substantial proposed financial compensation retroactive for several months, not something protracted, something that may come up in the future, something of an emergency, or something that would come up just once. This is something that involves a financial issue, which we believe is separate and distinct from the other very personal issues that the court has shown great empathy for, and properly so, to the jury. And we have always concurred with that.
I seem to recollect, Mr. Shapiro, that when one of the jurors was excused and you chose to take a writ to the Court of Appeal, that you urged that this court should go to a higher level of vigilance in keeping each and every member of this jury intact and on this jury. And you took the position that it's not just reasonable cause regarding excusing jurors, that I should take a heightened level of scrutiny to each one of these decisions. So I think this is an inconsistent position with your prior position.
That is absolutely correct, but we believe in this case that by separating one juror based on financial considerations, that it violates the basic tenets of the United States Constitution and the Constitution of this great state, and gives unequal compensation financially in a significant way to one juror as opposed to 12 others and 2 alternates. And I am sure that all of these jurors have tremendous hardships that would greatly be alleviated with the largesse of this court and by any type of compensation. But we believe constitutionally that that violates Mr. Simpson's rights to have a fair and impartial jury where each juror is treated as one and the same. And this gives the impression, whether it is right or wrong, but it gives the appearance that special treatment is being given to a juror. And we are not saying that Your Honor has singled out this juror for special treatment. This juror came to Your Honor. This juror demonstrated financial hardship, and this juror was apparently in a condition where this juror could no longer continue on this jury because of the great financial hardship this juror was suffering based on some rental income property. And the court sought to alleviate that problem. It is our position, however, that such relief, however wonderful and compassionate, noble, however noble, that's right, that's a better word, however noble the court's desire was, it is not a constitutional right that this court enjoys.
All right, I take it you'll file your motion.
Yes, Your Honor, we have also, just for the record, we have filed the motion. And the other thing that it does, Your Honor, is it puts a juror in a position where the juror now might feel that if this continues and if the court is going to compensate a juror for lack of income in a rental property, that this juror may have an added interest in prolonging any type of...
Ms. Clark, that's not necessary.
Ms. Clark apparently has a funny bone that has been touched. That this juror might have a financial incentive for wanting to prolong any type of deliberations. Now, we don't believe realistically that any juror wants to do anything other than end this and end this quickly. But we pointed that out in a footnote, and I think it's important to add.
All right. Thank you, counsel.
Your Honor, and we'd like to get an answer as soon as possible so that we can take a writ on this matter. We feel it's that important a constitutional issue.
Well, we may have somebody come forth from the public and volunteer to leave this problem outside of the court. Who knows? It may go away.
Thank you very much, Your Honor, for your
You're
consideration.
welcome, Mr. Shapiro.
Appreciate it.
As always.
Thank you.
All right.
Probably the last issue for today, Your Honor, may deal with the scope of rebuttal regarding certain lay witnesses and where we're going in this case.
We did have the June 17th issue still open.
Yes, we'll perhaps we can take it up tomorrow. But what I'm concerned about, Your Honor, is Ms. Clark indicated today that the people might rest on Thursday. If that be the case, we'd like to know which other witnesses they have pared down. You had directed Messrs. Douglas and I think Fairlow, instead of Mr. Darden, to get together. They have taken Steve Jensen, Stuart Roper, and Leonid Rubin off of their list. But we still have a list that would be roughly 56 people, less the few who've been called. We need to know who they're going to call in order to get down to this, to finish this case by Thursday. We'd be entitled to those list of names. We'd like to have those now. There may be another issue regarding the 617 events and an issue regarding Dr. Dutton. I guess that'll be coming up next week. So I'd like to have that at this point because if they pared other people down, if they're not calling other people, we need to know now so we can be ready to get this case over with. We want to resume our case. We have witnesses who are out of state, and one in particular we're going to be asking the court probably either tomorrow afternoon or Thursday morning to help us bring back, and a new witness to bring out here. So we want to do that as soon as possible, so there's no delay for next week. So may we have that, Your Honor, some indication of what are the witnesses they paired off, who's coming up next, who will be their witnesses to finish the case? If by Thursday, that's within 3 days, and we're entitled to it.
Mm-hmm. All right, I assume that they are going to offer at this point, a modified Herodotus video, that they're going to offer Mr. Diedrich as to fabric impression. Is that correct, Ms. Clark? All right.
Wouldn't it be easy to hear from them, Your Honor?
No, those are the issues we just finished discussing, so those are pretty obvious, wouldn't you say?
Yes, they are. And I'm trying to get, okay, yes, we knew about those yet.
Okay.
Trying to find who else they have.
And we are concluded with the glove people. So what does that leave us, Ms. Clark?
So, leaves us with Will Wozniak. We have to litigate the Bronco fiber issue.
Uh-huh.
That's, I would indicate to the court that would be, it's very brief. That's admitted. The Bronco fiber witnesses are 3 in number, 15 minutes each. We ask the court, also the Ackards, Lawrence and Nancy Ackard, Christian Anders, George Field, Don Thompson, the Dr. Dutton, at Rachel Scott, and that is really how I have to say that.
Is that all?
That's about 3 days worth.
But obviously, then it's clear they're not going to finish on Thursday. That's a pipe dream. How can we finish on Thursday with this number of witnesses? Wozniak, that's preposterous. And I haven't heard Popovich or anything.
No, it's not preposterous, it's optimistic.
Well, it's more than optimistic. I'm optimistic, Your Honor. That's preposterous. Your Honor, the issue is, I think we should be realistic because that brings me to the last motion I'd like to at least have the court think about. I told you earlier this morning that I think on behalf of the defense, on behalf of Mr. Simpson, we herewith ask this court to modify the sequestration of this jury. The court will recall that approximately, I guess now, 10 days ago, we met in chambers regarding a jury who shall remain nameless, and the court made a representation based upon what we told Your Honor, that you expected this case to be to the jury by the middle of September on or about September 15th. We're not going to make September 15th, clearly. We'll be lucky to finish this case next week, unless there's some paring down. And so I think that it's unfair. I think that from a standpoint of all of our credibilities, during voir dire, we told this jury they'd get the case in April, as I recall. And so it seems to me that we've reached a point where this jury should no longer be made to suffer. Our client has had to suffer, and we hope to alleviate this situation very soon. But these jurors have been brought in from the outside, and it seems to me the court should seek to modify the sequestration. And this court is very, very innovative when it wants to be, and it seems to me this would be an appropriate time to set up some kind of procedure where these jurors can go home at night and meet someplace in the morning. It's unfair to keep them here, it seems to me, past what we've told this one man. We're going to lose some jurors, as you're aware. And the people at first, we thought they might have understood this. But then when we see this list, and they say, well, this is just 3 days, they still don't understand it. We're going to be well into next week, and the problem is going to be as we've indicated. And so I make this motion most seriously. You can still have the ramifications of sequestration, and you'll recall that before, during picking this jury, you told these jurors not to watch television, not to do certain things, and by and large, they comply with your orders. These people have been here like almost 9 months, and I think they would do that. I think they would welcome it. It would take a lot of pressure off them. We can finish this case. We still should finish it as soon as possible, but it'd be a lot fairer for these people if the court would consider doing that. And we've thought about this. All of the defense agrees this would be an appropriate thing for us to do. Otherwise, we do not, on the defense, want a mistrial, and we're going to move in that direction. If we don't, the court has to spend every few moments apologizing. And I don't think you'd like to do that. You made a nice joke yesterday. Nobody laughed. You look vaguely familiar. I didn't see, no, think back, nobody laughed. There may have been a couple of polite snickers, but nobody laughed. And I'm just saying, Your Honor.
I got 3 smiles from the regulars.
Well, that's a smile, Your Honor. Well, that's a far cry from the laughter that you used to get. You would admit that also. So I'm just saying, Your Honor, it seems to be it's time to do something about it. We've thought about it, and we'd ask Your Honor to consider doing that. We would also like, if this is 3 days witnesses, that means it's going to be Wednesday, Thursday, Friday. Then we need to know the other witnesses. Also, with regard to these witnesses, we need offers of proof with regard to who these witnesses are, what they're going to be testifying about. And Don Thompson's already testified, for instance. He's the officer who handcuffed Mr. Simpson within 30 seconds of his arrival back on his property. He's already been called. So we need to know who they are and what they're going to be saying as soon as possible to keep from delaying further, Your Honor.
All right, why don't you have Mr. Douglas consult with Mr. Darden, get the offers of proof as to the names that Ms. Clark has just given to us, rather than take up the court's time at this point. Are you sure that those 2 gentlemen can work it out between themselves as to who's who?
Because there are some people who there are no reports at all on, Your Honor. All right. Thank you, Your Honor.
People that I just mentioned, they have full reports. Is the court inclined to entertain the sequestration motion, Your Honor?
I've just entertained it. I've just heard it. Do you have...
I'll be brief. I think this takes the cake for the most transparent motion ever made by the defense. Now that they have everything about Furman has been unleashed, everything that could possibly be said and done about this man has been all over the community, all over Los Angeles. There are posters, there are flyers, there are articles in the papers every day, news, television programs about this all the time. I wonder why the defense wants the jurors to be unsequestered. Gee, I wonder if I can figure this one out. I think anybody can figure this one out. This is, of course, the worst time for the jurors to be.
Would say this is a real no-brainer.
I wasn't even attempting to say that, but I know it's obvious to Your Honor. It's obvious to all of us what they're trying to do here, and it's absolutely improper. I don't even think we need to address it any further because it's so obviously improper. I will tell you one thing. We will rest by Friday unless the defense motions prevent it, because we have voluntarily pared back our list, having seen the fatigue of the jurors and their desire to go home, which we fully understand. Believe me, fully. So we will rest by Friday, Your Honor. It's up to the defense to finally rest and stop playing games, filing spurious motions, asking for more time on matters that they've been fully prepped on for months. Let's just get this thing done. We'll call Gary Sims. His testimony will take 10 minutes. I can give you an offer right now. Gary Sims' testimony, if it takes more than half an hour, we'll all be surprised.
No, we're talking, no, I'm not interested in that. Just the continued full sequestration of the jury as opposed to the modified sequestration suggested by Mr. Cochran and the plan originally contemplated by the court.
The answer is not to unsequester a jury that will be released into a community that is rife with inadmissible matter and very inflammatory matter. That's exactly why they want them released. The answer is to shut this case down. The answer is to end this trial. That's what we need to do. We need to stop with the endless motions and the endless arguments and the endless, requests for time that, for lack of discovery, now they have it. They've got it all.
They have everything, with the impressions that the defense complains of will be made available to them, although presumably they should already know this stuff. Their witness testified to it. No surprises are going to be had here. Now, with respect to our timing, I've indicated to the court that unless we get stopped up by a lot of defense motions, we will be done by Friday. And then the defense has to be made to rest at some point. They too have to end their case. And whatever witness they have coming, obviously a witness coming this late in the game, we're going to have to scrutinize for relevance and admissibility. That shouldn't take very long. If it's admissible, fine. If it's not, fine. And part of the admissibility issue with a witness newly discovered may well be that witness may engender a mini trial. We have to litigate that. That won't take that long. So if everything goes according to the way it should, and everybody just puts on their witnesses and stops talking, we will finish this case, both defense and the prosecution, by Tuesday of next week.
All right, thank you.
I must say, I know the hour started. Thank you. I'm not going to be personal at all. This is just to deal with this motion. We're serious about this motion. I'm mindful of the fact that when we were picking this jury, when the prosecution, the city attorney, and the police released that 911 tape and caused these problems, didn't cause a problem for these jurors. So now we're not worried about what happens in this community. What we're worried about is getting this case over with to the jury. We agree on that aspect. But counsel says, on the one hand, we got to stop all these motions. And she says, this mystery witness, whom they know about already, because Ms. Clark turned to Ms. Lewis yesterday, said he must be talking about blank, blank. Peter Neufeld saw her. They know. They've known all along. And in addition,
We're arguing sequestration at this point.
Mr. Neufeld saw her do that yesterday. And
Counsel, let's not get into this.
all right. Well, at any rate, the point is they know who this witness is. They should have told us about it earlier at any rate. And so then they argue on one hand, we're going to have all these admissibility hearings, as they did with every one of our witnesses. Keep in mind, Judge, they took what, 6-7 months? We took like 8 weeks? I mean, you can't even compare that. So we're very serious about this and would ask you not to give it. I don't think it's a no-brainer. I think when you see the fatigue on those people's faces, not paying much attention, staring off into space, coupled with the problem that lady has, coupled with the problem the juror had this morning, we're at a real crisis point, it seems to me. And so I throw this out for Your Honor's wisdom and thinking. I don't think it's a no-brainer. When you spent this much time and this much effort. And if you think, and I'd be real pleased if we could finish this case, their part, by Friday. If they do that, we'll finish our part as soon thereafter as possible. But I think that it is not a no-brainer. That's the point I wanted to make.
All right, thank you, counsel.
Not seeing from Dr. Popovich and Mr. DeForest.
I didn't hear their names, counsel.
All right, the other thing I have one thing that'll help you.
What's that?
I have the page references through the Xiphon program for Dr. Gertis's testimony with
have them
respect to
already.
303. You have them?
I have them.
Okay. Finally, could I request of the court, I will not have an expert, if they're going to deliver these things at 12:30 tomorrow with Mr. Diedrich, I won't have an expert here, and I won't have an opportunity to send them
Counsel,
anywhere.
we litigated this issue.
No, I
already.
understand. But what is the ruling? The ruling is they're going to be allowed to put them on in the afternoon after I alone are looking at these test impressions that
You've
I've never
heard the
seen
ruling,
before?
counsel. You've heard the ruling. All right, 8:30 tomorrow morning, we'll take up scope on the 617 incidents.
Your Honor, until Thursday morning for Mr. Diedrich.
Well, you haven't heard Mr. Diedrich yet. All right, one recess.